Madam, good morning. మేడం 11కి వస్తారు.
only matters which are urgent and has to be taken up at 2:30, and I will not hear any other matter.
Your lordship still.
Thereafter, they have come before this honorable court, obtained the stay order. I filed a petition.
That is for the court officer to be given. Memo to be given to the court officer.
Your
I'll
lord-
consider and give the dates.
Your lordships, on 22/7 deliverable warrants have been issued, your lordships. I have filed with a fresh filing, your lordships.
When was the delivery warrant?
22/7, your lordships.
Hmm.
I would like to let the matter be heard today at 2:30, your lordships.
Why?
Your lordships, they will execute the orders, your lordships. They'll take the possession of the property, your lordships.
Yes.
My lord, in my case, the landowner is trying to alienate the property and create the encumbrance, my lord. I'm a registered sale agreement holder, personally, my lord.
What is the
Personally.
IA?
So I filed and the matter maybe they got compromised among themselves.
When was the petition filed?
My lord, yesterday, my lord.
It will come, no urgency for that. Injunction is not an urgent.
CRP 350 of 15, your lordship.
Huh?
CRP 350 of 15, oldest matter. Trial court record is by this honorable court. But matter was fixed on 9/9. Matter is urgency.
When I gave a date, I gave a date. And please don't ask
No,
for.
no,
another-
I am not asking any relief. Send back the trial court record, that's all. If the trial court record is before this court, since from 2 years it is not conducting the trial before the trial court. And simply we as a CRP is not posting before this court.
I will see. Yes. When
Please
it
tell
comes on 9/9, no,
Withdraw,
not
my
now.
lords. Serial number 68, the petitioner has become infructuous. So we are withdrawing the
Yes.
petition.
Tomorrow.
In trial court deposit.
If any mention without urgency, if it is made, I will take the memo particularly and post it in the month of January. Because I'm really fed up with every day telling the advocates the same thing. Yes. Is it 2:30? Then only make a mention.
Yes, my lord.
Yes, what is urgency?
This to serial number 9, my lord. The executing court has issued warrant and list of mobiles in 2025, my lord. And the amount due is 2 crores 25 lakhs. And the matter may not reach, my lord. We've been trying for almost 6 months.
That is the problem with everyone. So what is so special about this case?
Is running a company.
Everybody has the same problem.
My lord, can we
Then
have another-
the numbers will vary. No, I will not take up. That's not the reason for urgency.
My
Yes.
lord, serial number 11, list number 2, with the direction from the appeals court to dispose the matter, my lord. 6 months.
Suppose
is
a matter in how many days? What is the time
6
frame?
months is the time duration.
When was the order passed?
It was passed in the month of June, my lord.
Where are we now?
July, but
6 months' time is still
no,
left, we
no,
can see.
elapsed in this week, my lord. Matter may be taken up.
He said June.
It's in July month, but
Oh, no. When did the Supreme Court pass the order?
June 24th, my lord. Sorry, January 24th,
January?
24th.
24.
I mean,
We will see. It's there in the list, we'll see.
Date is in matter, my lord. Matter has to be listed today. If your honor may remember, this is with regard to the 12 flats that were attached. The payments
And for the
from
rest one.
5 flats were released, my lord.
And for the respondent, my lord, the payment, Monday is the registration, will have, Thursday, my lord, will make the entire payment. Because I shared the details of the bank statement, everything to my learned friend yesterday, sanction letter. Have it on Thursday, we'll pay the 10 crores.
But let me hear what
Yes,
she
ma'am.
wants to say.
With regard to the 5 apartments, my lord, 1701, 1801, the 5 flats were released, my lord. However, it had to be listed today. The matter is not put up, my lord.
No, what is the reason why it should be listed today?
The payments had to be released by the petitioner, my lord. Today was the date on which the petitioner.
It is not done.
It is Monday, when Monday or Tuesday is the registration, when I've shared the details, have it on Thursday.
As per the order, what is to be
My
done?
lord, what has happened is there's a correction.
Take this matter tomorrow.
Yes.
Tomorrow, definitely.
In trial court, the order has been, the deposit order has been to the favor of the respondent, and the petitioner has filed a petition and they have took a stay, my lord. And tomorrow is the date, my lord, trial.
What
court.
date?
In trial court, there is a matter, my lord.
Is it urgent?
We have, yes, ma'am.
How many,
My
how
lord.
many stays are there in this,
Yes, my lord.
in the petition?
We have filed the.
I've already
IA for
said, I will take that, I'll list it in the month of January. Take the memo.
Tomorrow, my lord.
In
Tomorrow.
spite of mentioning it, he's again, take that memo, give that to the court
We have-
officer.
We have.
I'll list this matter in the month of January. I said, what is urgency?
We have filed an IA for,
There are so many vacate petitions. There are about 8,000 matters before me. And all that can I take? I'm repeatedly, every day morning, I'm making requests to the advocates, don't mention and waste the court's time. But in spite of that, you will mention. Yes.
Today I said list number, serial number.
Huh?
List number 2.
Serial number 18, withdraw the matter.
Take that.
My lord, list number 2, 30, serial number 35. Serial number 35. My lord, I had filed an application, my lord, seeking framing of additional issues. My lord, now, my lord, I'm withdrawing that application with the liberty to file appropriate, with the liberty to
For
file.
seeking liberty, that I will not grant while mentioning. The matter has to reach.
Okay.
Yes.
21 manager for additional term infectious in terms of the settlement before trial.
Lordships, pending fresh matter, my lords, it was listed yesterday in serial number 47. Due to oversight, my lords, we could not represent the
They
matter.
can't help
My
it.
lords, It's listed tomorrow, my lords, for final arguments.
We can't help it. When you're not there, I have posted the matter.
Due to oversight.
Every
my lords,
matter I will not take up like this. Yes.
But one matter for 230 lords, though they are.
I'm telling you, without an urgency, you make a mention, I'll take the memo and post it in the month of January.
Urgency is this, my lords. Execution court has issued arrest warrant.
When?
Though, my lord, 23/7, my lord, this month.
Yes.
My lord, so though there is a direction from the Supreme Court, my lord, to vacate the property by August 31st. Still, my lord, arrest warrant has been issued, my lord, in the executive court.
What was the order of the Supreme Court?
My lords, there is a direction from the Supreme Court to vacate the property, my lords, by August 31st.
Hmm.
But still not considering that fact, my lord, the executing court.
230.
My lord, due to the status quo order in this, there is a appointment of arbitration is also stayed, and one more application in the trial court is in my favor, injunction order.
Why are you making a mention?
My lord, due to the status quo in this.
Take that memo. Take that memo and list it in the month of January. Yes, next.
Supreme Court direction matter, it has elapsed, my lord. 6 months period has been elapsed. Matter is not reaching, my lord, although it listed multiple times. 2 crore has been struck in the money recovery suit.
I'll take it up somewhere next week or thereafter.
Tomorrow maybe on the top of the list, maybe post.
Yes, call the list.
My lord, fresh matter, my lord.
Fresh matter,
Matter
memos
and-
are not required.
Arrest warrant has been issued.
When was it issued?
15/7, my lord, and arbitrator has passed the order placing the
What are you doing
petitioner.
till
as
now
part
without
of-
filing the writ petition? Whenever you file that, that's not the day it is urgent. You filed, it will come. Yes. Serial number? '68. Memo is for seeking to withdraw the petition, dismissed as withdrawn. The other one? It is submitted that the memo is filed stating that the writ petition has become infructuous. Accordingly, memo is taken out record, dismissed as withdrawn. Yes. Serial number? Where is the? Same, instructions. Yes, next.
For orders matter. Serial number 1.
Serial number one.
Rajshekar as for
Petitioner.
petitioner.
I filed my lord's memo for withdrawal. Parties are settled before the trial court.
It is, a memo is filed stating that the already suit itself was withdrawn on 21/7/2026. And the nothing will survive the consideration in this petition.
Fit.
The petitioner wants to withdraw the petition. Accordingly, memo is taken on record and dismissed as withdrawn. Yes.
Serial number 2 for preliminary hearing.
I appear for the caveator in this matter.
This matter, I am
May I-
representing the petitioner's counsel.
Just
My lord,
want
at the
to-
time when the
I just want to make one
Lord, I-
submission. The writ, before my learned friend starts.
No, let me just
the
bring to the
prayer-
notice of the court
The
that,
prayer that is sought for, there is a subsequent order thereafter.
no, my your lordship.
Prayer is sought for stay, setting aside 7/7/2026 order. Thereafter, there is a subsequent order on 22nd July.
Take that.
There is a subsequent order of 22nd July. Kindly see, my lords, my ladyship at page 1.
My lord, the 22nd July order is for extension of time to comply with the 7
Page
July
1,
order. No, no,
internal
let
page
me,
1,
let me
yes.
tell your lordship what has happened. I mean, my friend
Subsequent order.
can't be so, she's got an ex parte decree against me for 11.5 crores
There is a
and trying to
subsequent
exit.
order.
I've not even been served with the notice in the suit.
There is a subsequent order which starts at page 1 dated 22nd July, and kindly see at page 11, page 10. May I just read out para 8 of this subsequent order? So the writ itself is infructuous. Page 10, para 8. Para 7, records reveal JDR has not complied with the order dated 7/7/26 directing JDR to deposit 50% of the decreed amount in commercial OS number so and so. Reason assigned by JDR seeking time to comply. Now he's seeking more time to comply is that he's in the process of raising funds. Simultaneously, proceedings initiated by JDR under Order 9 Rule 13 of the CPC to set aside ex parte and decree passed in commercial OS are also posted for further arguments on 27/7, directing JDR to deposit amount as per the order dated 7/7/26 on or before 31/7/2026 would meet the ends of justice. So a subsequent order is now passed. This
How can it be an order? Unless and until this order,
Yes.
is, I mean, when they have question, unless and until this is decided, you can't call it a subsequent. When this goes, this will automatically will go.
No, he has in fact filed an IA to seek more time. Kindly see at page 3, which is recorded. He has sought for an IA. Kindly see at page 3 of the order.
Madam, which is this you have given me? You have given me something else.
No, see.
Page 3 is there, something else.
Which order, which copy we have given?
orders and IA. This is the one.
No, he's not put it correctly.
When was this IA filed?
Yes, now
IA under
this
151.
agitation is
Date of
wrong.
the order?
IA is also there. Copy of the IA is at page 12.
Date.
Date of the IA, my lords, in fact, after the 7/7/26 order is passed, kindly see at page 12, he files another order, IA, saying, please grant me 60 days time to comply, which is at page 12.
No, that's what I'm trying to understand.
Yes.
When this order is on 22nd July 2026.
This
And
Yes.
this writ petition is filed
10/7.
10?
10/7.
After the writ is filed, he has filed an
But
IA.
I am on.
After
your
writ
lord-
is filed, he's filed an IA seeking
No,
time.
this writ didn't get listed. What is to be done, my lord? I'm getting choked. Please listen to me for a minute, my lord. Let my friend permit me to just submit to your lordships, my lord. My lord, what has happened in this matter is
No,
that
no. Before submitting what has happened in the matter, once an order is passed, you file an IA before the court seeking extension of time.
no, that's
Having sought an extension of time, can you maintain this writ petition?
it is without prejudice.
No, that is you have accepted the order.
No, my lord, it's without prejudice to my rights to.
How can it be?
Your lordships are seized of the matter on 10th of July.
By what happened?
My lord, please look
What
at
is the order passed?
No, please look at the, my lord, please look at the order which is impugned here. Please have a look at the order that is impugned here.
No, what?
No, but 1 minute, my lord, I'll tell your lordships, just 1 minute. My lord. I will convince your lordships, I know what is passing through the mind. If you have consented to an order and acted in accordance.
Forget about consenting
No,
also.
I'm saying if
go
you have
before the
acted in
court,
pers-
you both go before the court and say, please grant me time.
Correct.
So it is not for buying time from the court that you can't come up with.
No,
such
not so, my lord.
applications.
Please see,
And
please.
court has passed an
But
order
please
on
see
that.
what has happened, my lord. Just look at the order that is impugned here. I didn't have a copy of the order impugned, therefore only on the order sheet I filed it. Now I have got the order, I'm just giving to your lordships, my lord. Please have a look at the order.
Sorry, can I have a copy?
That's the
of that?
7/7 order, madam.
No, but 7/7 order also, you have not filed the full order.
I know.
The rate. So what, if you are.
You have filed the 7/7 order, madam. Same order.
Wrong.
7/7 order is the one which you are referring to.
Yes, just look at page 13 of that order.
Yes.
IA filed by the, my lord, blindly see what he says. Have I made out a ground for stay of the execution because it's an ex parte judgment? Please look at page 10, para 4. The point that arises for consideration is whether the JDR has made out grounds to grant stay of the execution proceedings to execute the judgment and decree. My lord, he answers it in the affirmative, and in the order he says is hereby allowed under the following condition: JDR shall deposit 50% of the decretal amount on or before 10/7. He doesn't release this order of 7/7. Therefore, I filed this appeal. writ petition on 10/7, only on the basis of the order sheet, operative portion of the order. Then, my lord, the matter comes up on before the court and says, where have you not deposited on 10/7? Therefore, I make an application saying, give me 60 days time. I have filed a writ petition challenging the order. Does it mean that I have?
Did you say so? Let's see.
Please, ma'am.
Let's see from the affidavit that is filed before the court, which she has placed
That is
before
at
the
page
court.
12.
No, I had already filed.
No, you're saying that you have, because you have filed the writ
When was this
petition,
filed?
you have sought for
It was
time.
on 10th.
Let
The
us see
date of
from
filing of that IA is 10th.
No,
Also.
let him
Yes,
complete.
yes, yes,
My lord, on 10/7, my lord.
yes.
Let's see the affidavit that is filed in support of the
My lord,
IA.
7/7, the order is passed.
The IA is in the compilation I gave. Sorry.
Let him complete.
Yes.
7/7, the order is passed.
No, I just wanted to know what was the case of the petitioner and why he filed this IA seeking extension of time. What are the reasons stated?
My lord,
That we'll
punitive action
understand.
would have been taken against me, my lord. This is what exactly I'm saying, my lord. This is what the trial court did. Never heard me on merits, my lord. I am
I'll
now
hear
with
you.
my back to the wall.
No, I'll
Hear
hear
me
you
for
on
a minute,
merits.
my lord,
I
if I
am-
have made out a case.
It is like this. There are step.
Please,
About
please,
this, it's
please.
for you to convince this court on
Please,
that
please,
point.
please.
So first convince me on this issue.
From
When
the,
you have filed,
from-
when you have filed an application
My lord, from
before
the-
the court seeking extension of time, what was the affidavit that you have filed?
Was the affidavit filed without prejudice to challenge the order, is what your lordship? It doesn't appear to be so from that. But this writ
Again, let me for my benefit, please
Please,
read
please,
page
please.
30.
Your lordship sees page 14 is the application.
Yes.
And it says that JDR company, paragraph 2, not having funds to comply with the order immediately, if any amount is pulled out from operations, will collapse for no fault. JDR company has to take financial assistance from bank, etc. We approached certain banks and financial issues. They told us JDR company being limited company, due diligence happen from banks, takes 45 days time. After that, processing will take 15 days. Accompanying application is not great hardship, irreparable loss, etc. Balance of convenience. Now, this was filed and simultaneously, my lord, the order of 7/7 was
Is
challenged.
it permissible, I'm asking? Is it not, are you not playing with the process of the court?
To comply.
I mean, I can only say this much, my lord, that they should have mentioned
Yes.
that agreed.
I have filed a writ
No
peti-
dispute.
I have filed a writ petition.
No, either you
The
have
matter,
filed,
agenda
either I have
matter.
filed or I propose to file without agreed,
Yes.
my lord. But just please go beyond that and see my case, my lord. That's all I'm asking. If your lordship is going to throw.
Conduct of the party is also very important.
Agreed.
Nobody can
No.
be permitted to take the process
Def-
for a right.
No, definitely, my lord. Conduct is extremely important. But I am only requesting your lordships that nobody has heard me on merits, my lord. Give me an opportunity. Let me tell your lordships what has happened, my lord. I am an e-commerce platform. They, my lord, supply goods to me. On e-commerce platform, my lord, I give it to different vendors. The agreement between us is that the goods that are supplied to me, I don't need to pay for the goods. When it is ultimately sold by those vendors, 3 or 4 or how many of them are, Lord, those, my lord, on platforms, after deducting my commission, my lord, I remit the money to them. Now, if any of the goods, my lord, are not sold, I return back the goods and get a credit note for it. This is how this arrangement has been going on from 2017. In 2020, my lord, they file an NCLT application saying that the amount that is due from me is 11 crores, the same amount that they are claiming here. The NCLT, my lord, I file objections before the NCLT. The matter is heard, my lord, for a substantial period of time. In 2024, the NCLT dismisses the petition on the ground of threshold. Because your lordship knows there is a 1 crore threshold for Section 9 proceedings. They said, no, this dispute is less than 1 crore. Therefore, we don't exercise our jurisdiction and dismiss the petition. Thereafter, they filed this, my lord, commercial suit against me for the same amount that is claimed in NCLT. I am not saying that it can't be done. But your lordship sees what has happened. Please look at the judgment of the trial court, my lord, against which, my lord, you please look at page number 18, page number 18 of 19 of the judgment, my lord, paper book, my lord. At 20, this is interesting, my lord. The suit is filed on 29/8/25. My lord gets that, top of the page. And it is decreed within 4 months, my lord, for 11 crores against me. I am not even served summons in the matter.
Yes.
He gets a decree against me on 12/1/26.
What
And
is, with regard to your service of notice, what did the court?
service of notice, my lord. Lord, may I just pass on the order sheet of the trial court, my lord?
It's at para 3.
My lord,
service.
just have a look at the order sheet. My lord, your lordship sees there are two methods and modes of communicating the proceeding to the defendant. One is you tell the defendant, a plaintiff to serve the defendant, and your court may also has to take out notice from the court process. The court process notice is given to the defendant's hand and say, you post it. That's where the mistake has come, my lord. Please look at, my lord, please look at the second page, my lord. First page, issue suit summons to the defendant by RPAD and also through email. Plaintiff is directed to pay process fee, furnish duly stamped RPAD cover. Office is directed to issue notice, etc. Then, my lord, next on 23, on the next date, 8/10, plaintiff by so and so advocate is present or office is directed to issue summons to defendant through court, speed post and email without fail to submit report. Now, next page, my lord. So and so is present. Summons issued to the defendant through email duly served. No reply is forthcoming in respect of bouncing of email. Advocate for plaintiff submitted that in view of the due service of summons to the defendant through email, date may be fixed for appearance. However, particulars of the summons sent to the defendant through speed post is not available. Office is directed to verify and submit report on the summons issued to the defendant through court and speed post. Reissue summons to the defendant through speed post. Plaintiff is directed to pay process fee, duly stamped cover. Then please look at the next sentence, extremely important. Office is directed to hand over the summons through speed post to the advocate for plaintiff to post. Why? Why can't the office itself do it? Office is directed to hand over the summons by speed post to the advocate for plaintiff to post and submit speed post receipt. This is unheard of, my lord. That's why in 4 months' time, there is a decree against me. And for 4 years, I have fought the NCLT proceeding and succeeded there in saying that the only amount due by me is 58 lakhs. The decree is obtained on 12/1/26. Immediately execution is filed. Arrest warrant is issued. The bailiff comes to me, my lord, literally under coercion, my lord. I issue checks and say, okay, fine, I will settle it. I mean, and therefore I file an application. Well, I have two actions have been taken by me pursuant to the ex parte judgment. One is I have filed a petition under Order 9, Rule 13 for recall of the ex parte judgment against me. I have also filed an application, my lord, not to execute the decree against me pending 9 Rule 13, my lord. There is something to be gone into in this. What has happened is they are relying on an agreement of 2017. The 2017 agreement, my lord, spent itself out. There was a new agreement in 2019. In the 2019 agreement, copy of which I have produced before your lordships, there's an arbitration clause. There are many defenses I could have taken. If I have contested the NCLT proceedings for 4 years and succeeded, is there any reason in 4 months I would have allowed a decree to be passed? How does it serve my cause, my lord? Why would any defendant, my lord, take a chance after having been served summons, my lord, not to appear before a court? It seems improbable and unbelievable. The summons is given, court summons is given to the plaintiff saying, that you only post and you only give me the receipt, my lord.
Yes. May I just submit?
So
My lord-
therefore, sorry, one
No,
minute,
please
one
finish.
minute.
Yeah, please finish.
The most important thing that I am submitting is the 2019 agreement, which is the agreement that would have governed the parties, has an arbitration clause. The non-production or the information being provided in the plaint that there is such a 2019 agreement is a suppression of material fact.
No, when you contested the matter before the NCLT.
Yes.
Was it raised there?
Yes. 2019 agreement.
No. Have you taken?
Yes, all these defenses have been taken. Your lordship sees most important, and there is a certificate issued by their auditor saying that the amount that is due is 58 lakhs. Just have a look at that one page, my lord. Please look at page.
By order of the court, how much you need to pay?
58. Oh no, 11 and a half.
Crores.
11.5 crores. Just have a look at 325, 375 for a minute, my lord. 375. This is their document. 375.
There is another volume.
No, same volume, my lord. Second volume, my lord, I'm sorry. Agreement or section statement NCLT ನಲ್ಲಿ. This is the defendant's letterhead, plaintiff's letterhead, respondent, my lord. We so and so confirm that we have not availed any credit so and so. Therefore, we request you to please reissue the invoice in our name. My lord, these are the debit notes first. The amount that is due is in the middle column, my lord. Middle
Page number?
page 375. 375.
Yes.
SSIPL Lifestyle Private Limited. That is the plaintiff, my lord. In the middle, your lordship gets, there are three charts. The middle one, 58 lakhs, 25,144. And then please look at the next page. This is a CA certificate.
No, I do not find this 58 on
Middle, my lord.
39/2023.
Middle sales, 3923, correct.
Hmm.
58 lakhs, 25,144. That is the amount that is due.
Yes.
The admitted amount. And there is a CA certificate issued by them at 376.
Yes.
This also says that it is same.
Yes.
Please look at 377. This document is dated 29/10/24. Their CA. This is all this is not provided by before the trial court, my lord. Ex parte judgment, my lord. In 4 months' time, my lord.
Yes, my lords, kindly see my ladyship in the judgment. First of all, I want to show at ink page 28, para 3 of the judgment. I will just go step by step. Ink page 28, para 3 of the judgment.
Yes.
Because the court asked on the summons. The court has recorded suit summons were issued to the defendant company through court, email also is through court email itself, and also through speed post is duly served upon the defendant.
No,
as
you don't get it from this proceedings.
No, I'm not getting it from there. I'm not getting it from there. That may be an individual order. Court has issued it through court summons.
No, that has to be reflected in the court order. That's what I'm saying.
That is what is reflected. I'm reading through court order.
No, I understood.
Yes.
Court has made a mention.
Yes.
In the order at
Yes.
para 3 about the summons.
Yes.
When you look at these proceedings.
Not these. These, my
That's the order
friend has,
sheet.
1 minute, my friend may have extracted 2-3 dates of the order sheet. If the entire order sheet, this is
No,
the
you have it.
computerized.
You have that with regard to the summons.
I'll submit. In fact, the court record, the court registry makes a note that in the RPAD is served. And in fact, even I have a copy, in fact, it is there of the court RPAD gone and seal and signature of the party, which we had submitted after getting certified copy of the RPAD card. This is in the court records. Just, I will give a same copy to my friend. Now, this was the court RPAD where the round seal of the petitioner company Confredis and their signature of some person is also there. Now, I just want to make one submission. The court recorded that service is complete, duly complete.
To her.
They were placed ex parte. Thereafter, an ex parte order was passed. As per the ex parte decree, 11.5. Sure. After the ex parte order was passed, 11.5 crores was the decree to be paid. Execution was initiated. When the execution proceeding started, kindly see in the memo that I submitted. Kindly see in this today's memo that I submitted at page 16. Today morning that I submitted, when the court bailiff went to carry out attachment, this is submitted by me, my lords. When kindly see page 16, there are 2 checks. Yes, when the court bailiff went to carry out execution, the petitioner herein gives two checks, one for 1 crore and one for 1.5. So basically, sorry, 2.5, 3.5 crores. Kindly see the letter after that. Next page is a letter given along with given the checks. The letter states, the third para, I am handing over, no, he writes in the second para, I understand there is a decree again, Confredis Retail Limited, so and so passed by so and so judge, etc. Third para, I am handing over the following checks in part discharge, part payment of the above mentioned decree and decree amount. That means he is admitting that decree is there and he's paying this in part payment. Then kindly see, I confirm on behalf of Confredis Retail Services Limited, A, that the above checks would be honored by Confredis Retail Services upon presentation or immediately after the respective dates. B, there is no settlement between judgment debtor and decree holder and balance decree amount remains payable, recoverable and realizable. 3, in case of dishonor of above checks, decree holder will have all remedies. So they give this, and thereafter the attachment of the movables was not carried out because they gave these checks and the letter saying this is in part payment, please accept 3.5 crores, balance we will give. So the bailiff has reported this, noted this and come back. Thereafter, both these checks have been dishonored. After this was on the 5th, this letter dated is 5th when the execution was carried out. After this, on 10th, this writ is filed, and thereafter, in the meanwhile, when we reported this, the court passed an order that since you have not paid, and simultaneously, my ladyship will see at page 59 in execution petition I have filed, in which they have given these checks. Simultaneously, they have filed suit at page 59, suit and petition under Order 9 Rule 13. The Order 9 Rule 13 is at page 60.
60.
The cause title. Suit application under Order 9 Rule 13 challenging ex parte decree. So the substantive relief to challenge that it is ex parte, the proceedings are filed. In that proceeding also a stay application is sought for. That stay application arguments are heard and it is posted for orders on 31st. Ultimately, in that application, if there is any stay, that basis of granting any stay by the court will be whether service is correctly served or not. Because that is the Order 9 Rule 13 is on challenge of ex parte decree. That matter is going on. It is already heard. Both of us have submitted our arguments. It's posted for orders. Execution now. In the execution, after that, on 10th, a writ is filed here. Simultaneously, the court and a stay application in execution is filed. In the stay application, initially on 7th, the court passes an order saying that you pay 50%, conditional stay of paying 50%. In fact, in my humble submission, there are judgments of our High Court and the Supreme Court saying in money decrees, in fact, it should be 100%, whether it's ex parte or not. Your relief for challenging ex parte is there under Order 9 Rule 13. You exhaust that remedy, that is there. But in money decree, 100% should be paid. Despite that, the learned trial court judge says 50% by 7th. 7th payment didn't happen. Then they file this order writ on 10th. Simultaneously, on 10th, they file an application saying, give us time. That I is there. So you can't float in you can't be in two boats at the same time. On one hand, they say, give us time. We want 60 days time because we are arranging for funds. On the other hand, in the same petition, in the petition here, they say, in this petition at para 6, that the commercial court in para 6, they say, respondent has initiated execution of judgment and decree, para 6, dated 12/1 so and so before the trial judge by committing irregularities of service of summons. Petitioner came with delivery warrant. Delivery warrant has come from the court to petitioner's premises, and petitioner was left with no other option but to stop them from executing delivery warrant and was constrained to issue checks of 3.5 CR. That means you have given checks just to ward off and to evade the execution process of the court. On one hand, you write letters in the check which is submitted to the court bailiff saying that these checks I'm giving in part execution of decree. Decree, I agree, I understand this decree is there. Then they say, just to ward off, I have paid this. Similarly, as my lords pointed out, you file a writ challenging that order. At the same time, you file another application there, give me 60 days time to comply with the order. So this is just taking the entire legal process for a ride. Either you challenge or you comply. You want to challenge, you have the right to challenge. Like my ladyship said, you can definitely disclose to the court, I have challenged it, give me some time to await the outcome of the High Court. This is after giving a check. So whatever issues of the service irregularities, regularities, whatever allegations are there, it is all raised in the Order 9 Rule 13. In execution, you can't raise it. If the order is passed, you are without considering any evidence or matter like agreement or whatever my learned friend is saying, that is the course is an appeal. If the issue is on service, the Order 39, Order 9 is passed. This therefore has to be dismissed. In fact, I just wanted to in fact give one or two judgments. In fact, our High Court and the Supreme Court has clearly, in fact, our division bench has said that in all appeals in money decrees, 100% has to be deposited. So in fact, these are just those decisions. If my
just have a
legal
look at
judgment you're
Papa.
relying
Yes,
on.
yes.
Just have a look at Papa.
I will just
But
kindly.
for that proposition, no judgment
Yes.
is required. What is that? you're relying on
Madam.
will-
Lord,
Record your submission.
this is a judgment that is arising from
Madam.
the old Andhra Pradesh before
If I
my
can
lord,
just pass
bifurcation.
this on.
Please look at page 231, my lord, para 21. Lord, there's a fraud that is played. There's a suppression of material facts. Suppose you don't produce the 2019 agreement. Suppose you withhold some material from the court. Does it amount to fraud? Just have a look at what the Supreme Court says, para 21. It is well settled principle law that if any judgment or order is obtained by fraud, it cannot be a judgment or order in law. Justice so and so said. No, they also refer to several judgments. Please come to page 232, para 28. Allowing an appeal setting aside a judgment of the High Court and describing the observations as perverse, Justice so and so observed, the courts of law are meant for imparting justice between parties. One who comes to court must come with clean hands. We are constrained to say that more often than not, the process of court is being abused. Property grabbers, tax evaders, bank loan dodgers, and other unscrupulous all works of life find the court process a convenient lever to retain the illegal gains in. We have no hesitation to hold that such a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out. Next paragraph, important. A litigant who approaches the court is bound to produce all documents executed by him which are relevant to the litigation. If he withholds a vital document in order to gain advantage on the other side, he would be guilty of playing fraud on the court as well as on the opposite party, etc.
I think same judgment can be applied to the petitioner.
Yes.
I mean,
I was just thinking that.
what fraud have I played, my lord? Your
Not
lordship says.
fraud, coming to the court with clean hands.
Yes.
You have only read it. The first courts of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. That is what.
I mean,
precisely
if I contested vigorously for 4 years the NCLT proceedings and on the ground of threshold it was, my lord, dismissed, that means that it was less than 1 crore. The amount that was being claimed was less than 1 crore. How can the suit, my lord, be maintainable for 11.5 crores against me, my lord?
What? It is like, no, you have a
Lord,
point.
I have one
You have a
suggestion.
point, you have a point on that about the
I have a
arbitration.
suggestion to make, my lord.
Yes.
My lord, according to me, 5825 is due. I will deposit 5825 before the court, my lord. Your lordship may permit me to contest. Your lordship may say the suit will be disposed of within 6 months.
How can I deal with the suit now?
Yes,
No,
it's
I'm
fine.
saying-
It's
For
fine.
order
Order
9
Rule
13
13
petition.
is
What I'm
fine.
saying is not to execute the decree.
No, no, no.
Await in 9 rule 30.
First is order 9 rule 13
Order,
is pending.
order 9 rule 13, my lord, will be considered. But as far as execution is concerned, my lord, 5820.
In fact, that order needs to be passed by the court dealing with order 9 rule 13. Because if it finds a reason to set aside the ex parte order, or if prima facie you
My lord,
convince
it's
the
the
court.
same court that is dealing, it's wearing two hats, my lord. The executing court
It
is
is
the order
always the
9 rule
same court.
13
It
court.
has to
So
be
I
the
mean,
same court.
they-
It has to be the same court.
no, there,
Execution and
No,
order
no, your
9
lordship
has to
sees
go to
I am-
that order is awaited.
he's not going to take a different view now that he has taken this view, my lord.
Unfortunately, now and all the more reason that the client should have been careful. Because that is dealt by the same court, execution and
Yeah,
your
agreed.
order 9 rule 13.
Agreed.
Before the executing court, you ask for time and come before the court.
Yeah.
This conduct will also weigh while considering the other aspects.
I'm
I'll
just
ask the court
requesting
to,
for an
anyhow,
opportunity.
31st it is coming, let it be
Yes.
decided.
Yes.
I'll pass the order.
Please.
I will not take your ladyship through it, but all those judgments in fact say that in all money
No,
decrease
no, not
100%. That
required,
is a
not
limit.
required. You have not questioned that order. Let's not
Yes,
go into
yes.
that. Yes. No, dismissed.
Grateful.
Grateful.
Number 3, Nagaraj Asif for petitioner.
Yes.
That's point number 1.
Challenge the annexure A, MEM load,
What is the suit for?
suit for not bare injunction. The facts of the case blood,
Trial court granted?
trial court
granted.
rejected,
Appellate court confirmed.
confirmed.
Let's,
Appellate court
Earlier,
granted.
first,
Appellate court granted, trial court rejected.
you are the defendant in the suit.
yes,
Yes, please come to the MA order.
facts blood. The father of the petitioner,
You can come to the order in MA, we can understand the facts from there.
blood, before that blood, kindly see the annexure. R blood, rejection order. Page number 138.
You want the trial
Early-
court order to be.
Trial
taken.
court order.
Where is that?
138, page number 133, 130, annexure R, relevant para 11, blood. Page number 138. blood. 11, kindly see. 130, page number 1.
We'll read from reasoning part, para 7, so that I'll understand the facts.
With your lordship, this is very crucial. blood.
I'm saying I read from para 3, it's the 7 itself. At,
Reasons.
Annexure R, blood.
page 135, para number
135,
7.
yes. Para 7, the petitioner has filed the suit against the defendant for relief of permanential injunction. The plaintiff has filed a IA number 1 to restrain the defendant from interfering in the development work in the suit scheduled property at the joint development agreement executed by one Ravi and others in favor of the plaintiff and others. The plaintiff pleaded that the defendant here filed a OS number 174 and 176. But before that, in that suit, blood injunction was granted against the owner. Injunction was granted against the owner, suppressing the material blood.
When your injunction is granted against that.
Against
that-
the-
that,
against the
Ravi,
owner of this.
Purchaser Ravi and others.
Yes,
Please read it.
74 civil Chamarajanagar against the purchaser Ravi and others. This plaintiff entered into a joint development agreement with Ravi and others. The mutation of Kata has been upheld before the revenue authority, Kata standing in the name of the above said purchaser. The honorable court has granted temporary injunction without going through document as such. The order is not binding on the plaintiff. The earlier suits were filed by the defendant herein for relief for declaration and injunction, comprehensive suit. The plaintiff themselves stated that the purchaser Ravi and others are the defendants. Earlier suit, the support of their argument, they have filed a revenue records and alienation order and copy of the development agreement. The counsel of the plaintiff relied on photographs as the plaintiff have invested money for development of land after execution of joint development agreement. Further, counsel argued that if the injunction not granted at this stage, the plaintiff will suffer from financial loss as they were already paid a huge amount to the purchaser of land. Per contra, the counsel of the defendant has produced entire case records in the earlier suit as stated above. I have gone through the said document. The said suit filed on 8/8/2022, and the purchaser of the suit scheduled property, Ravi, Mahesh, and Pal Chandra have been impleaded by filing application under order 1 Rule 10 to CPC by plaintiff. They have appeared through their counsel before the court on 30/9/2024. The defendant 2 to 4 to 6 in the above sets have filed a written statement on 11/3/2020. They have executed a joint development agreement in favor of plaintiff before filing the written statement, that is on 8/2/2025. The conduct of the defendant 2 to 4 in the earlier suit clearly showed that they have know the consequences of the execution of the joint development agreement during the pendency of the suit. This is not a case of the plaintiff as they have no knowledge about the dispute between the defendants herein and purchaser have executed the joint development agreement in their favor. The plaintiff contended that the said TI order is not binding on them as the honorable court not verified the document. Said contention of the plaintiff would not establish prima facie case. The court cannot grant injunction on the ground. The counsel for the defendant argued the defendants are in possession and para 7 of the agreement relied by the plaintiff itself is reveals that the purchasers who have executed the joint development agreement are not in possession of the property. The said contention not establish handling over the possession, but it shows that the plaintiff have been permitted for having possession of the property. The plaintiff are not in possession of the property on the date of filing of the suit. As such, not entitled for order of injunction. On going through the pleading of both the parties and argument placed by the counsel, there is no dispute as land was granted by dispute arose between the parties after sale of property by two different persons. The possession is in dispute and no material placed by both the parties to establish their actual position. The counsel of the plaintiff argued that being joint agreement holder is in possession of the suitable property for that aspect. The counsel for the plaintiff relied decision as stated above.
Oh, you are the plaintiff in the earlier suit?
Yes, ma'am.
And there is an injunction in your favor?
Yes, ma'am.
Against the purchaser?
Against owner.
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 Hmm.
See, they have filed the
What is the relation?
they have filed the return statement. They have not disclosed the joint development.
No, what is the relationship between that defendant in your suit and this plaintiff?
Lord, I have purchased the land during 1975
Hmm.
from grantee,
Hmm.
75 and 85.
Hmm.
After PODI, new number has been given. The old number will continue. The heirs of the grantee, Lord, taking advantage of the property, they have sold the property.
To this?
Yes, Lord. After filing the suit,
Defendant in your suit.
after filing the suit.
No, to the defendant in your suit.
Yes, Lord. Defendant,
And about this person is also purchased the property?
not purchased. They are developers.
Registered joint
With the purchaser?
Yes, developers.
Yes, now come to the appellate court's order.
Earlier, Lord, they have approached the Honorable High Court against the order of the MEA. They declined to grant an order.
Yes.
Their observation was made. Lord.
Please come to the MA order now.
The reason,
Where do you get it?
13, page
20.
para 2013. It is an admitted fact that the plaintiff have instituted the suit seeking relief of declaration permanent injunction in respect of the suitable property and a careful perusal of the record. This court is of the considered opinion that learned trial judge committed an error serious in dismissing the IA number 1 by misappreciating the pleading.
20, page number 20.
Page number 20, Lord, para 13. I'm reading 14, Lord. The trial court failed to properly appreciate the registered joint development agreement. It is a registered sale deed dated 3/4/2023.
It is for bare injunction.
Is bare injunction. My is comprehensive suit for declaration.
At para 17, you see? Para 17.
Bare injunction. This is a wrong. This is a suit for declaration and this is a wrong. This is only bare injunction. Their suit. The question 16, Lord, it is further evident from the records that the appellants have approached the Honorable High Court of Karnataka by filing the writ petition 15672, challenging order dated 7/5/2026, passed in MEA number 1 of 2026, insofar as declined to grant an ad interim ex parte injunction. While disposing of the writ petition, Honorable High Court directed
What do
the
you
first.
say? What is this order?
Lord, kindly see minutes. I have produced registered joint development agreement, registered seal deed, tax paid receipts, and all the documents minutes showing that I am in possession as on the date of filing the suit. What the trial court did minutes, without considering all these documents, simply said that none of the documents have been produced. But as a matter of fact, records are available with the court. That is why para number 14, Your Lordship, kindly see.
You have an agreement with the person.
Yes.
Against him, the
Yes.
source of your agreement and everything is
Yes.
given by that person.
But kindly.
No, against, there is an injunction operating against that person. How
Injunction,
can you proceed?
Kindly see minutes. Injunction was granted minutes without examining the records placed by
But
the
we have
defendants.
to-
That was
No.
challenged before minutes appellate court.
That will
Yes.
eventually take, but there can't be these kind of conflicting orders.
Kindly see minutes, page number 21, para number 14. Para number 14, Your Lordship, kindly see minutes. The trial court failed to properly appreciate the registered joint development agreement, registered sale deed dated 3/4/2023. The mutation order passed by Tahsildar, RTC extracts, revenue records, Haddubast sketch.
How can you,
conversion.
joint
All
development
these
agreement,
documents.
no, please understand
Please,
what the court is
please.
saying. Joint development agreement is between you
Please.
and the defendant in the suit.
Yes,
There is an injunction against it.
Right.
Both of you are doing it.
yes.
When there is an injunction not to make any further construction in a suit for declaration and injunction.
Kindly
how
see,
can-
Milords, it is not that Milords not to make construction, not to interfere. Milord, they themselves not produce document which is invalid because the original
We
owner
cannot
Milord
say.
died. Kindly see, Milords.
In this suit, we
Yes.
cannot say the order passed in the other suit is wrong unless.
Not
and
binding
until-
because
Binding on your,
Yes.
with whom
Plaintiffs,
you have entered
plaintiffs.
into.
plaintiffs.
It is binding on the person with whom you have entered into an agreement.
Yes.
Basing on that agreement,
Yes.
you want to make
But
construction now.
Milords, kindly see, Milords, the injunction was granted without examining the records.
Please understand
Therefore,
that.
Milords-
How can we decide it now?
Milords,
in this
kindly see
suit?
the order passed by the trial court first, Milords.
I have seen that.
Please, Milords, what the trial court observes, Milords, the possession is in dispute and no such material placed by both the parties to establish their actual possession. Milords, we have produced the documents of title of our vendor and also, Milords, our possession, RTC extracts, Milord, tax-paid receipts. Moreover, Milords, joint development agreement which is registered sale deed. None of the documents have been referred by the Milord, trial court, even in the previous order also. Therefore, previous orders are under challenge, Milords, in separate ME, which is pending. Milords, in the meanwhile, Milords, when we are invested the huge funds, Milords, they are preventing us. Milord, admittedly, Milord, it is in our possession because, Milords, the plaintiffs, Milord, very plaintiff in the earlier suit have admitted in their cross-examination that they are not in possession. Milord, subsequently, cross-examination has been done before the trial court. They was virtually conceded that they are not in possession. Of course, it is subsequent development. Milord, as of now, Milord, we have taken the development program, Milord, activity, and we have shown the first appellate court by producing registered documents that we are in possession.
Let
We
your,
have-
let your partner,
Please.
let him get the other order decided. But, yeah, till such time you are not entitled. There can't be orders like this. A
Milord,
person who is the
Milord,
owner of the land is
Milord, Jayalakshmi,
injuncted.
Milords.
No, owner of the land is injuncted and a person with whom he has entered into development agreement
Yes.
will continue with the work.
Milord, the prima facie case
W-
balance
in
of
WS,
convenience,
they are
Milord,
not
lies in my favor because, Milord, as Milord, order 39 rule 1 and 2, Milord, the court has to look into who is in possession, prima facie, Milord, who is in possession. Milord, we have produced documents of, Milord, title deed as well as other relevant.
Can't be in a better position than your, the owner
Milord,
of the
vendors,
property.
Milord, as a matter of
Than the owner of the property or nothing to do with the
Milord,
vendor.
of course, Milords, vendor, Milords, might be, Milords,
Purchaser.
restrained.
He is the owner of the property, has entered into an agreement with you.
Yes.
There is an injunction against him.
Yes.
You will not be in a better position
Milord,
saying that
Milord,
I have
injunction
title
is-
to the property.
Milord, injunction is subsequently granted, Milords, subsequently granted. Milord, kindly see, Milords, one judgment, Milords, of this
Please,
honorable
please.
court, Milords.
Oh,
Milord, on the honorable Supreme Court, Milords.
yes,
Para number 16, Milords, may kindly see, Milords.
yes.
16, Milords. The ratio of the above noted judgments is that once the court of first instance exercises its discretion to grant or refuse to grant relief of temporary injunction, and the said exercise of discretion is based upon the objective consideration of the material placed before the court and is supported by cogent reasons, the appellate court will be loath to interfere simply because on a de novo consideration of the matter it is possible for the appellate court to form a different opinion on the issues of prima facie case, balance of convenience, and irreparable injury and equity.
In fact, this
Here,
will-
Milords, kindly see, Milords,
Oh.
here,
No.
Milords.
This judgment which you are quoting now, I'll apply this to the
Milord.
appellate court.
Milord, of course, Milords, now, Milords, we are not under Article 227.
No, I'm
Milords,
saying.
And even, Milords, one more judgment, you may kindly consider, Milords, para number 9. Quote. Para number 9, Milords, this honorable court, while confirming the order of the trial court, observes, para number 9, Milords, it is also seen from the records that the plaintiff has placed reliance on the registered sale deed dated 27/4/2021 and the gift deed dated 5/1/2023, along with the supporting documents as such kata, tax-paid receipts, and other documents. At this interlocutory stage, these documents prima facie indicate that the plaintiff has derived a title and is in possession of the suit.
This observation is in the general facts and circumstances.
Yes.
Not in your case.
Milords, of course, Milords, when the trial court, Milord, rejected my application for injunction without considering my documents, But where, my lord, I have established prima facie in possession and balance of convenience lies in my favor, but the court should have exercised the jurisdiction under Order 39 Rule 1 and 2. On the other hand, what the trial court did, my lords, kindly see one sentence, my lords, here in this suit, title and possession of the parties is in dispute. My lords, title, my lord, is in dispute. My lord, it is, my lord, it can be proved, my lords, only after trial. Only after trial. Moreover, my lords,
In fact, appellate court has committed an illegality or there is an error on the face of the order itself. The court considered this as a suit for declaration. And that is a suit for bare injunction. And the court says during the course of the trial that the title will be
trial
decided.
court find it that the suit would be for title also. Otherwise, the finding should not have been come, my lords, as the title is in dispute.
Please come. The petition is before this court. Agreed with the order passed in MA number 11 of
May I
2026.
make one more submission, my lords? As on the date of sale, my lords, in favor of the my lord, first petitioner, the very executor was dead, my lords. This sale deed, my lord, is not executed by the real owner. That is what the contentions raised by the plaintiff, my lords, herein.
The plaintiff has agreed with the order passed in MA number 11 of, the defendant is agreed with the order dated, passed in MA number 11 of 2026, dated 6th of July 2026 by the principal senior civil judge and CJM at Chamrashnagar. The petitioner, the respondent herein has filed a suit for bare injunction and also sought for filed an IA seeking an injunction that came to be dismissed by the trial court by order dated 24th November 2025. The court, while dismissing while rejecting the application for injunction, the court has observed that the defendant, in fact, has filed a suit against purchasers seeking declaration and injunction. In the said suit, the court has granted injunction and the said injunction is subsisting. Further, now the plaintiff here is the developer who has entered into a joint development agreement with the defendant, with the defendant in the suit for declaration. It is the court has considered this aspect. And the court also considered the photographs which clearly established that no, where is that order?
Not annexure A, my lords.
Page number?
Page number 21, my lords, para number 14.
No, not the impugned order, the order of the trial court.
Trial court, my lords,
Page number 135.
Reasons.
Page number 130, annexure R.
27th April, 27th April 2026. The court has observed that in the suit, the title and position of the parties is in dispute. The defendants have already approached the competent court for their redressal by filing suit for declaration and injunction. The executant of the joint development agreement have been already contested their case before the court. After appearance of defendant number 4 to 6 therein, the court granted temporary injunction in favor of the plaintiffs, that is the defendant in the present suit, by passing a detailed order. The plaintiffs are standing in the shoes of defendant number 4 to 6 in the other suit, as the court specifically passed order restraining the defendants, his agents, or anybody acting on behalf of them. The suit has been filed by the plaintiff for relief of injunction after knowing pendency of above suits, and there is no such satisfactory explanation given by the plaintiffs why they have filed this suit before this court. The granting injunction order in favor of the defendant herein in the earlier is nothing but accepting the granting injunction order in favor of the defendants herein in the suit for declaration is nothing but accepting their position. Therefore, The court cannot give contrary findings with regard to position.
Those orders are appealed, my lords. MAs are pending.
That moreover, if application not allowed, no such hardship will be caused to the plaintiff, and the rights would be defeated as they may get damages from the execution of joint development agreement. Hence, the court has dismissed the application. When the matter was carried in the appeal, the appellate court by order dated 6 July 2026 has granted injunction in favor of the plaintiff. While granting injunction, the court observes that the present suit is one for declaration and permanent injunction. The questions relating to title, ownership, and the ultimate rights of the parties over the suit scheduled property are disputed questions of fact and law, which can be conclusively adjudicated only after a full-fledged trial. At this stage, considering on application under Order 39, Rule 1 and 2, 1 and 2 CPC, is not required to record any final finding regarding the title or ownership. The scope of consideration is confined to examining whether the plaintiffs have established the prima facie case, balance of convenience, and irreparable injury. The court observes that the documentary evidence produced by the appellants, including the registered joint development agreement, the registered sale deed, mutation entries, revenue records, and the conversion order, prima facie establishes their lawful right and position for the limited purpose of deciding the application for temporary injunction. Therefore, the trial court was not justified in rejecting the application by entering into issues relating to title and position, which are required to be finally determined after a full-fledged trial. The right, title, and interest of the party shall ultimately be decided by the trial court on the basis of the evidence adduced during the course of the trial. Accordingly, the court has granted injunction. The learned counsel appearing for the defendant submits that when the trial court, considering the earlier suit that is filed by the defendant, that is the petitioner herein has rightly refused to grant injunction, and the court has judiciously exercised the discretion. It is submitted that now the appellate court has gone beyond the jurisdiction conferred on it and has granted injunction, and the reasons that are assigned by the court for granting injunction cannot be sustained. It is submitted that when the owner itself is a party to the earlier suit, who is suffering, where there is an order of injunction, basing on an agreement that is executed by him, the defendant cannot, the plaintiff herein cannot file a suit for injunction. All these aspects were rightly appreciated by the trial court, but the appellate court lost sight of all these aspects and granted injunction. It is submitted that the order impugned needs to be set aside. Next para. When counsel appearing for the respondent submits that the respondent plaintiff submits that when an application is filed under Order 39, Rule 1 and 2 seeking injunction, the plaintiff has to place the material, has to show a prima facie case, balance of convenience, and irreparable loss. The plaintiff has shown the prima facie case basing on the registered development agreement, the RTC extracts, and other documents. Further, and that itself clearly shows the title and the prima facie case. Further, he has invested huge amounts, and if this construction is stopped, it would cause a lot of hardship. Hence, there is balance of convenience and irreparable loss in favor of the plaintiff. These aspects was rightly appreciated by the trial court, by the appellate court. However, the trial court has failed to exercise its discretion and consider the parameters for granting an order of injunction, injunction. The appellate court has rightly exercised the discretion, and there are no grounds to interfere by this court. He has relied on an order of the Honorable Apex Court in case of Skyline Educational Institution Private Limited versus SL Vaswani and another, reported in 2010 Supreme Court 3221. He relied on paragraph number 16. It's right. He has also relied on another judgment of a coordinate bench of this court in MFA number 8849 of 2025, dated 2nd April 2026, in case of Srimati Manjula TS and others, versus Srimati Manjula N. He relied on paragraph number 9. Relying on these judgments, it is submitted that the petitioner could make out a prima facie case, and the order passed by the injunction that's granted in the other case is without appreciating the facts of the case. And in fact, against that an appeal is filed, and the same is pending consideration. And the same is pending consideration. Hence, at this stage, that cannot be the basis for the court to reject the case of the plaintiff. Next part. Having heard the counsel, Sunny decide per the material on record. The plaintiff, the suit that is filed by the respondent plaintiff herein is a suit for bare injunction. The defendant herein has filed a suit for declaration and injunction against the defendant therein who is the purchaser. The petitioner plaintiff in this suit had entered into a development agreement with the defendant in the suit for declaration. There is an injunction that is granted in suit for injunction an injunction is granted in a suit for declaration against the defendant, and that will operate against the defendant, the man assignees, and any other person deriving right and title through him. The joint development agreement is entered between the defendant in the declaration suit and the petitioner. In a way, the injunction that is granted against the purchaser or against the owner of the property operates against the plaintiff in the present suit, who has entered into a joint development agreement in respect of the very same suit scheduled properties. It is a submission of the learned counsel that by placing the joint development agreement, by placing the title deeds, he has shown a prima facie case, and he relies on the coordinate bench judgment of a coordinate bench. In a normal sense, when the party comes to the court seeking injunction, the court would be looking at the prima facie case, and all these documents in a normal course would constitute a prima facie case, but not in a case where the owner of the property has himself there is an injunction against him which is operating as on today. In those circumstances, the plaintiff cannot say that he has made out a prima facie case. The court has also the trial court has rightly observed that when the suit for declaration and injunction is pending, when the owner of the property has suffered an injunction order which is subsisting, how the suit for injunction is filed is not known. In these circumstances, the trial court has rightly appreciated all the facts and rightly rejected the application for injunction. However, the appellate court travels beyond the jurisdiction conferred on the court and granted an injunction without injunction contrary to the settled principles of law. In that view of the matter, the order impugned dated so and so needs to be set aside, and the order of the trial court is restored. Cast in I number so and so is restored. This court has not made any of the observations made by this court shall not be construed as an expression of the court, as they are only for the purpose of deciding the interlocutory application.
Please.
Bill number 4, Raja Ayari for petitioner. Mohantesh Yasov Osman.
This case appear for the petitioner. Petitioner is the plaintiff before the trial court. Suit for declaration and easement right of the encroachment of deed scheduled property. After completed of the evidence, the plaintiff is to file the application order 26 rule 9 to the appointment of the commission before the trial court.
Come to the order.
The trial court input order is Annexure G, my lord, page number 67. After hearing the application, trial court is rejected the application. Hence, file the writ petition, my
Come to
lord.
the order, reasoning parts.
in the impugned order,
Come to para 7.
70, Moila.
Yes, paragraph number 7.
The plaintiff has filed a suit against the defendant for the relief of the declaration. Suit D property is the public road and granting the permanent injunction against the defendant over the suit scheduled property. Further, the plaintiff seeking appointment of the court commissioner to review the dispute of the respect of the identity of the descheduled property and ascertain the whether the suit property is road or not through the survey or as per the record. The defendant appeared and filed the written statement. Now the matter is both the side evidence is completed and now the case is posted for argument. At this juncture, the plaintiff is presenting the IA appoint of the court commissioner to make the local inspection of the suit scheduled property. As per the plaintiff is pleading.
Why can't it be allowed?
Lord, the court is very clear that not there is no any ambiguity and there is no this thing. So therefore, para 9, Lord, the reasoning.
I've seen that.
Yes,
No, considering the nature of the dispute, if the advocate commission is appointed, it is not a conclusive evidence. It's for the court whether to take it or not.
Certainly, Lord.
Why should it?
Certainly, Lord. May I make one submission?
Yes.
This is a third round litigation, Lord. In the year 2012, when I obtained, Lord, the permission to, Lord, the license to construct the property, Lord, the defendant challenged it, Lord, before the municipality. Municipality has cancelled my license. Lord, in the same this thing, Lord, his contention is there is a road carved out in my property. Lord, this court, Lord, up to this court, this thing has been travelled. Lord, this court consistently set aside that, Lord, there is no road. Lord, then I'm, Lord, I'm compelled to file a suit, Lord, because of, Lord, his disturbance. I file a suit for, Lord, injunction. Lord, in injunction suit also, he's take up the same defense that, Lord, there is a road, existing road. Lord, after the contest of the suit, Lord, my suit has been decreed.
Unfortunately.
Once again.
No, unfortunately, where are those?
I have produced all those documents, Lord. It is.
That's not the reason for the court to deny it.
The court is not denied by citing that reason, Lord, because.
But we can only look at the reasoning given by the court.
Yes.
When we are considering an order, we can only look, nobody can supplement or supplant the order of the court reasonings.
No, my only, Lord, endeavor to your Lordship, Lord, there are two consecutive orders, Lord, up to this High Court, and Lord, in a suit filed by me in a
It will be
OAS.
conclusive now. It's also good for you. It will be conclusive now. When
But
there is no road, then the.
No purpose may pass on the, Lord, only relevant portion I'll read it, Lord, RA court judgment. There is a, Lord, consideration, Lord, as there is a road existing or not. Lord, I may pass on, Lord.
Is it correct? Already
And-
there are findings by the courts that there is no road.
And file the civil suit is the earlier observation, my lord, this honorable court. Only file the suit for easement rights.
But
That
para
file the suit for.
I'm saying, when as far as the road is concerned, in the earlier round of litigation between both of you, there is a finding that there is no road.
Only challenging the earlier license granted by the
I am
executive.
asking about a finding with regard to road. Is it correct what he submits?
No, my lord.
Finding that?
No, no, no.
I read, Lord, para
Oh, the
18.
order is here.
Hmm.
Yes, where is that page
Para
number?
18 of RA judgment, Lord. The
Para?
first, para 18, 1-8.
Hmm.
Lordship got it, Lord. After analyzing the evidence of the DW1 and also the evidence of his witnesses, which according to me is not required for appreciation, I straight away gone to the exhibit P16, which is the rough sketch produced by the defendant learned counsel for the respondent has brought to the notice of the court that even as per the rough sketch produced by the defendant themselves, there is a gully which is existence which is shown in the black color of line. And absolutely there is no road in existing in the suit schedule property. The defendant here in also, Lord, the defendant plaintiff here exists in property. Exhibit D16 substantiate the argument of the learned counsel for the respondent. Learned counsel for the appellant during the course of argument has squarely contended basing on
Straight away
exhibit.
come to that finding. Straight away come to that specific finding.
This is the, Lord, the observation where says that, Lord, the court says there is no existence of a road pre-existence.
Did you
of the
get that exact observation?
Lord, that is what I read it, Lord, now. Exhibit
Submission.
P16, para 18.
That is a submission.
Para 18,
Uh.
para 18, exhibit P16, which is rough sketch produced by the defendants, Learned counsel for the respondent has brought to the notice of this court that even as per the rough sketch produced by the defendant themselves, there is a gully which is in existence, which is shown in the black color of line. Absolutely, there is no road existing in the suit schedule property.
That's a submission.
Yes, para 19 is not the para 19 not the reasoning which court held that not in the negative. It's not, it's a two and a half page not para. Very not.
No, he's a plaintiff in the suit.
He is a plaintiff now in the suit. Not in my suit, he is a defendant. His contention was that not there is a road
No, it is for him to establish. No, he's seeking a declaration that he has a right of easement. Yes, please come. The agreed with the order past 10, I number 8, NOS number 935 2015 dated 25th June 2026 with the principal surgeon JMS at Mandya. The petitioner plaintiff is before this court. The petitioner has filed a suit seeking the declaration that the suit schedule D property is public road, which is meant for ingress and egress of the plaintiff defendants and the public at large, and consequently sought relief of permanent injunction restraining the defendants from either encroaching the suits, the scheduled road portion, or putting up any kind of construction over the same. After the evidence is completed, the present application is filed seeking appointment of a commissioner. An application is filed under Order 629 to appoint a court commissioner to survey the suit property and ascertain the existence of the road property in just and to answer the memo of instruction to the parties. The court by order impugned had dismissed the said application. Court observes that whenever court cannot decide disputed fact on the basis of available record and evidence placed before the parties, then only the court can ask help of the commissioner to submit a report about the point in dispute to decide the dispute in a satisfactory manner. Whereas in this case, now the evidence of both the parties have been completed. When the case is posted for argument, without arguing the matter, the plaintiff has filed this application. By looking into that aspect, it is noticed that the plaintiff has intended to drag on the proceedings. Even if a commission is appointed and a report is submitted, it will not be helpful to settle the disputes on the basis of the commissioner report. But the court has decided the suit by considering both the parties' evidence such as documentary and oral evidence. Accordingly, the court has dismissed the application. Then counsel appearing for the petitioner submits that if the commissioner is appointed and the report is placed before the court, it will be helpful for the court to decide the dispute. As rightly observed by the court, the report of the commission is not conclusive, but it will be helpful for the court. It is submitted that in the light of the litigation between the parties, there would be a quietus to the litigation, and the court, without considering all these aspects, had dismissed the application. Next one. Then counsel appearing for the defendant submits that the court has rightly dismissed the application. In the earlier rounds of litigation, the plaintiff could not prove that the petition herein could not prove that there is an existing road. In fact, according to the land counsel, the defendant, there are observations in the previous litigation that he could not prove that there is no scrap of paper is filed to show that there is a existing road. It is submitted that in those circumstances, the present application is filed only to drag on the proceedings, and this aspect has been rightly appreciated by next para having heard the counsel's concern. The suit is for declaration of the easementary right of the petitioner. No doubt there are previous litigations, the suit for injunction filed by the defendant herein, and also another one.
Another one not also filed by me, writ petition, which has been challenging.
Also a writ petition when the petitioner and the plaintiff herein has this with regard to the easement between the plaintiff and the defendant in various proceedings. The evidence is adduced. Now the matter is posted for argument. At this stage, if the if the commissioner is appointed, and that the commissioner report would help the court to decide the dispute between the parties in a more effective manner. and there is no prejudice to any of the parties. In those circumstances, the court ought to have allowed the application in that view of the matter. This court is, accordingly, the order impugned is set aside. And IA number so and so is allowed. The plaintiff shall cooperate with the court and shall not seek unnecessary adjournment.
Both the parties may be allowed to file their memo of instruction.
Both the parties are allowed to file their memos of
Instructions.
instructions. Yes.
5. Party for petitioner S. Rupesh Kumar.
Petitioner, Your Lordships. The petitioner was defendant number 1 before the trial court, Your Lordships. His election was challenged by the respondent number 1 plaintiff here in Your Lordships.
What is that? What is the suit for?
Suit for challenging the election to the to respondent number 2 organization, post of president, Your Lordships. That was challenged in OS. And IA number 12 comes to be filed before the trial court, Your Lordships, seeking recount of votes.
Yes, I remember.
Please, Your Lordships.
You were saying something that it is
If
already
Your
done.
Lordships had asked what is the current status, Your Lordships. Current status, IA number 16 has been filed by the plaintiff seeking to continue with the recount of votes pertaining to the post of president without deposit of the entire amount, Your Lordships. The matter is posted for orders tomorrow, Your Lordships, on IA number 16.
Why should the court do this exercise?
My Lord,
When
the reasons are recorded
when the
by the
prayer
trial court.
itself, when the main prayer itself is that,
Yes.
at an interlocutory stage, why should the court do it?
My Lord, the suit was, the election is of the year 2024. ma'am.
So forget about that. But the relief is that. That's the main relief you're seeking. In an interlocutory stage, court has in fact allowed it. It almost amounts to allowing part of your prayer.
My Lord, if the direction is given to dispose of the suit, my Lord, within a time-bound
Yes.
manner, my Lord. Please, that would help the.
We'll set aside this order. We'll ask.
No, let this order be kept in abeyance until the completion of evidence, my Lord. Lordships. No, my Lord, there is.
Oh, why? What is the purpose?
My Lord, again, I will have to file an application, my Lord, for recounting.
That is the prayer.
Main prayer is there, my
Also,
Lord.
that has to be decided by the court.
Agree, my Lord.
Please come. Where is the order?
Lordships, order is at page 83, Annexure E. My Lord, I have also deposited the amount, my Lord, for recounting, my Lord. The returning officers, my Lord, are also hand in glove with the present petitioner, my Lord. My Lord, kindly see, the returning officer has not challenged the order, my Lord. The application is filed by the answering respondent, my Lord, is under 94E, my Lord, seeking respondent number 3 to recount, my Lord. He has not filed any objections, my Lord. Whereas the defendant number 5.
But he is affected party.
Yes, my Lord.
He has
My Lord,
every right to ask.
If the election has been conducted in a proper manner, my Lord, he should not be affected.
No, I am not going into all those aspects now.
I agree, my
I'll
Lord.
read by the order passed in I number 12 in OS number 1388 of 2024 dated 2nd May 2026 by the 12th additional civil judge and JMFC at Mysore. The petitioner, who is respondent,
Respondent number 1.
respondent number 1 is before this court. The respondent herein has filed a suit. Where is the plaint?
Plaint is, Your Lordship's, Annexure A, page number 15.
Has filed the suit to declare that the election held on the second defendant unit by the post of president on 21/7/2024 is illegal, invalid and inoperative in law. To order for recounting of the ballot in open court through court commissioner appointed by the court. To further grant the decree of mandatory injunction directing the first defendant to conduct the election to the post of president afresh in accordance with law. In the said suit, the respondent herein has filed an IA under section 94E, read with section 151 CPC, seeking a direction against defendant number 3 to recount the votes casted on 21/7/2024 with respect to the election conducted by defendant number 1 and 2. That came to be allowed by order impugned. And the court has directed the defendant number 3 and 4 being the returning officer and deputy returning officer to conduct recounting of votes in the election held on 21/7/2024 within a period of 2 months from the date of this order by following due process of law and in strict compliance with the applicable procedure under the bylaws of the All India Veerashaiva Mahasabha or any other governing law applicable to the election process. and the recounting shall be conducted after issuing due notice to all contesting candidates and in their presence, and shall be carried out in a transparent manner. Land counsel for the petitioner submits that such a course is not available to the court at an interlocutory stage to call for the recounting. It is submitted that the court is virtually going to decide the main relief that is sought by way of this order. He relied on an order passed uh, by the Bombay High Court at Nagpur bench in case of Deepa Sunil Sahare versus the returning oblique election officer, municipal council and others. He relied on paragraph number 17. He relied on paragraph number 17 extracted. Relying on this judgment, order is submitted that it is not, the court cannot, the court ought not to have allowed the application. Next para. When counsel appearing for the respondent submits that the court has rightly allowed the application, it is submitted that when the elections have not conducted in a transparent manner, it is incumbent upon the court to recount these votes, and basing on an application filed by the petitioner, court has allowed the application, and there is no infirmity with the order passed by the court. It is submitted that the writ petition, the returning officers, I have not questioned this.
Yes, ma'am.
D2 and D3.
Yes, ma'am.
D2 and D3 have not questioned this, but only the petition has come before the court, which clearly shows the manner in which the elections are conducted. It is submitted that the writ petition may be dismissed. Next paragraph. The IA, in having heard so and so, the IA that is filed by the petitioner is the prayer that what he has sought in the suit itself, that is prayer number B. The court has ordered the same. The petitioner has relied on an order passed by the Delhi High Court. In that the court has, the Bombay High Court, in that the court has observed that evidence is not yet let in by any of the parties, and the application for recounting of votes is decided only on the basis of the mere allegation as contained in the application filed by the election petitioner. The court observed that there cannot be compelling circumstances warranting immediate recounting of votes even before recording any evidence. Admittedly, in this case, as so far the evidence is not let in those circumstances, the trial court ought not to have
Para
allowed
22, ma'am. Para 22. The court has given liberty to file fresh application to
so
it arises.
What did you write? Ought not to have allowed the application. However, this will not preclude the don't write this. And as should ought not to have allowed the petition. Accordingly, this court is passing the following order. The order impugnated so and so is set aside. Accordingly, the petition is allowed. Number 2. However, this will not preclude the respondent herein to make an application at an appropriate time.
Speedy disposal.
The trial court shall dispose of this matter as expeditiously as possible.
Within 6 months, ma'am. Please. Already 2 years has lapsed, ma'am. That is the reason.
Yes.
Pratik, there are for petitioner. Nirmala
My lords, I am appearing in item 6. My lord, this is connected to writ petition 13260/2026, my lords, which is a challenge to the CRC deviation settlement mechanism regulations. Your lordships have already passed, my lords, 2 similar orders. My colleague will just, my lords, hand over that order. We are just requesting that the same order be passed and this matter be tagged along with that. Your lordships just have that order. This is the order sheet in 13260/2026, and if your lordships have paragraph 4 of the order of 27/4/2026, your lordships will see, my lord, that having regard to the submission made and a prima facie case being made out, pending consideration of the writ petition, and the petitioners are willing to continue under the earlier DSM regime and comply with the existing deviation norm.
This court and the connected matters that is WP 13260/2026, has passed an interim order. And the petitions also stand on the similar footing. And also the prayer that is sought is, that petition is also the same. Hence, considering the order dated
7/4, 27th of April.
27/4/2026.
6.
It's 27/4/2026. Pending consideration of the writ petition. As the petitioners are willing to continue under the entire DSM regime and comply with existing deviation norms, the operation of regulation 6(2)B and 8(4) of the DSM regulation 2024 shall not be enforced against the petitioner to the extent of revised formula and enhanced penalties till the next date of hearing. The petitioner shall continue under earlier DSM regime. Deviation up to 50% shall be governed in terms of the earlier framework, and the petitioner shall pay deviation charges accordingly. Notice to the respondents. List along with so and so.
I'm obliged.
Yes, next.
Obliged.
On all the respondents. You appear for the
Ladyship,
respondents.
I appear for respondents 1, 2, and 4.
1, 2, and 4. 1, 2, 8, the respondents. Then who is left? No. 1, 2, and 4 are served. Who are the other respondents?
3 is the Central Commission, my lord. Notice will have to go to them. I think they have not entered appearance in the other matters.
3 and 5 to 8. Notice. Yes, next.
Obliged.
7, R.K. Mahadeva.
Petitioner filed the suit before the trial court, suit for injunction, and also filed an application before the trial court order Rule 6 and order Rule 617, and came to be rejected.
When is the suit filed?
Suit is 2022.
Suit for?
Suit for injunction.
What is the present stage of the suit?
Now is framing the charge. Framing the charge. Issues.
Why it is dismissed? Come to the order.
Order page number 60. Only typographical documents, all the documents, page number 16, relevant, page number 16, reasoning, para 8. The plaintiff contended that the mistake crypt, the plaint are only amend the northern and southern side of suit schedule property along with the proposed amendment. If the amendment application is allowed, the entire suit property would become the different. And the claim of the
What
plaintiff.
are the objections of the defendants?
Defendant objection, page number 36.
Page number?
36.
Yes.
Page number 36, Annexure E.
When counsel for the petitioner submits that when an application is filed, seeking amendment of the plaint, the court has rejected the same only on the ground that it has been filed at a belated stage and has failed to give any cogent reasons for the same. Considering the same, there shall be the stay of all for the proceedings pursuant to the order dated so and so. Notice to the respondents. Hand summons memo shall be filed by 10th of August, or else a stay granted by this court stands vacated. Next.
Deliberate.
Much obliged.
Sundararaman
My lordship,
MP for petitioner.
tomorrow hand delivery. Tomorrow case is pending before the trial.
Hand
Hand delivery.
Yes. Yes.
Is that matter which had come up?
Today all contested matters. Even till now,
I don't know, I was just wondering. This won't take more
morning
than 30
started with 2 senior counsels. That is continuing. Yes.
Well, this shouldn't take more than a minute, Manoj. This should not take more than a minute, Manoj, because
yes,
my learned friend's grievance, Manoj, without short-circuiting his submissions, Manoj, is that his application filed under section 47 of the CPC, Manoj, was not properly considered by the commercial court in execution proceedings. Manoj, the short response, Manoj, taken by a coordinate bench of this honorable court, Manoj, which lays down the law, is that the section 47 application itself is not maintainable in respect of arbitration matters. So the question of that not being considered properly can never be a grievance, Manoj, which is taken, Manoj, before this honorable court.
Learned friends should have possibly checked a little more
because after that judgment, Supreme Court has answered that question in two judgments, where the Supreme Court has said a Section 47 application is maintainable. I'll pass it on. I don't know why my learned friends have not checked this note, but the lot has. Copy. Give them also a copy. In the context of an arbitration proceeding, as a matter of fact, now it went to the extent of saying, even if you have not challenged under 34, you can still raise a ground under 47 to say it is a nullity in execution proceedings. Can I humbly request now to kindly come to para 67 of this judgment? The High Court is correct. I'm sorry, my lord has that. Page 795. And this is subsequently followed by another judgment of Justice K.V. Vishwanath. Para 67. The High Court is correct in answering the first issue that a plea of nullity qua an arbitral award can be raised in a proceeding under Section 47 CPC, but such a challenge would lie within a very narrow compass. Section 36 deals with enforcement of arbitral awards. Subsection 1 says that where the time is for making an application to set aside an arbitral award under 34 will expire, then subject to provision subsection 2, such award shall be enforced in accordance with the provisions of CPC in the same manner as if it were a decree of the court. As per subsection 2, where an application to set aside an arbitral award has been filed under 34, filing of such an application shall not by itself render an award unenforceable unless an order of stay is granted by the court. Therefore, in terms of Section 36, an award can be enforced in accordance with provision of CPC in the same manner as if it were a decree of the court. Then 36(9). Section 46 deals with questions to be determined by the court executing the decree. As per subsection 1, all questions arising between the parties in the suit in which the decree was passed and relating to execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Execution of decrees and orders is provided for in Order 21. Law is well settled that at the stage of execution, an objection as to executability of the decree can be raised, but such objection is limited to the ground of jurisdictional infirmity or voidness. Law laid down by this court in Vasudev is that only a decree which is a nullity can be a subject matter of objection under 47 and not one which is erroneous either in law or in facts. Aforesaid proposition of law continues to hold the field. Objection to execution of an award under 47 is not dependent or contingent upon filing a petition under 34 of the 96 Act. High Court is not justified in taking the view that since the appellant did not file a petition under 34, therefore it was precluded from filing an application before the executing court to declare the award as void and hence non-executable. This is going to the extent of declaring that the award itself is, because that is the question in this case. Then, Lord, may kindly see at para 72, my Lord, at the last 5 lines. Since the placitum G, since the award was passed without jurisdiction, same could be assailed in the proceeding under 47. View taken to the High Court because the appellant did not challenge the award under 34. Therefore, it was precluded from objecting
What
to.
are the limitations of the court for deciding an application under Section 47?
My Lord, that your Lordship will see under 47 itself.
No, here.
Yes.
69.
In this case, now what happened was.
No, in para 69 of the order,
Yes,
the
ma'am.
apex court.
Yes.
The law is well settled that at the stage of execution, an objection.
That is when you challenge the executability of the decree. Here, my Lord, what we are challenging is that the decree has been satisfied. Therefore, 47 encompasses two, three things, my Lord. One is as to the voidness of a decree. Like I'll give you lots of a classic example. My Lord. Once a company goes into IBC, your Lordships know moratorium steps in, and then an award, judgment cannot be passed. If a judgment is passed, I can, without filing an appeal, in execution, I can say it is void under 47. But 47 deals with 2, 3 things. One is as to whether it is satisfied. Suppose the decree is satisfied, whether, my Lord, it is an arbitral award or a decree otherwise, it, in my humble submission, makes no difference because it is a decree for the purpose of execution. What happened, my Lord, was in all the other high courts took a view, it is as if it were a decree, and therefore 47 does not apply because it is not in the suit. Supreme Court now clarifies that 47 objections can be raised, which goes to the root of the issue, whereby, my Lord, the entire decree itself can be effaced by virtue of an order. Therefore, if that is the extent to which a court can go under 47 to say that a decree is non-executable at all because it is a nullity in the eyes of law, a question, Lord, as to whether if I've paid the entire amount of money, I'm giving you lots of an extreme example. Suppose I paid the entire amount of money. They come and say, no, I'll still execute it because it was not paid into court, but I paid outside court. I say, but I paid it to you and you received the entire amount of money. You cannot execute the decree today. That is a question as to whether the decree is satisfied. Well, please see another judgment after this on the same question in MMTC, my Lord. Again on an arbitral award. Okay. Can I humbly request, my Lord, to kindly come to para 20. Starts at 15, my Lord. They of course look at this judgment as well.
Yes.
Para 20 is electro steel, which is referred to in answering the issue about maintainability of the objection under 47. Court held that the High Court is correct insofar as stated that plea of nullity qua an arbitral award can be raised in a proceeding under 47. But such a challenge would lie within a narrow compass. Court held that in terms of section 26, an award can be enforced, so and so. Then, my lord, para 69 of what I already read. Then, my lord, may kindly come to para 30, my lord.
Yes.
The objections only on maintainability, that is, it goes into merits as well because it was to go back after a significant. And then they entertain it on maintainability and examine it. The point, Lord, is this. The argument is section 47 itself does not apply in arbitration proceedings.
I think that's not the ground of the trial court.
Trial court does not go into it all. That's a ground raised by my learned friend for the first time here. Trial court, Lord, says, Lord, ultimately, what did I say? I said, Lord, that there is an agreement between the parties. The parties have come to an agreement insofar as the compensation that is to be payable under the award. And there are exchange of emails by virtue of which, Lord, it has come, parties have agreed. And that this is the amount that has to be paid. I have paid that entire amount of money. You must inquire into the question as to whether it is to be paid or not, or if the payment is satisfactory. You may come to a completely different conclusion, Lord. It is possible that the court may say that the payment is not a full satisfaction of the decree. But it has to take into consideration those facts and then answer the question. But please see the order.
Where do you get the order?
Can I humbly request my lord to kindly come? The order starts at page number 29.
Yes.
And Lord, the court, my lord, at points are at 33.
Right, 30?
33, my lord, page number 33, after examining this. The question framed is whether the facts declared in the affidavit gives rise to a cause of action for conducting the inquiry. The question is correct in my humble submission, because that is what has to be done to determine whether an inquiry is to be done. Decree holders have given some computation, which is 10 crore 46 lakhs. The award is silent with respect. I'm sorry, my lord has page 34.
Yes.
The award is silent with respect to payment of interest. Decree holders have paid interest at 18% per annum. Mr. Abu Bakr, the director of JDR, filed his affidavit in support of IA number 3. Relevant portion of his affidavit touching the matters and issues is extracted as follows. The affidavit note is extracted as to what has been said. Then, my lord, Srimati Banu Rahmatullah in the next para, I won't read all of that, has responded to the above paragraphs. Based on the email correspondence, JDRs herein have made certain submissions to the Honorable High Court on 11/9/23. Having heard the submissions, Honorable High Court in its order dated 11/9/23 made the following observations. We have heard the learned counsel of appellants. Learned counsel of appellants placed time stating he has entered into settlement with 3 of the defendants. Respondent number 1 before this court and would submit there is no question of him settling the issue. And he, along with his sister, respondent number 4, have no intention to work out any settlement with the appellants, and that they would submit that not a single penny has been paid to them despite the agreement in the award. On a query, learned counsel for appellant to submit that he would require 2 weeks' time to deposit the amount. We do not. I'm sorry. I hope I'm not reading ahead.
Yes.
Your lordship, sir.
I'm at this 14, 15 over.
Oh,
Yes.
I am a little slow, man. Sorry. Yes.
17. You can come to 17.
Yes. Arbitral tribunal is not expressly awarded interest. That's on interest. They said I'll deal with interest separately.
Court said you have not made out any point to here to consider on section 47.
On 47. That's
47.
the finding. Therefore, my lord, today the issue.
Let's come to your application under section 47.
Yes. Page 181 is my application. Honorable Court may be pleased to conduct an inquiry to determine whether the arbitral award dated 4/2/2014, which is sought to be executed, has been discharged or satisfied in full by the judgment debtor insofar as the payment of amounts awarded to decree holder under the award. The affidavit your lordship will kindly see.
Yes.
Para 7 onwards, if my lord see.
Yes.
These are all there. None of which is considered. But at least there should be a consideration of the documents and say, no, it is sufficient. I will therefore ignore those documents. None of that is considered. I have produced the emails. And your lordship may see the emails as well, which are there. Please see page 123 onwards, my lord.
We'll ask him.
Yes. The short response to that, my lord, is
So first of all, on the maintainability, in the light of the apex court judgment, it is maintainable.
my lord, on that, my lords, we will probably look into that matter further. But at first blush, my lords, it does seem to suggest that, my lords, Section 47 may have a limited role to play insofar as arbitration proceedings are concerned. But, my lord, that seems to be limited by the Honorable Supreme Court. Just give me the other. Two, my lords, paragraph 67, a case where the arbitral award is a nullity. Because, my lords, paragraph 67 says the High
Of the
Court
very same judgment?
of the very same judgment which my learned friend relied upon, my lords,
Is in
electro-steel.
Electro-steel?
Well, let's kindly see paragraph 67. The ratio, my lords, seems to be limited to this.
Yes.
The High Court is correct in answering the first issue that a plea of nullity, qua an arbitral award, can be raised in a proceeding under Section 47, but such a challenge would lie within a very narrow compass. And what is the narrow
That
compass?
is the facts of the case.
On the facts of the case. Now, my lords, kindly see.
Further.
Yes. Then, my lords, kindly see 69.
Yes.
Around 4 lines from the top of that paragraph. The law is well settled that at the stage of execution, an objection as to executability of the decree can be raised, but such objection is limited to the ground of jurisdictional infirmity or voidness. So, my lord, these are the two grounds. Insofar an arbitral award is concerned, either it must be jurisdictionally infirm or the arbitral award must be void. It is not, my lords, expanded to say that this is not, my lords, my learned friend's grievance is not that the arbitral award was passed without jurisdiction or that it is void. His contention, my lord, is that after the arbitral award, my lord, during the pendency of Section 37 proceedings, not even 34, Section 37 proceedings before this honorable court, the matters was settled. And since the matter was settled, my lord, accord and satisfaction, there is nothing to be enforced. That seems to be the tenor. My lord, that the honorable trial court, the commercial court has said, cannot be an argument, because if you had, that was your position, you would not have prosecuted the appeal. My lord, insofar as proceedings before the High Court was concerned.
No, but one aspect is that
yes,
whether Section 47 is applicable, and if it is applicable, what is the kind of exercise to be done by the court is one aspect.
Yes.
But the other is, they have raised so many grounds under
Yes.
Section 47.
Yes.
An application is filed.
Yes.
When you come to the order, the
Yes.
consideration is
It
not-
is, my
not-
lords, I take your lordships to the order, my lords, and I'll show, my lords, why the order is correct and brooks no interference. And in fact, my lords, what seems to be problematic is suppression of material facts by the petitioner, which has approached this honorable court. My lords, kindly come to the order first.
No, if you see, right from 2, 3,
yes,
4, then till only consideration of whatever the facts of,
yes,
whatever the arguments.
Yes. My lords, in
10
fact,
also the same.
yes.
Of
My lords,
about the
could I take
earlier
your lordships?
proceedings.
Yes, I'll take your lordships
Then
to the
you
order.
can come to para 11.
Yes.
From there, something it started with Section
Paragraph
47.
10 also, my lords, is actually very important because
Para?
it says, paragraph 10 of the impugned order, based on email correspondence, and their case is based purely on email correspondence, which, my lords, we also say is incomplete. I'll take your lordships to that. Based on the email correspondence, JDRs herein have made certain submissions before the Honorable High Court on 11/9. According to them, my lords, the settlement was reached in June and July of 2023. This, my lords, culminates in an order made by the court on 11/9/2023.
Yes.
Having heard the submissions, the Honorable High Court in its order dated 11/9/2023 made the following observations. We have heard counsel for the appellants, learned counsel for the appellants praised for time, stating that he has entered into a settlement with 3 of the 5 defendants. So not me, not my sister, with 3 out of the 5 parties. This is his submission made on 11/9 after relying on the same emails which have been placed before this honorable court. Respondent number 1 is before this court and would submit that there is no question of him settling the issue and that he, along with his sister respondent, have no intention to work out any settlement with the appellant, and they would submit that not a single penny has been paid to them despite the agreement and the award. On a query, learned counsel for the appellant would submit that he would require 2 weeks' time to deposit the amount. The amount is the admitted amount according to him. We do not see any justification for the appellant not having handed over the property in terms of the development agreement or paying the amounts due to the respondents. The development agreement is of the year 2006 and approximately 18 years have passed by without the respondents' landlords in a dime. Hearing is adjourned by a week to enable the appellants to demonstrate their bona fides of depositing, my lords, what is the admitted amount of the amount due to respondents number 1 and 4. Depositing the share. It is pertinent to note that had the matter been truly settled between the parties, the terms of settlement would have been placed before the Honorable High Court, and the Honorable High Court would have recorded the same by way of a compromise decree or award. Admittedly, no such compromise decree or award was drawn by the Honorable High Court. On merits, the Honorable High Court dismissed the petition filed under Section 37 of the Arbitration and Conciliation Act and confirmed the arbitral award. SLP preferred thereafter. So, Manoj, if there is no dispute, where is the question of continuing with the High Court proceedings? Where is the question of them filing an SLP? Section 47 then, Manoj, is discussed. Then kindly come to, Manoj, paragraph number 17. The arbitral tribunal has not expressly awarded interest on the award amount. The question as to whether the award holders are interested,
This is what I'm saying.
that is left open.
No. Where is the, according to them, they're not saying that they have compromised the matter before any court.
Yes.
According to them, in view of the settlement between the parties, they have made the payment.
Yes.
If that is the case, the court has to have some discussion on that, whether it can be considered or not considered, or it is beyond the scope of Section 47.
Yes.
All that is missing in the order.
But what is, Manoj, the approach that has been taken by the commercial court is, according to them, this is their case. Their case is that there was a settlement between the parties in June or July 2023. And therefore, the matter stands, the arbitral award stands effectively extinguished. This is their case. But what the commercial court says is, if this was really the case, that would have been recorded as a settlement before the High Court. But what is recorded as a settlement before the High Court is only a settlement between them and 3 out of 5.
I have also expressed the same thing the other day.
Yes.
No, what I'm saying is,
yes.
Section 47, no, as you, whether the court has jurisdiction, whether the court can decide an application.
Yes.
In the arbitral, in execution proceeding, Section 47 is applicable or not is first issue.
That is one question.
If at all, what is the
on facts? Was this
number
case?
Number three.
Yes.
All these aspects.
Yes.
Assuming that they are not done before the court.
Yes.
According to the party, he has paid the amount after the order of the High Court, and there is a settlement.
Yes.
In that regard, he is relying on something.
Yes.
So, on the merits of that, there need to be any order or not?
Malad, the issue is this, Malad. I see where the question that is being put to me. Malad, effectively, what that requires then the commercial court to do is to go behind the High Court order. Malad, I'll take your lordships to the High Court order, which is relevant. And Malad also then challenge, essentially question the proceedings before the Supreme Court also. Malad, that can't be done in a proper exercise of powers under Section 47. And the reason I say that is this, Malad. Now kindly see,
No,
the lordship has seen the order.
According to them, when did they pay the money?
Malad, they paid the money, what is the date? September 2023. Whereas after that, now kindly see the order of the Honorable High Court.
When was
And then September 23, they make the payment. Now kindly see the judgment of this Honorable Court in December 2023. They don't bring before the court the point, Malaj, that we have settled the matter, therefore there is no dispute with them. This is not what they say. In fact, the settlement is recorded, Malaj. What is the nature of the settlement that has been arrived at?
So according to them, during the pendency of the appeal before this court, they paid?
Yes, in September. So, Malaj, if the payment was in September, Malaj, then the judgment of the Honorable High Court would have been different in December. Now, Malaj, kindly see that judgment, Malaj, which is at Annexure G at page 137.
So the other day, yesterday, the other day when the matter came up, I read that order. Justice Narendra's orders in MFA.
No, that Justice Narendra's order, my lord, is the order directing us to deposit that
After
money.
that, where is
After
that was the dismissal of the
Section 37, page 137, my lord, Annexure G.
Yes.
Manoj, it starts at page 137. Manoj, could I take your lordship straight away to paragraph 11 at page 144? Initially, I'm so sorry. Manoj.
Yes.
Page 144, paragraph 11. Initially, all the claimants contested the matter. Pending these proceedings, claimant numbers 2, 3 and respondent numbers 1 to 3 filed joint memo dated 2/12/2023, duly signed by them and their counsel with the affidavit. Under the said memo, they claim that they have settled the matter with respondent numbers 1 and 3 as per the terms stated therein, and that the award so far as it related to them stood satisfied. That was opposed by counsel for claimant numbers 1 and 4. That is me, my lords, on the ground that such settlement in no way affects the rights of claimant number 1 and 4 under the award. So this is my position before the High Court. And that has been, my lords, adjudicated upon. Now kindly see.
Who are respondent numbers 1 and 3?
Me and my sister. So, my lord, the fact that there is no settlement with me was brought to the attention of this court.
Yes.
Respondent numbers 1 and 3, my lords, are the
Builder and his partnership.
builder and the partnership firm, my lords, which took over this thing. And my lord, the claimant numbers 1 and 4 are, my lords, me and my sister. My lords, so last line of paragraph 11, that was opposed by counsel for claimant numbers 1 and 4, that is me. Claimant numbers 1 and 4 is claimant before the arbitral tribunal. That is how it is referred to. Now, my lords, kindly see on this, paragraph 26. At page 154, my lord.
Yes.
So far as the, I'm so sorry.
For demolition.
Yes.
So far as the compromise entered into between respondent numbers 1 and 3 on one hand and claimant numbers 2, 3 and respondent number 2 on the other hand, at most if the award is put to execution, the said respondents cannot proceed against the present appellants for recovery of the amount so far as their commitments to lease out the share of the property to the appellant. But that agreement in no way binds claimant numbers 1 or 4 and 4 or their right to enforce the impugned award so far it relates to demolition, etc. While complying the award if portions of the property allegedly allotted to the share of claimant so and so have also to be demolished, that does not affect the award so far as it relates to claimant numbers 1 and 4. So, Manoj, this is in December. Matter doesn't end there. They file an SLP. Now, Manoj, kindly look at the SLP. Just two portions, Manoj, of the SLP I will show. And, Manoj, the fact that there are emails which have been suppressed, which show that there is no settlement which is within their knowledge.
Documents now, my lord, can't be produced. They were not produced before the trial court. It can't be just handed over like this.
Go to the,
No, kindly see the
SLP is all right. SLP is okay. But
kindly see the SLP, my lord. SLP starts, my lords, at page 6 of the memo, and kindly see what they say in paragraph 39. Page 39.
No, you have given the running pages.
Well, running page 76, my lord. I'm so sorry, there are two page numbers. My lord, the small page number is 76, the larger font is 39. So these are the grounds.
So no, I have to look at the larger font or the small font?
My lord, small font is 76.
76. This is the order of the.
No, my lord, this is the grounds urged by them in the SLP, and I'll show you, Lordship, the SLP order also.
Yes.
My lord, paragraph B, my lord.
Yes.
Because the impact of paragraph 26 of the judgment impugned herein would cause the settlement that the petitioners arrived with the third and fourth respondent to be rendered as a nullity, and thus the Honorable High Court has heard in holding that the settlement compromise would have no impact whatsoever on the award in respect of the demolition. Now kindly see the next page, grounds for interim relief. Because the petitioner has a very good case on merits, petitioner has already settled the matter, but with whom? With third, fourth and fifth respondent, not respondents number 1 and 2. This is his case before the Supreme Court. Filed in May 2025. And then, my lords, the SLP gets dismissed. That order that has been produced along with the repetition. So therefore, my lords, effectively what the commercial court said is, for me to go into all the grounds that you have raised, that there has in fact been settlement and accord and satisfaction, and therefore there is no executable award, would require me to go behind the order of the Section 37 court, this Honorable Court in its judgment of December 2023. And these are grounds that you've also raised in the SLP. And now it's just on one aspect, just to show the lack of clean hands. Well, the contention that was made was, we entered into a settlement in July 2023. Well, what has not been produced before this Honorable Court is, Manoj, kindly see of this memo, just 2 or 3 emails, Manoj.
Was it produced before the trial court?
This is placed before the trial court. This is nothing new.
It was not placed before the trial
No,
court.
please seek instructions. It was placed before the trial court.
Yes.
Let them seek instructions. I have no difficulty. But let me just point out, my lords, it can't be. And my lords, if these emails are false, then your lordships, of course, my lords, will impose consequences on me. Now, kindly see page 4.
I have to see them.
Of course, please see it, but kindly see page 4. You should have produced it also. That's our grievance.
Page 4 of your now the
of this memo.
Yes.
These are not referred to in the objections as well.
And my lords, kindly see page 5. This is an email sent in September. This is not produced. This is suppressed. September, where, my lords, I write to him, to his lawyer rather, saying that, dear Mr. So-and-so, reference your email of 12 September, please be informed that the negotiation regarding settlement of the long pending dispute has failed in view of the divisive and unfair conduct of so and so, regards so and so. And on that basis, my lords, he says, yes, out of 5 people, I have settled with 3 people. I have not settled with 2 people. That is his case before the High Court in section 37. That is also his case before the Supreme Court. And now, my lords, again, he tries to agitate this. And there's a reason why all this is happening. There is a very good commercial reason, my lords, and my learned friend's client is a very astute businessman. What did the arbitral award hold? My lords, this is a joint development agreement. I gave my land, he was supposed to construct it, and he was supposed to give me a share. Till today, the entire property is in his possession. I have not been given, my lords, my share of the property. And what has he done with it? He has rented it out. My lord, this is prime property, my lords, on Residency Road, right next to the Ritz-Carlton, from the time of the arbitral award, which was in 2024. And in fact, from 2014, he has been in possession of the premises. He's, my lords, making commercial use of it. He's rented it out. I don't get anything. The reason I don't get anything, my lord, is this: he had built more than what he was supposed to have built. The arbitral award tells him that you now have to demolish those portions which are beyond what was permitted by virtue of the sanction plan. Then once you've brought the building into compliance, you will then convey the share of the respondents to them. And therefore, for any delay in handing over this property to them, this is the compensation that you have to pay. So, my lords, he wants to delay this proceedings as much as possible, because every month of delay is every month of profit that accrues to him by virtue of rentals.
Demolished half the building. I'll make my submission. My learned friend is finished. Lord. First of all, not on section 47. On section 47, if your lordship, can you take 47 for a minute? I'm sure your lordship must have seen it several times. Why there are 2 parts to 47? It's not that it is limited to something. Supreme Court is only answering that first question.
Yes.
First, my lord, please see 47. All questions arising from the parties to the suit in which the decree was passed. That question is a question. I'm sorry.
The Arbitration Act.
No, sorry. CPC. We have gone beyond arbitration. Now we are in CPC. Section 47.
Please read.
All questions arising between the parties to the suit in which the decree was passed or their representatives. That is the first part of 47. That is where the question of nullity comes. The second part not comes, and relating to execution, discharge, or satisfaction of the decree. Now, the questions, my lord, which all other high courts answered was, which your lordship, which I think Justice Purnacha's judgment also, was on the question of whether you can backdoor challenge an arbitral award without challenging it under 34, or going through 34, losing there, then coming back to execution court and then challenging. They said you can't do it. There is a process
You
prescribed.
have passed on the judgment?
Yes,
Yes, last time his lordship.
Yes, we have. This is Purnacha's judgment.
This is Purnacha's
I'll
judgment.
just hand over another copy also.
That was earlier to our the Supreme
Yes,
Court judgment,
yeah.
and it was not even placed before it, because obviously it was earlier. It was 24 judgment. This is 25.
Yes.
Supreme Court judgment is 25. Therefore, all of them proceed on that basis. The question, my lord, please see the situation. If the argument of the other side is accepted, if I've paid the entire amount of money, I'll never be able to raise a challenge saying I've satisfied the decree in an execution proceeding and say I've paid the entire. I'm saying I'm taking the. I'm not paid in this case, but in a case, my lord, where I paid the entire amount of money, I can never tell the executing court I've paid the entire amount of money, because then the executing court will say I can't look at it. I will only look at the decree and then pass it directive to make payment again. Respectfully, my lord, that can never be the intention. If money has been paid and the money has been recorded, and in this case they admit it, it is not as if they don't admit the amount having been received, because in the execution petition they give a deduction to that amount of having received already.
Absolutely.
Where is that?
Please see the execution petition.
We have to, man. Whatever has been paid, whatever has been
Then-
received. But that's not the entire sum that we were entitled to.
That's true. I agree. That's your case. I'm today on the question as to whether the court should have answered.
Then, no, in that case, instead of filing an application under section 47, you can as well say, in the light of this, as per the this is the amount I have paid, and you pay the you place
No.
the calculation memo, they'll also place
No,
the
no, not that. The question of 47 is on the question of settlement and discharge. Please see 47, the second part of 47.
saying that they have accepted if a part payment.
No, no,
is made.
I'm only that. My case is that what has been paid is in full satisfaction. Their cases, it is not in full satisfaction. Therefore, it is not a question of calculation anymore. If it is a question of calculation, then it is only a question of saying how much more has to be paid. And that's all.
This is what, no, according to you, have paid the full amount.
Yes.
According to them, you are not paid.
Yes. But that question, Lord, is a question of satisfaction, whether the decree is satisfied or not. Lordship will see, my lord, if it is a, like
According to
yesterday,
you- No, according to
like
you.
yesterday's matter, my lord, where according to me, 147 crores, 140 was to be paid, according to them, 95. There it's only a question of calculation. There's no issue with respect to discharge. In this case, our case is the payment of the 2 crores and odd, which I've already made, is in satisfaction of the decree. Therefore, my lord, my case is different.
What is that they admit?
They are saying that is not satisfaction.
No, they admit this 2 crores?
Yes, they admit. Please see the exhibit.
We've adjusted that. We've adjusted that.
One minute. 167,
The 2 crores paid.
that was paid in the High Court.
Yes.
That was paid in the High Court.
In September 2023.
Yes, that is the payment made in the High Court. Please see 167. No?
On the face of it, if that is made towards a settlement, you would have brought it to the notice of the court.
No, it's a question of what happened was in case of all the other three sisters, we may not enter into a joint memo, place it before the court and closed it. In their case, not they reneged on their commitment. And I want to show you lots of those emails because now my learned friend shows you lots of one email and says, oh, look at this email. I've written this email to them.
Let us not go into any of the emails. Now, according to you, this entire amount and settlement is
yes
when the matter is pending before the court.
Pending before court.
If that is the case, if there is a settlement,
Yes.
you would have at least stated
No.
before the court.
Yes, yes. I could have stated, I stated it before the court. They denied it. But the question at the stage of a 37 proceeding, my lord, in a 37 proceeding, the court cannot go into the question of whether there is a satisfaction of the claims monetary in nature. There were two parts. One is for demolition of the building. The other part is satisfaction of the decree insofar as money is concerned. I had, my lord, a situation where I had also to challenge the award.
All these issues in the appeal and before the
Yes.
Supreme Court, all these issues, consistently, this is your stand.
No.
And there is a finding that there is no settlement
No,
between.
no. There's no finding on whether there's a settlement between us. The finding is there's a settlement between the other three sisters. The finding of settlement, my lord, and the conclusion that the court has arrived at is that a settlement recorded in court and the amount of money which he had said had to be paid to them has been paid in this case, which is why I only take 1 minute of your lordship's time. Please see the emails for a minute.
So virtually, you want the court to decide something which was not recorded by any of the courts.
Absolutely.
During the pendency of the proceedings.
100%.
And
I agree.
Which has already taken note of the fact by both the courts, both
No,
the
no.
division bench and the, no, when you say there is a settlement, they have stated before the court that there is no settlement. And that is.
Court did not answer that question as to whether there is a settlement or there is no settlement is not an answer given by the
And
court.
what is happening from 2023 to 2026?
My lord, then the matter was heard, disposed of. Then they filed the execution petition.
When was the execution filed?
May 2025.
May 25 is the execution
When is
petition.
this application filed?
In 2026. In 26, my lord. We filed. They were of course arguing it.
You are contesting from when?
I'm contesting right from the beginning.
No, your notice is served and from.
After
May
notice
you
was
are-
served on us,
or before the court.
then we appeared before the court, filed the application, and the application was heard over a period of time. And then, Lord,
No, immediately you have not filed. You have filed in 2026.
in 26, yeah, filed in 26.
Before that, what was?
Before that, I think, my lord, some objections were filed.
Objections were filed?
Yes.
Objections
What
were
were
filed.
those objections in 2025?
Filed by them, Melons. They
Where
have
are
said,
they?
Melons, that they have in fact paid, etc., etc.
They've-
I'll take a
They've
look.
taken, I've not filed the objections before your lordships, but I filed the application and the objections to the application. But if your lordship see the emails, my lord, it'll give your lordship a completely different picture.
Have the copy of that objection?
I do, only in soft copy, Melon.
Let's see.
Unfortunately, I don't have a copy because I was not there in the trial court, in the commercial court. I don't know what objections have been taken. Do you have a copy of objections?
Well, I just hand it over, Melon.
Would your lordship, or till then, may I just request? Sorry, I'm taking too much time. Page 123.
Yes, 123.
3. This is, my lord, from the respondent number 1.
Yes.
To us, thanks for spending time today. I believe we arrived at a constructive solution.
This is on 4/2/2023.
23 itself. I spoke with the concerned family members, and in the spirit of moving forward, Faizi, Foizia, and I agree with the terms you offered of 9 crores by way of compensation for the entire family and a rate of 17,000 square feet for any of the family members that wish to sell. Faizi and I have agreed to sell at the aforementioned price per square foot. We need to run tax implications. Then, last paragraph, for sake of clarity, we would expect full payment of both compensation and sale value to be made on signing. And of course, all of the above subject to mutually acceptable legal documentation. I hope this is agreeable to you. Please confirm your agreement as well. Then, on the next page, There are some issues which they point out. Then, my lord, he says, third paragraph, a compensation amount of 9 crores for family area of 17,180 per square feet is equal to so and so. Therefore, the total consideration per square feet should be so and so. Please clarify urgently and enable me to review and process the text of the draft sale deeds. Then you also will see 125 at third paragraph. To elaborate further, the compensation of 9 crores will be divided into 7 equal shares, of which the male member will get 2 crore 57 lakhs and the female member will get 1 crore 28 lakhs. Similar in respect to sale, the total amount works to so and so. Therefore, that is also accepted. Then, my lord, please see at page 126. He then again writes, we are on the same page regarding determination of family and individual entitlements. You are right, if we go by the area as per MOU and the agreed price of 17,000 so and so, Firdaus and Fazile would get less, which I had overlooked and would never want. Hence, the MOU would not be taken into consideration. Consolidated consideration which should be paid now in the sale deed is as follows. Naim is 8 crore 59 plus 257. Fazile is 429 plus 128. Firdaus is so and so plus 128. Therefore, my lord, he was entitled to 2 crores 57 lakhs, which is the amount deposited in court. Therefore, my lord, yeah, all I'm saying is, maybe I'm right, maybe I'm wrong, but it can't be a rejection as simplistic as what they have done. The court, my lord, could never have rejected my application in such a simplistic fashion. It was an agreement. You may say at the end of it, after looking at the emails that he has produced and I've produced, that maybe I'm wrong. Maybe the agreement came to an end because, my lord, in my humble submission, once there is an offer and an acceptance, a contract is concluded and an agreement has come into effect. The question of then reneging on it is a different issue. You go back on it. That, my lord, is a question which has to be answered. Without an answer to the question in my respectful submission, the court could not have rejected it in a simplistic fashion.
Well, we'll file a hard copy. Could you
Speak to the court of.
Yes, please.
Heard reserve.
I'm grateful.
Number 9,
Deeply blessed. Good.
Swami NBN for petitioner. Ken Nanja Reddy for respondent.
If there are any other judgments on section 47, Manoj, we
Please.
haven't had a chance to look into it, but Manoj, we would place it on record. Deeply blessed. Deeply.
This is another joint development agreement. The
What is the suit for?
suit for damages has been filed and also an injunction.
What is IA?
IA, I have said, the execution petition is premature. Where the damages comes in, he cannot enforce it in view of the other judgment. The relevant portion
Please
is that
come to the order so that I'll understand the facts. and
it's
the
better your lordship comes to 113, my lord. That is the other order.
No, first we'll read this order.
Okay. Annexure K, my lord. Learned advocate for the decree holder has filed an application under order 21 rule 54 of the Code of Civil Procedure to pass an order of attachment and immovable property of the judgment debtor as prayed in the application. Particulars of the immovable property intending to be attached are explained under A and B schedules of the application. In the affidavit filed in the support of the said IA, decree holder K. Ravichandra Reddy submitted that he filed commercial OS number so and so against the judgment debtors seeking damages of rupees 2 crores, together with costs and interest and other consequential reliefs. The said suit came to be decreed with costs. This court directed that judgment debtors jointly and severally liable to pay 2 crores along with interest at the rate of 18% per annum as damages from the date of investment till realization of decreed amount. Now the total amount payable by the judgment attached to the decree holder is 6 crores and odd. It is further submitted that the properties described under Schedule A and Schedule B are joint family properties of the judgment debtors. Schedule A property is owned by the judgment debtors 1, whereas Schedule B is owned by judgment debtors number 2. They have acquired these properties under the registered partition deed dated 23/5/2007. It is further submitted that judgment debtors have not preferred any appeal on the judgment and decree passed by this court within 90 days from the date of judgment dated 30/8/25. Judgment debtors are not making payment to the decree holder under the execution petition. Hence, attachment of the scheduled properties situated within the jurisdiction of this court is utmost necessary. In the event of order of attachment of immovable properties of the judgment debtors are not ordered, he will be put to untold hardship and difficulties. For the said reasons, it is prayed to allow the application. In support of the said application, decree holder produced copy of the partition deed, Kata extract of the Schedule A and B properties. Now on the application duly served upon the judgment debtors, judgment debtors number 6 to 9, that is the petitioner's herein, have appeared through counsel, produced memo with a copy of the judgment and decree passed in commercial OS 98 of 21, connected with OS number 187 of 2002, dated 29/8/25. It is orally submitted that the judgment decree passed by this court is a conditional order, unless the decree holder execute the deed of cancellation or.
I've seen it.
Yes.
Yes. Hmm.
So long as the OS number 98 of 2001 and commercial OS number 187 of 2002 is pending, he has taken an injunction to, that is at 113, my lord, page 113.
Well, this order has not been challenged.
Hmm?
This order just now they are
This execution, yes, it's
Yes.
an independent,
pending.
No, that is why I'm coming to 113, man.
no, a suit is decreed, execution petition is filed, no appeal against the.
Then what is the
judgment
subject matter of the property?
Appeal is filed and it's pending, my lord.
Yeah.
Now they are not prosecuting that.
Here,
Unless and
113 may be gone into, my lord. The suit filed, this is a suit filed by the developer itself.
Hmm.
The suit filed in commercial OS number 98 of 21
This is an interlocutory application.
no, final order. This is the final order. Permanent injunctions granted,
Injunctions.
restraining the defendants, Chikana and others, that is the petitioners, or anybody acting on their behalf, interfering the
That
execution.
is an injunction restraining from
Interfering with the execution of construction work.
Construction work.
So if this construction work, it's his own undertaking that he will do the construction work. If this property is sold, this judgment washes away.
No, court has not said so.
No.
Court said till the property, till the.
Yes, until
execution,
payment of the compensation, this will be there.
It will be attached.
Yes.
It will be under
So
attachment.
long as attachment is there, I'm not,
That is the order.
no grievance. But further, they have sold it. They've gone and sold it. If it is sold, what happens, my lord?
Prohibited from transferring or creating charge over the property. That is the order, operative portion of the order.
That is the operation. Page 142, my lord. Now the property has come for sale.
No, it is 162 I'm reading.
Page 142, my lord. The same property
No, what is the order impugned now?
that the execution could not have been filed.
They have
If that
challenged
execution is filed and sold,
No, have you questioned the order, the operative portion at 161? That is
Yes,
what
ma'am.
is questioned before this
yes,
court? Yes, so what that order says is, as far as this order is concerned, it only says attachment.
then my objections have not been considered. My objections have not been considered.
Now, if the property is attached, what is your difficulty? It's attached by the
I
court.
have no grievance if it stops there. But if
has
it is
to stop
sold,
there.
no, it has not stopped.
That is in violation of the orders of the court.
Beg your pardon?
That is in violation of the orders of the court. As far as this order is concerned, court has only asked them to, said that nobody should transfer it and accordingly attached it.
Attached. But going one step further is the question, my lord. They've ordered to sell it
Then you have to go, you have to bring.
in
it
this,
to-
in this petition only. Execution petition. Page 142, my lord.
That is not challenging.
That is not,
No.
we are only concerned with the impugned order.
Yes.
Yes, my lord. If that,
Impugned order is pertaining to the attachment. The court has not given them any permission to sell the property. If they're doing something, that
Yeah.
is for you to bring it to the notice of the trial court, the executing court.
I have brought it to the notice. That is why it has not been considered. Only page, para 11, if the impugned order is looked into, para 11, it is not, my objections are not considered at all. Records reveal that Schedule A and B properties stand in the names of JDR. Absolutely, there is no force in the objections raised by the judgment debtors. This court is of the considered opinion that in view of the strict directions of the Honorable Supreme Court of India to dispose of the execution petition within 6 months, they say only for 6 months. My objections, what happened to my objections? My objections are not considered because the connected decree is there. He has to execute the joint development agreement according to his own undertaking, and that property is sold. If that is sold,
What happens to the decree? Decree is again washed off.
I'm not able to understand this connection, what you're trying to project. As far as we are only concerned with this order.
Yes, my lord.
This
Then
order,
my objections may be.
This order does not permit them to sell the property. Beyond this order, if they're doing something, then the court.
That is that liberty may be given, my lord,
Yes.
if that is the case.
Yes, please come. The petitioner is before this court, agreed with the orders passed in I number 1 in commercial execution petition number 42 of 20.
That is not challenged, my lord, before.
I am not saying
Yeah.
anything. I said I'll record his contention and say, if you have any grievance, bring it to the notice of the court.
Not,
Like a commercial execution petition number 42 of 2025, dated 12th of March 2026 by the 11th Additional District and Session Judge, Bangalore Rural District. The respondent herein has filed an IA before the executing court under Order 21 Rule 54 of the Code of CPC to pass an order of attachment of immovable property of the judgment debtor as framed in the application. The executing court by order impugned had passed an order allowing the application, and the court has observed that judgment debtor number 1, their agents, administrators, assignees, or any person claiming through them are hereby prohibited from transferring or creating charge over the Schedule A property till realization of the decretal amount passed in the commercial OS 171 of 2022 by way of granting an order of attachment of the property bearing survey number 52 of /1 measuring 17 guntas situated at Belturu village, Bizrahalli, Hopi, Bangalore, East Taluk. Judgment number 2, judgment JDR number 2, their agents, administrators, assigned, or any person claiming to them are prohibited from transferring or creating charge over the property till realization of the decretal amount. The agreed thereby, the judgment debtor is before this court. Land counsel appearing for the petitioner submits that he has filed the objections and that the same were not considered. It is submitted that now, in the light of the orders passed in another suit, they have to complete the construction. And after completing and if they sell the property, it is submitted that now they're going to sell the property, and he has placed some document before the court in support of the same. It is submitted that without considering his objection, this order is passed, and now they're going to sell the property, and it caused a lot of hardship to the judgment debtor. These aspects were not considered by the trial court. Then counsel appearing for the degree holder submits that the petitioner, what is questioned before this court is the order impugned, and the other contentions cannot be considered by this court. It is submitted that the court has rightly considered and passed orders, and no interference is called for with the well-considered order passed by the court. Next, having heard the counsel's 20%, there is a material non-record. By order impugned, the court has passed an order of attachment restraining the defendant, the judgment debtor 1 and 2, from alienating or creating any third-party rights. As far as this order is concerned, this court do not find any reasons to interfere. However, it is a submission of the land council that now the properties are going to be sold. That is not the subject matter of this petition. If a subsistence of an attachment order, if the parties are selling the properties, it is for the petitioner to bring it to the notice of the court and seek appropriate relief. As far as the impugned order is concerned, this court do not find any reasons to interfere. Accordingly, dismissed.
Still number 10, PD Surana for petitioner H.V. Devaraj.
There is a dispute amongst the family members. I am running a business of manufacture and sale of ice cubes in the property. The power connection is opened.
Matter has come up before, this ice cubes or
Yesterday.
you only argue.
No, it did not reach.
No. Some other matter. The other day, with regard to some, the tenant has saying that this ice cubes business, tenant, I have passed an interim order in that. You only appear. or rather have appeared. I said not to till they were seeking some time. As
Not
I
in
have
pertaining to
given,
this, this is a dispute among the father and son, where that suits are pending. That the
Kindly-
installation stands in the name of the father.
Hmm.
That he gives a representation to reduce the contract demand from 190
So that I
kVA
can
to
share.
40 kVA.
So that the business
That
can be closed.
petitioner has filed an objection that yet to
the
be
petition is the son.
son. He has filed objection to that not to reduce the contract demand. That yet to be considered. Not yet considered. My submission is
Like
that
if the
writ petition
contract is
premature.
reduced,
No, let's come to the prayer.
not to reduce the contract.
Contract demand.
Not to downsize the power supply.
Power
To
supply.
the scheduled property. Who is in possession of the property?
I am in possession of property, I am running the business. Kindly turn to, my lord may kindly turn to page
One
45.
minute. What is the procedure and what are the rules you are governed by?
No, the
But
government
if
by
they
the
downsize
rules-
it, what happens is if I consume more power than what is fixed, I have to pay the penal charges.
We'll ask
that
him, what are
reduction of the contract demand, that if the consumer don't want power that sanction load, he requires to submit an application
That you have to
and fresh
consider.
agreement, all that material has to place it on record. Here, the interstate dispute is concerned.
No, in the light of the interstate disputes and the suits pending between the parties, in those circumstances, what should be the
The decision has
action?
not been taken. It has not been reduced. That they have given application, he has filed an objection, not yet taken any decision.
I'm asking you, what would be the procedure?
That these
The
circumstances,
When the disputes are pending between the parties and in that civil suits are
at
already
the sometime that we will not take any action on account of the dispute pending before the court.
because that is
Yes, yes,
that is the
that
way
it is
that
among the
the-
civil disputes among the parties.
Kindly see 47.
No,
Annex
what we
D is the
What we do
representation.
is, you have submitted your representation to them.
Yes.
And the owner has your father, in whose name the.
Consumer has
stands.
submitted application
Consumer
for
has
reduction.
already submitted the application.
That is the.
No, they have to pass
May
the
make a
order.
submission. May make a submission. Kindly turn to page 45.
Yes.
This was MFA filed by me.
Hmm.
Kindly turn to page 47.
Yes.
Para 3. Therefore, placing the memo on record, the appeal is disposed of by directing the respondent not to dispose.
That's your father.
Yes.
So the same
Now,
thing.
now
The same
they
thing.
gave an undertaking that they will not interfere with business.
That's what.
Now, therefore, let the KB also aid with the order. Let them, if they reduce the power supply, I will be penalized. I will have to close the business.
That is what I'm saying. Now you have given a representation. You have stated about all these orders and all. Now he has given his representation, your father. They will consider and pass orders. Till such time they will not do it. We'll ask them, because in the light of these orders, I'll record your contention. It's for them to pass an order.
Like in the event, if it is reduced without notice to me,
Why they will, that is what I'll say. They can't do it.
that's the.
Let there be an
Without
observation.
it may be posted.
Observation, give an opportunity to both that consideration of the
The
representation. Both
petition is
parties.
filed. Sing the
But
following.
they can't
prayer.
reduce it. That is my prayer. In the light of the undertaking given to the court in MFA,
No, that is what he also wants to say. The writ petition is filed. Sing the following prayer. There are.
virtually it amounts to.
You
dispossessing.
didn't make the father a party to this.
Here not.
I have
made a
not
point.
made a point.
You should have, when you're saying that there are disputes between me and the father and the whole reason is.
So far as this dispute is concerned, it is with regard to KB only. Therefore, it may be required.
In this.
You filed this order.
The installation
When
stands in
you're
his name.
referring an order of this between you and him is a necessary party. The writ petition is filed. Sing the following prayer. The petitioner and his father are having civil disputes pending between them. And it is a case that the father of the petitioner has gave a representation to the respondents to downsize the power supply from 190 kVA to 40 kVA. It is submitted that when the petitioner is in possession of the property and when the disputes are there between the parties, and in fact, in MFA number 9329 of 2025, the court has disposed of the MFA directing the respondent, that is the father of the petitioner, not to dispossess and interfere with the business of the petitioner on the Schedule A property. And if any disposition of by the respondent, that shall be only with due process of law by a competent court of law. In the light of the undertaking, it is submitted that the respondents cannot consider the request of the father and they cannot downsize the power supply. It is submitted that if the power supply, if they reduce the power supply, that will cause a lot of hardship to the petitioner. Next, land council appearing for the Mr. Devraju, who appears on behalf of respondents number 1 and 2, submits that the father, who is the consumer, has given a application, as a representation.
And as per annexure D.
As per annexure D, dated?
That the dated not that 24/6/2026.
24/6/2026.
That the petitioners have filed objections 25/6/2026.
25/6/2026, the petitioners have filed their objections. It is submitted that so far they have not taken any decision. They have not passed any order. The writ petition that is filed is a premature writ petition. It is also submitted that without passing any orders, they will not take, without considering the objection, considering the case of both the parties, and without passing an order, they will not take any action. Next, having other counsels on either side, President will not record. Undisputedly, it is according to the petitioner, and as per both the petitioner and the respondent, there are disputes pending between the petitioner and the father is the consumer. Petitioner is in possession of the property. In the light of the said disputes, when the father has given a representation, they've called for, you have issued a notice to him.
No, we are not issued. They themselves
When
file
the
objection.
father has given a representation to that. Already the petitioner herein has filed his, placed his reply to the same. Now the respondents are yet to pass order at this juncture. And when it is submitted before the court that unless an order is passed, they will not reduce the
Power supply.
Contract demand. Reduce the contract demand.
they will not reduce the power supply from 190 kVA to 40 kVA. This court is not inclined to go into any of the merits of the matter, and accordingly passing the following order. The writ petition is disposed of, directing the respondent not to reduce the power supply from 190 kVA to 40 kVA without passing any orders on the representation of the consumer and considering the reply and the.
In the light of the order made by the MFA.
And the
let them not take
representation
the decision,
given
give
by
the
the
disposal of suits.
representation given by the petitioner, and also consider the light of and the orders passed in MFA number 9329 of 2025.
Yes.
Before passing any order, a reasonable opportunity shall be given to both the parties accordingly disposed of.
Item number 11, Shoshankar Singh petitioner, B.C. Sitaram Rao, Aviator.
Lord, I am for the aviator respondent, my lord.
Lord, this is the matter where, Lord, a suit for declaration has been filed in respect of 4 acres of land. Indisputably, my lord, even in that court fee, and that is the prayer. If your lordships were to see the prayer also, it is my dear.
What is this IA?
Lord, IA was filed under, my lord, order 11 of the Karnataka Court Fees and Suit Valuation Act, where, my lord, then they'll have to pay on the market value. Now, this, what they do in the suit, they, my lord, show it as agricultural land.
We'll take it up tomorrow.
Beg your pardon?
From the morning,
Lord,
all
it is very simple, my lord.
the parties
IA
are.
has been-
I understand, my lord, your lordships have.
It is like a
been-
final hearing.
I know. No, my lord, this is a very simple thing, my lord, because this
It
is.
is a very simple thing for dismissal of the writ.
The only issue here is.
No, I'll take it up tomorrow. This matter tomorrow. All from morning, all this caveat where now I have to finally dispose of the matters. I have to complete the list is like running into 80 or 100.
I understand, my lord, your lordships are heavily burdened and I do understand.
I'll take it tomorrow.
Please,
List is marked tomorrow in the first list. Yes,
10 more courts.
on the top of the,
yes.
Shortage of courts. We want 10 more courts, otherwise it is difficult to.
I've
answer the
already
litigants.
informed the Honorable Chief Justice. It is very difficult with one court dealing with all the matters.
we understand.
Cell number 12.
Appear for
Yashoda
respondent.
Reddy.
For the petitioner minutes in this, minutes an application seeking to adduce additional evidence.
Same thing to you also. We'll take up all this wherever these caveats are there.
I
we'll
understand.
take-
My only
but-
difficulty, my lords, is the trial court is taking the matter up on a daily basis of final arguments.
There
But
is a
there is still
direction
some
from the
time tomorrow,
court.
please. Science.
Bill 13,
34
14,
petition.
14 and 15 tomorrow.
Please.
13 minor.
That's 13. All tomorrow.
Tomorrow, all these
Cell
matters
number
will come
16
tomorrow.
for admission matter. Cell number 16.
For petitioner.
Jagan Mohan HT.
Day after tomorrow. 14 day after tomorrow in the first, all the matters in the first list, whether I say or not, say in the first list. It's 14 day after tomorrow in the first list. 13 day after tomorrow, 13 tomorrow, or day after tomorrow.
13.
Well, tomorrow, 13,
My lord, 15 day after tomorrow, my lord.
15, my lord, the trial court has posted the matter for
Uh-huh.
judgment. 15, trial court has posted the matter for judgment. That is the reason I will have it tomorrow.
tomorrow, 15 tomorrow, 13 also tomorrow.
Much obliged.
No, I'm not raising. I'm only said only this, where there is a caveat and, yes, 15, 16.
Cell number 16.
Lord,
Jagan Mohan.
for petitioner.
Hmm.
Petitioner here challenging the orders dated 9/10/2025, page number 7, my lord, implement order. In a suit for partition filed by respondent's father. This petitioner filed application under order 7 rule 11D because there is no specific reading of cause of action and also is barred by limitation. That was rejected by trial court, my lord. According to petitioner,
Come to your application. Where is the IA that is filed in support of this?
page number 35, my lord. 30, page number 30, my lord.
Office has not even taken objection for this paper to file a
Yes,
typed
that is
copy.
in manuscript.
How can I read it? You please read it.
That for the reasons stated in the accompanying of, I'm reading the application at page number 30.
I'm looking at 31. I want you to read the affidavit.
Oh, my lord.
From this affidavit, please tell what is the ground.
Lord, because according to petitioner, the respondent, there is a property belongs to come to page number 18, pleadings of the para
We
number.
are not concerned with we are concerned with your affidavit. What is the reason why the plaintiff has to be rejected?
No, that is because there is no, there is already partition took place between the petitioner and respondent's father.
That is whose case? Your case or the plaintiff's case?
That is my case.
Your
That's-
case cannot be considered.
That
From
one
the
thing.
plaintiff's case, you have to make
Lord,
out a case.
The cause of action arisen in 2013, according to them, according to respondent himself. But suit filed in 2022. So that is barred by limitation. That we have taken the 2 grounds in the application.
Come to the order.
Reasons are page number 11.
Same mixed question of fact and law.
Yes, there is the finding of trial court because it makes mixing of facts and law. That is rejected. But according to them, cause of action is in 2013. Finally, see the plaintiff, para number 3 of the plaintiff, on page number 18, million. They have not specifically pleaded any cause of action. Without pleading the specific cause of action,
Come to the
suit is,
plaintiff.
suit is not maintainable.
Let's see the plaintiff.
Para number 3,
The cause of action for the suit arose on the first week of January 2022.
22.
When the defendant had denied the right and share of the plaintiff in the
No, my
property.
lord, according to them, there is a property belonged to their mother. Mother died in 2013. So cause of action arises immediately after death of their mother.
Please come. The present petition is filed, agreed by an order passed by the trial court in I number 7, NOS number 18 of 2022, dated 9th October 2025, by the second edition senior civil judge JMFC Chitradurga. The petition before this court is the defendant in the suit. Respondent herein has filed a suit for partition. In that, an IA came to be filed and order 7 to 11 seeking the rejection of the plaint. It is a specific case of the petitioner that, according to them, the mother died in the year 2013 and the suit is filed in the year 2022, and the suit is barred by limitation. Further, the suit does not, and further, there was an earlier partition, and as such, there was no cause of action to file the suit. The trial court, by order impugned, has rejected the IA. The court has observed that the law of the aspect of limitation is a question of fact and law, and on that the court cannot reject the plaint at the threshold. It is submitted that it is that is observed by the court that, according to them, the cause of action arose in the year 2022, and from looking at the facts of the case, the petitioner could make out the plaintiff could make out a cause of action, and the suit cannot be rejected on the ground of limitation, as that can only be decided during the course of trial. Land counsel for the petitioner submits that when the mother died in 2013, then only the cause of action arose. Now they cannot file the suit and it's barred by limitation. On the face of it, when the court can make out, it cannot be necessarily. It is not a question of fact and law in every case, and the defendant could demonstrate before the court that it is barred by limitation. Next, having other counsels on either side, there is a material on record. This court has seen the plaint. In the plaint, it is stated that in the year 2022, when they have pleaded when they have asked for the partition, when they denied it, their cause of action arose. So, on a plain reading of the plaint, the cause of action discloses if according to the defendant, there was an earlier partition that is not mentioned in the pleading in the plaint. Hence, the court cannot consider the same. Whether the cause of action arose in 2013 or whether it is in the year 2022, it's a matter of trial, and the court cannot decide the same at the stage of filing, considering an application in order 7 to 11. Hence, this court finds no reasons to interfere. Dismiss. Next.
Number 17, KG Sadashivaya.
The last occasion, I have been directed to produce the plaint, the supplications and other. I'm producing.
We'll continue after lunch. Please.
Please.
It's only one.
Madam, list number 2, serial number 29.
ಹೇಳಿ ಸರ್.
ಅದು ರೀಚ್ ಆಗಲ್ಲ ಟೈಮ್ ಕೊಡಿ ಮೇಡಮ್.
ಯಾವಾಗ?
ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಆಗಸ್ಟ್.
ಅಲ್ಲ ಸರ್, ನಾವ್ ಇವಾಗ ಕೊಡಕ್ಕಾಗುತ್ತೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆದ್ರೆ ಅದೆಲ್ಲ ಲಿಸ್ಟ್ ಮೇಡಮ್ ಹತ್ರ ಹೋಗಿ ಫೈನಲೈಸ್ ಆಗೋದಿಲ್ಲ ಎಂಡಿಗೆ. ಅದು ಅಲ್ಲಿ ಹೋಗಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬೇಕು. ಮೇಡಮ್ ಯಾವ ಡೇಟ್ಸ್ ಅವರೇ ಅಸೈನ್ ಮಾಡ್ತಾರೆ. ಹಾ, ನೆಕ್ಸ್ಟ್ ಒನ್ ಸೇಲ್ ನಂಬರ್ 14 ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದು ನಾಡಿದ್ದಕ್ಕೆ ಸರ್. 2:30 ಎರಡಿದೆ, ಕೇಳ್ತಾರೆ ನೋಡ್ಬೇಕು. ಹಾ, 2:30 ಎರಡಿದೆ ಸರ್. ಕೇಳಿ ಬಂದಾದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ ಅವ್ರೆ. ಲಿಸ್ಟ್ 12 ಸರ್. ಅದು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ಸ್ ಅಸೈನ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್. ಸಮ್ ಡೇಟ್ ವಿಲ್ ಬಿ ಅಸೈನ್ ಫಾರ್ ದಟ್. ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ ಮೇಡಮ್. ಆ ಡೇಟ್ ಅದಕ್ಕೆ ಬರುತ್ತೆ.
ಲಿಸ್ಟ್ 2 ತಗೋತಾರಾ ಮಧ್ಯಾಹ್ನ?
ಸರ್, ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 2 ಹೋಗೋದು ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ. ಲಿಸ್ಟ್ 2 ತಗೋತಾರ ಅಂದ್ರೆ ರೀಚ್ ಆದ್ರೆ ತಗೋತಾರೆ.
ಲಿಸ್ಟ್ 1 ಆಗಲ್ಲ.
ಸರ್ ಹಾ ಅಲ್ಲ ಸರ್ ಇವಾಗಲೇ ಪ್ರೊಸೀಡಿಂಗ್ಸೇ ಕಂಪ್ಲೀಟ್ ಆಗ್ದಲ್ಲ ಯು ಆರ್ ಸೀಕಿಂಗ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಸರ್ ಅದು ಸಂಜೆಗೆ ಅದು ಫೈನಲೈಸ್ ಆಗೋದು ಮೇಡಮ್ ಹತ್ರ ನಾನು ಲಿಸ್ಟ್ ತಗೊಂಡು ಹೋಗಿ ಆ ಡೇಟ್ ಗಿವನ್ ಲಿಸ್ಟು ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ಮೇಲೆ ಡೇಟ್ಸ್ ವಿಲ್ ಬಿ ಅಸೈನ್ಡ್. ಈಗನೇ ನಾವು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ನಿಮ್ಗೆ ಹಂಗ್ ಬೇಕಿತ್ತು ಅಂತಂದ್ರೆ ಮೇಡಮ್ ಹತ್ರ ಕೇಳ್ಕೋಬೇಕಾಗಿತ್ತು ನೀವು. ಆದ್ರೆ ಸರ್ ರೀಚ್ ಆಗ್ದಲ್ಲ ಇದ್ರೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಇರುತ್ತೆ ಬಿಡಿ, ಇನ್ಯಾವತ್ತೋ ಒಂದಿನ ರೀಚ್ ಆಗುತ್ತೆ. ರೆಕಾರ್ಡ್ ಲಿಸ್ಟೇ ಆಗ್ತಿಲ್ಲ, ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ರೀಚ್ ಆಗ್ದಲ್ಲ ಇದ್ರೆ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ, ಡೇಟ್ಸ್ ಕೊಡ್ತೀವಿ.
Call the rest. No, 2:30 today. Call the rest.
My lords, kind permission, my lords.
Serial number list 1, serial 17.
Memo moved, date given for tomorrow.
Give the file.
Being a 14%, date given for tomorrow, but 14% committee is not sitting for a week. Hence,
How many times you'll make a mention at 2:30? Yesterday I said you shouldn't make a mention at 2:30. And why you are making again?
morning I came, my lord, I was not knowing that the committee is not sitting. So now only I came to know because it's posted for tomorrow, the date given for tomorrow only. So if it is, direction is not given to board, so they don't list for tomorrow. So there is urgency because of a life threat, my lord. I'm being a foreigner, I'm facing.
I already yesterday I've seen, I've given a date.
Yes, ma'am.
And accordingly it will come. No further directions to the board are not required.
Scrutiny branch, direct.
That all that is not the problem of the court. Yes, call the matter.
Serial number 17, KG Sadashivaya.
Please, madam. With the leave of. Get the permission in the open court only.
Yes, call the.
With the leave of the court.
17, KG
Yes.
Sadashivaya.
I am permitted to file the pleadings, my lord. The application was not submitted to the court.
Yes. What is the
My
suit
lord,
for?
the fact, suit for bare injunction, my lord. Having purchased the property on 3 sale deeds by the petitioners.
Suit for?
Suit for bare injunction.
Hmm.
This was not, this is by the other side. Respondent has filed a suit for bare injunction. I purchased the property on 3 sale deeds, and my lord, I am in possession of the property, and all the revenue records are rotated, and the ancestors who sold the property is no more, and the respondent here is in the succeeding to the estate of the deceased, what they say before his court. Now, my lord, ye say before his formal court saying that, my lord, I am in possession of the property, I should not be dispersed. And the revenue records have been mutated, that has not been questioned by them.
Come to the IA that's filed in support
Yes,
of
my
the
lord, will ask me
application.
kindly.
Yes, where is it?
This application came to be filed before this court on order 7
Page
to
number?
11. My lord, first page, 2 minutes. Not for the reasons warranted in the accompanying affidavit, the defendants 1, 2, 3 place that the formal court may please to reject the plaint filed by the plaintiff in so and so in respect of this one. Now, my lord, will ask me kindly, there are several facts are there before the formal court. One is, my lord, cause of action.
I'll understand from the
True, ma'am.
affidavit. Please show from this affidavit, where are the grounds?
Grounds, my lord, will ask me kindly appreciate how I acquired the property has been stated before the court.
Why the plaint has to be rejected? Where is that
Yes, my lord.
stated in the affidavit?
That's why, my lord, before the formal court, that is one is cause of action.
I want to see it from the
Plaint.
affidavit.
Plaint itself is.
I want to see it from the affidavit. What are the grounds raised?
Affidavit.
Please come to that.
Yes.
Relevant paragraph.
Yes, my lord, para 6, my lord.
What did you
The
say in
suit-
para 6?
The suit came to be filed with, before the trial court by the petitioners and came to be decreed in my favor. That was not questioned even to this day, and the res judicata is applicable.
Yes.
Then, my lord, the cause of action. For the cause of action stated in the plaint averments, my lord, about about the filing of the suit, my lord, before 1 year, one month ago, that is there is no specific cause of action which is mentioned. Thirdly, my lord, they have admitted the fact that, my lord, the property has been sold in my favor. I am in possession of the property. All the revenue records are standing in our name. If at all, if I want to file a suit for declaration, then the things should have been different. A bare injunction is not maintainable.
Come to the order. Where
Please.
is order?
Order.
Yes. Page number?
My lord, starts at 16, my lord. The
Yes.
findings recorded by the court. There are 13 only the main, my lord. Page 24.
We'll read it from para number 10.
10, my lord. Yes, my lord. The defendant number 2 and 3 have filed this application in order 7 Rule 11 for seeking for rejection of the plan. As per the contentions of the defendants 2 and 3, the court, the social property was purchased by the grandfather of the defendant number 1 by name 1 Gangaya by registered sale deed dated so and so. As per the decree, the passed in voice number 205 of 2041 and execution petition 126 of 2013-14. Subsequently, the defendant number 1 has also purchased the property bearing number 43, bearing to an extent of 1 acre in Ranga from Ranga and others. In the registered sale deed dated 5/12 to 19.
Notice to the respondents. Petitions permitted take out hand summons and file a memo to that effect. If the memo is filed by 18th of August, this is the matter on 19th. Yes, next.
I sought for an interim order. Grateful.
18 Leela Krishna.
Appearing for petitioners, my lords. My lords, in this matter, the respondent is no more, my lords. We were required to bring in the LRs of the respondent.
Submitted that the respondent is
We
no
will
more.
seek instructions, ma'am.
Petitioner wants to take step. Huh? Huh. Take that. At request, list this matter in the month of September. Yes, 19?
Much obliged.
19. Bapat Sampath.
Yes.
My lord,
Online.
My lords, I beg to represent Mr. Sampath. This
Yes.
CRP is filed, my lords, challenging the orders of the court below dated 17/4/2025, dismissing the petition filed under Order 7, Rule 10 for return of the plate. The application was filed by the respondent, first respondent herein, for challenging the arbitral award passed by the second respondent on 15/2/2025. The court, without considering the matter pertains to arbitration, says that the petition filed by the first respondent challenging the award under Section 34 of the Arbitration Act does not reflect any commercial dispute. On that ground, the application is dismissed. Lord, this case is squarely covered by the Supreme Court judgment of 2022, wherein the Supreme Court said all matters, all arbitration matters, Lord, they will have to go before a commercial court. Before adverting to the other merits of the case, if I may draw the attention of your lordship to the judgment below 2022 area 2020.
No, first, let me understand on what ground the court
Yes.
has dismissed it. Where is the reasoning part?
The reasoning part, the Honorable Court will be pleased to peruse the order at page.
Para 36.
Yes. It starts from page 266, Annexure K.
Yes.
The reasoning, the Honorable Court will be pleased to peruse the 261, paragraph 4. No, I beg your pardon. It's not. The Honorable Court will be pleased to peruse 66.
We'll take up this matter on some other day.
No, I'm ready. 283, page 283. Paragraph 36, your lordship's quite right.
Yes.
On perusal of the entire petition amendment, it is very clear that the respondent number 1 has miserably failed to avert that the present petition does not disclose any cause of action, is undervalued, is written upon a paper insufficiently stamped, is barred by law, is not presented in duplicate, or that the petitioner failed to comply with the provisions of Rule 9, No materials have been placed on record to show that the present dispute falls within the ambit of Commercial Courts Act whatsoever. Then the Honorable Court will be pleased to peruse the last paragraph, page 286. Paragraph 39, last 5 lines. So, third line from page 286. So, looking from any angle, it is very clear that the above dispute is not commercial in order to come under the provisions of section 521C of Commercial Courts Act, or it is not international commercial arbitration, or in order to refer the matter to Honorable Court of Karnataka. So, whatever the contentions taken in the application is devoid of merits, accordingly the answer and so on. So, now, if I may pass for a moment here, this application that is filed, AP 552 of 2025 was filed challenging the award passed by the second respondent under section 34 of the Arbitration Act. Look, all the applications that arise out of arbitration are invariably have to be filed before commercial court. That is the law laid down by the Supreme Court. That apart, the pleadings, the trial court, the court below has miserably erred even to read the plaint avowments. They clearly say that this is a sale agreement, business transfer agreement for consideration. It is not for free, for consideration. Once there is an element of money transaction is involved, it cannot be any other transaction other than a commercial transaction. Once it is a commercial transaction, because of that, the matter was referred to arbitration. The land arbitrator had granted relief by way of about 7 crores total plus costs. That is being challenged before the court below. The entire transaction between the petition before your lordship and the respondent is commercial in nature. Any dispute, and when the notice was served by the respondent number 1 under section 34(5), saying that he intends to challenge the award, the first respondent was informed that that is the wrong court, that has to be filed before the commercial court. Having said that, would my lord be pleased to peruse for just a moment 2 paragraphs of the Supreme Court judgment rendered in 2022, AR 2022 SC 5239. That
I'll
will
hear
set
it on some other day. This is matter on Monday.
Monday, no?
Yes, next.
Would it be, may I request for updation?
Monday. Yes.
Number 20, Lakshmikant K, petitioner.
Madam, for the petition, madam, order 7 rule 11, madam, has came to be rejected, madam. Madam, in the affidavit, madam, may kindly see annexure C, madam, page 24. In affidavit, madam, page 25, madam.
Yes.
That I have narrated that, madam, suit in OS number 55/2003, madam, which was earlier, madam, was decided, and in the
According to you, there is no cause of action. Then,
please, the res judicata, madam, on the ground that, madam, earlier, madam, the suit OS number 55/2003 was filed by the other side, madam, for declaration as well as possession, madam.
was it filed before the court by the plaintiff?
Please.
By the plaintiff.
By the plaintiff.
That document
Please, madam.
is filed by the plaintiff, I'm asking.
Please,
Is
madam.
it part of the plain documents?
Please, please. For that, madam, I am producing the
Take
list
that.
of documents. And another connected matter, madam, your lordship has passed an interim order, which is also next.
What is the connected matter?
That 432, madam, which 2 suits were filed with the same properties, madam. And in one suit,
Let's see this.
please.
Hmm.
The plaint, madam,
Yes, where is the plaint?
plaint, madam, relevant portion of page 14, madam. Para 6, madam. The public so-and-so were obliged to file a representative on behalf of the pledge in OS number on the file of so-and-so, my lord. And para 2, my lord. Para,
No. In the affidavit, you have raised, what is first ground is cause of action. Second ground, plaintiff died. And what is the other ground?
the res judicata would applicable, my lord. They filed a suit for declaration possession. The declaratory relief was granted. Now, my lord, they filed a suit for possession of the property. The declaration was declared in OS number 55/2003, my lord. Without challenging that, my lord, again they filed their present suit.
Where is that order, earlier order passed by the court?
I produce along with me.
Where is it?
Page 2, my lord.
Page 2 of this.
Please.
The same order. But the suit
I may be
numbers will
permitted
change.
to take out the hand summons
Yes,
instead
same
of connect with that matter.
Yes. And connect the, tag this along with that matter. Yes, next.
Please.
Roll number 21.
For petitioner, my lord. My lord, petitioner is aggrieved by the order passed by the Honorable Execution Court on 8th of April 2026. My lord, this original suit was for eviction 4602 of 2014 without establishing the right to title to the property. The plaintiff didn't have any title as such. He has taken shelter under a fake and fraudulent will, which was a subject matter in another suit. Taking that.
Anyhow, this suit is declared, EP is filed.
Yes.
Please come to the order, impugn. What your question now?
Yes. My lord, I invite your kind attention to page number 27, paragraph 13. I'll read a short text only. As has been requested by the decree holders, the court, as per its order dated so and so, allowed IN number 1, which was filed under order so and so, issued process the delivery warrant. Now, a report is filed by the bailiff to the effect that the decree holder number 2 was very much present, and but he could not deliver possession of the suit property. Decree holder is supposed to deliver that is what the order says. This is one major flaw. Then I invite your attention, kind attention to paragraph 14, previous page, my lord, 26, para number 10. Whatever that.
No, the decree holders have filed an application for delivery of warrant.
Yes, my lord.
Court has ordered.
JDR
What is wrong with this?
JDR has to deliver the property, not the decree holder. The order says decree holder has come in the way of delivering the property.
The office is hereby directed to issue delivery warrant with an authority to the bailiff to break open the lock of the premises.
Yes, ma'am.
And with the assistance of police of the said jurisdiction.
No, decree holder is supposed to deliver. Actually, the JDR is supposed to deliver to the decree holder.
Who are you?
I am for JDR. No, but the order says
But ultimately, what is the order? It says
no.
You have to give the portion of the property.
My lord, on the face of it, the order is fraud. That is what my that is there is no application of mine. And secondly, one more thing. Para number 10. Here, whatever has been quoted about RFA and SLP at the Supreme Court, they do not pertain to this particular OSSH.
This decree is not, this execution is not based on RFA or some other thing. The execution is based on a judgment and decree pertaining to this.
I agree fully, but the execution court is telling this in this order that I have gone for appeal dismissed. I have gone to Supreme Court, is dismissed, it is not correct.
Then what did you do? You tell the court now.
No.
After the judgment and decree, what is the appeal filed by you?
My lord, the OS was decreed in the year 2014. Soon after that, the execution has been filed. My contention is that the edifice of this case is built on fake and forged one will.
I think that is beyond the scope of this application.
No, I invoked the provision of Section 44 of Indian Evidence Act, saying that orders taken based on the fake documents are null and void. I want an opportunity given to me to place the clinching documentary evidence before the execution court.
Where did you ask for that
It
opportunity?
is there. I've already, my written argument is there, my objection is there. And without touching the
A
subject,
decree of 2014, order passed in which year? And still you say that you want opportunity in the month of 20, in the year 2026.
no, when execution came here, I filed the objection to particular IA. In that, I've quoted that the earlier, the will is forged because the,
No, the executing court will decide all that.
no, that is what Honorable Supreme Court says, Your Honor. When there is a fraud, I can raise the issue at any time, before any court. I have a
Yes.
citation also to that effect.
Yes.
My only humble request is, Honorable Court, give me an opportunity, whatever conditions I've taken there, I will prove that. If I am unable to prove that, case will go against me, no problem. And also, now I have been evicted. The JDR number only 76-year-old man. He has been put on the road now. And the thing is now, they want to sell their property or rebuild that property. I want status quo to be maintained and let the matter be referred back to the court. I will place the clinching documents before the execution. That is my plea.
Any more submissions? Please come. Agreed with the orders passed in I number 3 in execution number 238 of 2025 dated 8th April 2026 by the 25th additional, 23rd additional CCH number 23. The petitioner JDR is before this court. The respondent herein holds a decree holder has filed an IA number 3 under order 21 rule 35(3) read with section 151 CPC to issue delivery warrant by breaking open the lock of the premises with the help of the jurisdictional police to deliver possession to him. The JDR has filed objections and contended that the affidavit is manifestly fraudulent and mischievous. The DHR has tried to mislead the court and made a false and fraudulent claim of his residential address. JDR numbers 1 to 3 have been residing in the address for decades. The property number furnished is also not correct. None of the decree holders have any legitimate locus standi against the JDRs. The claim of the decree holders is fraudulent and absolutely untenable. Since the said so-called registered will dated 21/2/1991 does not confer any legitimate right to the decree holders are successful in getting favorable decrees by indulging in manifest fraudulent pleadings, evidence or arguments. The amendments made in the affidavit are absolutely false and therefore requested the court to dismiss the application. That the trial court by order impugned has allowed the application. And while
I submitted written argument also. I submitted written argument also subsequently.
the defendant has submitted, the JDR has submitted the written document. It is the court observed that while filing the written statement in voice number 4608 of 2015, the defendant have taken all contentions which now taken by them by way of objections and submissions of the counsel. However, the court held that the plaintiffs therein are entitled for vacant portion of the scheduled property. The finding of the court have attained finality. Therefore, at this stage, JDRs are not entitled to urge the same grounds which they have urged at the earliest point of time while filing written statement. And accordingly, the court has allowed the application. Land counsel for the petitioner has submitted and reiterated the grounds which are already taken before the executing court, and it is submitted that a fraud is played and a decree is obtained, and the fraud can be questioned even before the executing court, and the executing court is competent to decide the same. It is a grievance that the executing court has failed to consider the objections, the written argument that are filed by the petitioner and had allowed the application. It is submitted that the JDR is a senior citizen, and if this order is executed, it would cause a lot of prejudice to him. It would cause a lot of hardship to him. Hence, it is submitted that in order the status quo may be maintained, there may be direction to maintain status quo, and the matter may be remanded, giving him an opportunity to file all the relevant documents. Next paragraph. Having heard the counsel for the petitioner, present material on record. It's an undisputed fact that the suit is filed. The respondent herein has filed a suit that was decreed, and the execution is filed in the year 2014. Admittedly, the judgment and decree is not questioned by the petitioner. The said judgment and decree has attained finality. According to the petitioner, there is a fraud, hence he can raise it in the execution. The said submission, this court is not able to appreciate for the reason the petitioner wants to agitate the very same issues which are agitated before the trial court in the written statement, which were considered, and the court has decreed the suit. If the petitioner is still aggrieved, he would have carried the matter in appeal. In these kind of circumstances, the Supreme Court has never laid down the law that an unsuccessful defendant an unsuccessful defendant can raise the very same grounds raised in the written statement in execution proceedings alleging fraud, and the court has to consider the same. In the considered opinion of the court, the petitioner has not made out any grounds to interfere with the, let me complete, has not made out any grounds to interfere with the order passed by the executing court, and this court finds no infirmity with the order passed by the court. The court has considered all the aspects and passed a reasoned order. Yes.
My lord, simple issue. Bill has been authored by one advocate and he himself becomes the witness, what is that, attesting witness also. Second witness name we cannot even read also. And the advocate by the time he has died and he was on the cloud. And the advocate himself has defended the case for some time. And this honorable court has terminated his advocacy in between on the application of the defendant. And all these factors are not coming in the beginning, my lord. Only one opportunity of only single opportunity. Under section 47 and order 6 rule 4, I will place clinch. And also, my lord, one more important thing is there. The title what they are seeking for through their mother is not the biological daughter of the property owner. And she was born to another husband earlier and she migrated here. All this has become part of that proceeding only. Still the court has overlooked that. Grave injustice in that. I need one opportunity of proving that. If I am not successful, the matter will go by law.
Yes, dismissed. Next.
My lord.
Number 22, Abhinav Anand case.
Yes.
Blood, application IN number 2 is rejected by the trial court for rejection of claim as per annexure A, my lord,
Come to
on
the
IN
order.
number 2,
Reasoning part.
filed by the second defendant in the pending suit. The suit is as per the plaintiff at annexure D, my lord, at page 24. So as per the plaintiff averments, the first plaintiff, first respondent, is the mother of the second respondent, and the second respondent, second plaintiff, is a minor boy, aged 3 years, 8 months, and he was admitted to the third respondent nursery school on 1/6/23, and he was undergoing the classes. And 6/11/23, there is an incident in which another boy child with sharp nails or pencil and has caused hurt to the forehead of the plaintiff number 2 and caused scratches on the nose, hurt to the eye and caused severe injury to the eyeball of plaintiff number 2. So this is the injury on account of the incident in the nursery school being run by the fifth respondent and the third respondent, the headmistress. And
On what ground you have filed this IA?
IA, because my lords, your unmindful is annexure J is an agreement between the second petitioner herein institution and also respondents 4 and 5, in which the fifth respondent is running the schools.
That agreement is between whom?
Between the petitioner,
That is
institution,
defendants.
respondents 4 and 5.
So how come that all that will be considered under order 7 to 11? That is not the case of the plaintiff.
That is not the case of the plaintiff's might,
Your
but
documents
our
can't be
liability
considered.
will not lie on us.
Huh?
And if any damages arising out of the trial of
No,
this,
if then in that case, you will lead evidence and tell the court that this is not your responsibility, somebody else has to do, but not at this stage. Please come. Agreed with the order passed in.
I may be given opportunity, liberty to file appropriate application for deleting this defendant from the suit. Under Order 1 Rule 10(2) CPC.
And all that I will not do. This is an application, only this to this I will consider. Agreed with the order passed in I number 2. In OS number 239 of 2024 dated 17th April 2026 by the Principal Senior Civil Judge CJM Tumkur. The petitioner is before, the petition defendant is before this court. The respondent herein has filed the suit seeking damages and refund of school fee. As per the plaintiff number one, due to the negligence of the teacher, her son was sustained injury to his eye. The plaintiff number two was admitted to the defendant number, it is a case that the plaintiff number two was admitted to the defendant number one school, and the defendant number two was having an office at Mumbai, was not concerned to the allegations made in the plaint. The Podar Education Network Private Limited is a company registered under Companies Act having an office at Mumbai. Hence, according to the defendants, the court has no territorial jurisdiction. And the defendant number two is not aware of the alleged incident which has happened in the premises. The court has dismissed the said application. The court has observed that even though defendant number two is residing at Mumbai, but cause of action arose in Tumkur. Hence, suit filed before the court, and the court is having jurisdiction. Land counsel, the petitioner submits that there is an agreement between defendant number
one
and
respondents 4 and 5.
they are defendants before.
They are not defendants. Now we are impleading them.
No, you have impleaded somebody who are not parties to the suit.
As per Annexure J, my lord, they are the parties who have entered into agreement to run the institution in Tumkur district and Karnataka state.
How come you can, how the registry has allowed you to make them as parties to the, show them as parties to this?
And we have given explanation as per Annexure J.
How come they can accept the
objection to
explanation?
that effect. We have offered explanation on the basis of Annexure J.
First of all, docket order 4 and 5 are not the parties to the suit, which have been impleaded by the petitioner herein. They shall be deleted from the array of parties. Land counsel for the petitioner submits that they had an agreement with one Siksha Associates and one Sri Pavan Kondapuram Srinivasa, and as per the same, they are unconnected with the things that have happened, and further they are at Mumbai and the court has no jurisdiction. The court has no jurisdiction. This court has perused the order passed by the court in the light of the submissions made by the petitioner. The suit is filed for damages. Whatever the petitioner is submitting before this court, and whatever the petition is submitting before the court is not the case of the plaintiff, nor any documents are filed by the plaintiffs. While considering application order 7 to 11, court can only look at the plaint governments and the documents, if any, filed along with the plaint. Admittedly, all the pleadings, all the grounds that are raised before this court now are contrary, it is a case of the defendant, and the court, while considering an application order 7 to 11, cannot go into all these aspects, and the court had rightly rejected the petition. This court finds no reasons to interfere. Yes.
Till number 23, we have Vishwanath for
A sales transaction of 1992, my lord, was sought to be challenged in the year 2023 after a lapse of 31 years, my lord. No allegation of fraud is made. Only allegation is that, my lord.
So according to you, it's barred by limitation.
Barred by limitation.
Come to the plaint.
That is page 20, my lord. Is the plaint, my lord, filed by the plaintiff who was aged about 46 years on the date of filing of the suit, my lord. Para 6.
For equitable partition and separate allotment of the plaintiffs 1/6 share each in the suit rental property.
And next
by
prayer
Wilson.
is, my lord, declare that registered sale deed dated 1/10/1992 by document number 2838 of 1992-93, pages so and so, in the office of Sri Lanka, Bangalore, executed by the father of the plaintiff and defendant number 1 and 2 in favor of
What did they
defendant.
say about this document?
My lord, it's a sale deed, my lord. It was executed by the father and 2 brothers, and wherein the delivery of possession was also recited. That's a suit document, my lord.
Please come. When counsel for the petitioner submits that a suit is filed in the year 2020 questioning the sale deed of 1992, wherein the 1992, it is submitted that the suit is barred by limitation. And as it is a public document that is in the deemed notice of the parties, and there is no explanation forthcoming why a suit is filed after these many years, and all these aspects were not considered by the court. Notice to the respondent, stay of all further proceedings, a hand summons, memo, 10th. Yes, next. In all the matters, same 10th. Yes, next.
Interim.
24, Naveen GS.
Yes.
But so suit is one for recovery of money based on a dishonor of a check for deceased person as against the LRs. Our only contention is if there is a loan, they can file a suit seeking for recovery of the loan, establishing that there was a loan, not on the basis of a dishonor of a check, which was presented after the death of the drawer, and they got an endorsement that insufficient funds. They come and file a.
When was the check issued?
The check was issued on 26/4/2023.
When was it presented?
It was presented on 4/5/2023. The drawer of the check had died on 30/4/2023.
No, the suit is for recovery of money.
Money based on dishonor of check, not for the loan amount that they alleged to have given to the.
Come to the plaint, let us see what it is.
Page 20, para 3, my lords.
Page
20.
Yes.
Para 3, my lords. He submitted that the deceased Dr. L. Prasanna Kumar had borrowed a loan of 8 lakh from the plaintiff on 26/2/23 in the presence of witness by name Puttaswamy of Kallahaddi Doddi and another for his legal necessity to meet household expenses, and agreed to repay with same within 2 months and for the payment of the said loan.
How does it make a difference? I'm not able to understand.
No, it's because there is no cause of action if they are basing their entire suit on a dishonor of a check. Because once
money has been taken and he has issued a check. Now, cause of action will arise when the repayment is not made.
There are two things, my lords. If they are taking the dishonor of check as the basis for the suit, then there will be presumption under section 118 and 139 of the NI Act, even for the civil suits.
What they said, plaintiff prays that may please to pass a judgment decree for recovery of a sum of rupees 8 lakhs.
Correct, my lords. That is the prayer. But what is the cause?
And along with interest.
They base their own, all the cause of action based on the dishonor of check. They not even say that the 8 lakh was paid and so on. So 8 lakh rupees in cash, that is what they say. This is not a single suit, my lords. There are 4 suits that has been filed after death of the person. If they are seeking, my lords, as against the loan that has been allegedly taken by the person who has deceased for 8 lakhs.
Because he has given because you have taken loan, you have given my check for that.
My lords, that is what, my lords. If the person who has been alive and they file a suit on the basis of dishonor of check, the person who is alive, who is the drawer of the check, could establish that whether the check was actually issued, whether he has signed or something. Once, my lords, the person dies, the instrument has no value. Then if they are, my lords.
Where did they say? Please read it and tell me. From the plaint, where did they say?
Kindly, my lords, kindly. If I can.
It is, you took the money, you gave the check. You wanted to repay the money. You have not repaid the money. They are seeking recovery of money.
That is the, my lords, that is the only difference I am making out, my lords. They can seek for recovery of money of 8 lakh rupees as a loan, which they allegedly say that my father and husband has taken.
What did they say here? That's what I'm asking.
They say that, my lords, for a loan of 8 lakh rupees, a check was issued. We present it on 4/5/2026. Since the check was dishonored, you pay us 8 lakhs of the check amount. They don't say the loan amount. My lords, because, my lords,
all this has to be decided under Order 7, Rule 11.
Yes, my lords, because, my lords,
come to the order of the court.
Kindly, my lords. My only submission with respect is, my lords, if it is checked, my lords, the presumption under section 118 and 139 would be With
But you
respect,
can argue on the merits of the matter when, during the course of trial.
Millards, page 33, para 10. May I read, Millards? That is where
That DL Prasanna Kumar died on 34 after expressing condolence, requested the defendants for settlement of the said check amount.
check amount,
And the
Millards. That is what I am saying, Millards.
Don't go with that.
It is not technicality, Millards. If they are saying there is a check, obviously, Millards, NI Act section 118 and 139, the presumption will be drawn against the defendants herein. Then, if the
all that on the merits of the matter.
Millards,
that
it's
can't
not
be,
merits,
that can't be
Millards.
decided now.
Millards, it is not at all merits, Millards, because once the instrument, Millards, may I refer to a judgment, Millards, by the Jammu and Kashmir High Court, where it says summary suit cannot be filed as against dishonor of check.
It is not dishonor of check. It is for recovery of money. In the chain of events, they are narrating it. You
Millards,
cannot take advantage
They don't
of
narrate it, Millards. They base their entire plaint on the dishonor of check.
They say for your personal necessities, you have taken the money. Thereafter, you have issued the check. The check has dishonored. Then they went to your house. They asked for the money. You people didn't give. They
Kindly,
filed the
Millards,
suit.
may make out one difference between the dishonor, the suit based on the dishonor of
They
check.
didn't say so, dishonor of check.
They did, Millards. May I refer to in the plaint, Millards?
I've seen already the plain.
No, Millards. Kindly, Millards, for a
Yes.
moment.
Happily, you enjoy the money of somebody and now you want all these
No,
technicalities.
Millards, how can it happen, Millards? 2 days before my death, I will give a check. 2 months before, I take money for 8 lakhs for household expenses.
You prove it.
Millards, that is what Millards since Millards in a civil suit, it is the plaintiff to prove that 8 lakh has been given to them, given
Why
to
are
me.
you bothered? He will prove.
Millards, he is basing entirely on the check, Millards, which has been dishonored, saying that since the check has been issued, the presumption is lying on me. That I have to prove. That is what, Millards, I am differentiating. If the suit is based on a dishonor of a check, the person should be alive so that he can defend it. Once the person dies, Millards, instrument has no value.
Can't this taken up in that during the course of the trial? All this.
Millards, that would be, Millards.
It can be. You can always take these grounds.
Millards,
Not at this stage.
Millards, if based on the check there cannot be no cause of action.
That you argue.
That is what I argued in 7 Rule 11 application, Millards.
Not here during the course of the trial.
Even before the trial court, Millards, I argued on the same aspect.
Trial has not commenced before the court.
It has commenced, Millards.
Yes, dismissed.
Kindly, grateful, Millards.
Yes, next.
Cell number 25. Sanjeevani, Kabuling, now Aditi.
My application floats under order 7 Rule 11 has been rejected solely on the ground that the application is filed at the stage of arguments. May I request Lordships to kindly see at page 25. The operative portion of the order, Lordships will get it at page 47, reasoning. Page 47 is there.
Where is the finding that it is
The
only on the
finding is,
ground?
Lords, at kindly see at page 48, paragraph 12.
Yes.
Then it starts from there. May I request Lordships to see page 52, para 15. Page 52, para 15. Plaintiff in para number 16 of our plaint mentioned the cause of action which is to be established by giving the opportunity of the plaintiff. Moreover, suit is of the year 2014. Now the case is set down for arguments. At this stage, D7 has filed.
One thing is, what is
This I just want to point out is not factually correct. Therefore, I have produced the order sheet. If not, at page 242, Lordships may kindly see. I do not know why the trial court records it. It could be a genuine error. Page 242. This is the latest order sheet as on 26/9/2025. Defendant number 16, that Lordships get it 242 on the right hand side. Reissue notice to defendant 16, 18, 19 through RPD. If PF paid, and so therefore we have not even crossed this stage. We are still in the stage where defendant 16, 18 and 19 are impleaded and the matter is. Therefore, my application to be rejected only on the ground.
The trial has not commenced.
Trial, no, because what happened was subsequently they have impleaded these defendants who are the subsequent purchasers. Trial evidence has been recorded, I must say. But
The
these
matter is posted for, the whole purpose of this order 7 to
Please.
11 is unnecessarily the defendant.
No,
should
no, I
not be
understand.
put to
No,
the-
no, in fact, no,
You've already crossed all that.
No, I would straight away would have conceded before your lordship, saying that let there be direction to the trial court to conclude the trial itself. But I am told, my lords, now they have asked for impleading of 3-4 new defendants, 3 of them in fact, and notice is issued to them. Now they will come and contest the matter, and it will be no end. The application is filed solely on the ground that earlier there was a suit for partition filed, which has been dismissed. Now, I must be given an opportunity for the trial court to examine as to whether this order 7, rule 11, disclosure of cause of action applies or not.
Where did they say in the plaint about the suit?
So she does not say so.
When she does not.
No,
say
she does
so-
not. No, I'll just point out. No,
Yes.
she suppresses that fact, which we bring to the notice of the trial court. No, but that theory that only plain averments must be seen has some exception.
No, the documents also can be seen.
Yes.
Now the court will not look at the defendant documents filed with
No,
the
but in
defendant.
this case, there is a judgment. Suit filed for partition dismissed.
No, the judgment has to be on record to
No,
understand. and see.
not that theory that only plain averments must be seen has an exception to the extent of judgments of courts are not courts are record. They are not defenses which are set up.
No, I think which law, which judgment says so?
No, the judgments are to the effect that you only have to see the plain averments, but not the Diven's case, which the Honorable Supreme Court says, a meaningful reading has to be seen of the plaint as to whether it discloses cause of action.
No,
Not
then
if the
what
plaintiff
happens
comes to
is,
the conclusion.
What the defendant says, if you start looking at
I'm
it,
sorry, paragraph 9 of the plaint. She does say about the suit.
and the document is filed before the court.
Yes,
Along
ma'am,
with the plaint.
she
Because
must
to demonstrate.
Yes,
What is the sum and
proper.
substance?
No, she
of
comes
the
up with an
judgment.
explanation that these properties were not included. But I have 2 submissions to be made. Kindly see paragraph 9, Lord. She says about this earlier suit. Paragraph 9, Lord, Lordships will get it at page 65. Paragraph 9. But there is one other aspect, Lord, which I must point out before your Lordships.
Yes.
There has been, apart from this, there is one thing very substantial. She admits in the place that there was an earlier registered partition deed in the year 2006 among the brothers, in which, my lord, this property, suit scheduled properties, fell to the share of the defendant number 7 brother, and she has been left out. Now, till this day, my lord, neither has she sought cancellation or declaration to the effect that the sale deed is not binding. The Honorable Supreme Court in that Ranganayakama's case and Prem Singh's case holds, if a instrument, if left not to be declared as null and void, is left unattended, then the limitation under Article 59 will apply. That is also a second. But I am kindly look at my situation. But in fact, I have sold this property to somebody else. The third party rights have accrued.
Unfortunately, from 24 to after 12 years, you realize this aspect.
No, but this these now not subsequently sale has taken. No, I would still not say this one. But in all fairness, if we could get the suit expedited, the trial expedited, I'll be more than happy because our property is stuck there. But the problem is not the implement of these defendants. They will come and one way or the other, we were requesting for the suit to be terminated.
There's 2 options. One is I'll dispose of this petition because it's old suit, 14.
Yes.
I'll ask the court to dispose it off expeditiously.
Please.
Number 1. If not, I'll issue notice. Because stay, I'm not someone.
No, I would not seek to stay because our endearment is to get the suit expedited. Lordships may issue notice,
Yes,
and if defendants 18, 19 are already our party, we may seek for expeditious disposal of the suit.
The notice to the respondents, petition permitted take out hand summons and file a memo to that effect. If the memo is filed on 12th of August, list on 13th August. Yes.
Then number 26. Anjanath HKV, petitioner. Pradeep Karada.
My lord, this is a matter wherein, my lord, there's pertains to a partnership, my lord, and there's an arbitration clause in the partnership deed, my lord, and that has not been considered by the court below, my lord. I have brought it to the notice of the court below in the first instance, that is, my lord, in my written statement, my lord. I'm the defendant therein, my lord.
Please come to the order.
My lord.
Order.
Order is at ink page 10, my lord. 10 is the order, my lord. The operative portion, my lord. Reasons is that from 7, my lord. My lord, at in page 17, my lord.
Suit is filed in the year 2020.
Yes, ma'am.
You file your written statement.
In my written statement, I have taken the contention, my lord.
The suit is not maintainable
Yes,
because there
ma'am,
is
I
an
have taken it.
arbitration clause.
Kindly go to, ink page 28 is my written statement, my lord.
What do you say?
Written statement is filed on 14/6/2022, after the lapse of 90 days.
You know, it is taken on record.
Application is filed on 12/8/2022.
No, in the written statement, he has taken a plea that there is an arbitration clause and the suit is not maintainable.
But if he has not filed the application under section 8 of arbitration act, either he has to file as per section 8 along with the written statement, not more than that.
Then when there is an arbitration clause, no, when there is an arbitration clause also, like, you can proceed with the suit.
He has also not completed the section 8 subclause 2 also. While filing an application under section 8, he has to
No, but how did you go to the court when there is an arbitration clause? How can you invoke the jurisdiction of the court? By filing a suit.
No, it means that section, whether section order 7 rule 7D is applicable. So here is that it can be converted into the arbitration suit, not disposing in dismissal. The court has got the ample power to do it. That evidence is over, partial evidence is done. When the matter is posted for further evidence of VW1, then they came with an application to.
The fact remains is at an earliest point of time, they had already taken a defense with regard to that, not that he is coming up with the first step.
But whether this section is applicable or not.
No, when there is an arbitration clause, why should the parties, when it bars the jurisdiction of the court?
But it is, by passing the order, court will has clearly observed. Let us see, in page number 18. It starts from in page number.
So,
17.
according to the court, because he has not filed at an appropriate stage, even after it came to the notice of the court that there is an arbitration clause, still the suit can continue. Is it the law?
But whether it is the ground for a dismissal of the claim.
But because you can't maintain a suit.
No, it can be converted.
Let that be done.
But original,
Yes.
Yes, ma'am.
Because the trial court has already passed the orders on A number 3. So to decrease to an extent of paying income tax of the firm and GST and property tax. Because of this,
I'll pass the order. Yes, I'll pass the order. Heard reserved. Yes, next. 27.
Still number 27. Veeraya
I begged of you for the petition. As my 711 application came to be rejected. Subject matter of the petition is the third suit, my lord. This honorable court already has passed the interim order, my lord, earlier. The first suit came to be withdrawn in.
Then why is it listed today?
My lord.
Interim order earlier granted is extended. No,
My lord, it is a small matter, my lord. It may be disposed because second suit already rejected by the trial court.
Mr. Counsel, there is.
Hardly I'll take 2 minutes, not more than 2 minutes. Please.
People are waiting for their interim order. You have an interim order and you have a urgency for disposal. Please, this matter in the month of September, interim order earlier granted is extended. Yes, next matter.
P.S. Babu Narayan.
I appear for petitioners, my lord.
Yes.
This matter has arisen out of a suit for specific performance. Impugned order is order 7 rule 11 CPC, my lord.
When you come physically to the court, then that day will we hear it. No time today. This is matter on 5th of August. Yes.
Serial number
Much obliged, madam.
29.
Humbly appear for the petitioner, my lords.
Yes.
My lords, this is the defendant number 1 CRP challenging an order whereby our application under Order 7 Rule 11 has been rejected. The plaintiff was a member of our trust, a trustee, and he has been removed. He has filed a suit for a declaration that his removal is illegal and null and void, and further that we do not have the power to remove him. We are a public charitable trust. Now, according to us, my lords, as per section 92 of the CPC, if a suit is filed against a public charitable trust, prior leave of the court is necessary. A catena of decisions of the Honorable Supreme Court has held that the plaint has to be examined as a whole to see whether the plaintiff is asserting a private right or a public right. If it turns out that he is asserting a public right against the public charitable trust, then he has to seek the leave of the court, without which the suit is not maintainable. Now, in the instant case, kindly see at page 452, my lords, the learned trial judge does not even look at the plaint. There is no consideration of the plaint at all. 3 judgments are extracted, and then at para 20, page 52 at the bottom, without looking at the plaint at all, the learned judge holds that your IA is liable to be rejected. There's no consideration of the plaint at all anywhere. And I will now take, my lords, to the plaint itself to show that a public right is involved. At para 20, my lords. Further, regarding other judgments relied by learned counsel for defendants so and so cited above, the fact regarding the plaintiff's private right with respect to trust or trust property was not subject matter in the judgments, and for that reason, the above ratio is not applicable to the case on hand, and for that reason, on meaningful reading of plaint averments in the light of ratio of Honorable Supreme Court, clearly goes to show that the plaint is not barred under section 92 CPC, and for that reason, plaint cannot be rejected under Order 7 Rule 11D of CPC, and accordingly, I have answered point number 1 in the negative. Meaningful reading of the plaint averments. Now, my lords, I will take my lords to the plaint averments. Please see my memo for additional documents, where I have produced the plaint, and please see from page 21 onwards.
Yes.
Para 44. These efforts have not fructified as the defendants continue to persist in their illegal actions, and by that means are attempting to hijack the trust and take it outside the control of the central trust, which is a reputed public charitable trust held in high esteem in the country and abroad. If I may just explain the context, my lords, the plaintiff is also the trustee of the Sri Satya Sai Baba Central Trust. Bhagwan Sri Satya Sai Baba, during his lifetime, was the sole trustee of 2 trusts, the Central Trust, of which the plaintiff is a trustee, and the Lok Seva Trust, of which the plaintiff was also a trustee. We represent the Lok Seva Trust. Both are public charitable trusts. Now, after Bhagwan was no longer in his earthly abode, dispute arose between the 2 trusts. And already there is a suit pending, OS 141 of 2015 in Chikbalapur Court, as to whether the Central Trust is entitled to nominate and appoint the trustees of the Lok Seva Trust. In the meanwhile, my lords, the plaintiff, who was a member of both the trusts, has been removed by us, by this Lok Seva Trust, and he has challenged that in this suit. Now, my humble submission, if his challenge was only with regard to his removal per se, it might have constituted a private right. But he challenges his removal, and he challenges the power to remove, and now see the averments, my lords. Every possible allegation is made, which make it clear that he is not just making a simple suit against his removal. Please see para 46. In addition to this, defendants 3, 6, and 7, and 8 have also been extending extraordinary facilities to defendant number 2 to reside on campus and administer and promote another trust, namely the Sri Satya Sai Saraswati Trust for collecting donations, which would have normally come to the D1 Trust from devotees and alumni, and de facto administer those trusts and institutions set up by them, even though he is not a trustee. The actions of the defendants in soliciting donations, which is completely against the teachings propounded by Bhagwan Sri Satya Sai Baba, by enticing hapless donors, of whom many are foreigners, by claiming that defendant number 2 and his protege 1D9 are able to communicate with the divine soul of Sri Satya Sai Baba and obtain replies and responses to the questions and doubts of devotees. Even though D3 to 8 are not willing to accept these claims made by D2, slowly they are being brainwashed into believing such fanciful claims on account of the advanced age of the D3 to 6, who are all octogenarians, and due to their fragile mental and physical health, they are being subtly coerced to follow the directions of D2, which are all against the interest of Sri Satya Sai Lok Seva Trust, unmindful of their obligation and duties as trustees of a public charitable trust. Then, my lords, in the same vein, other than 2 or 3 paragraphs in the plaint which relate to his removal, everything else is about allegations made against the current trustees amounting to a breach of their public trust and their duties. Please see again para 51, page 23. Under the active participation and support of D9 number 2, D9 is continuing to hold out that he is the chosen communicator of Bhagwan Sri Satya Sai Baba and pretends that he can communicate Baba's message.
Is the plain?
Totally plain, my lords. It is 60 paragraphs. 60 paragraphs making various allegations against the existing trustees. And a reading of it would leave no doubt that it is not a simple suit challenging his removal. If that were the case, I humbly ask myself, what do all these averments have to do with such a suit? It is clear that he is asserting a public right, even though he is ostensibly styled it as a suit challenging his removal. And indeed, even in the prayer, he seeks to challenge not only his removal, but our very authority to remove him, which is a different thing altogether. Now, my lords, kindly see at page 52, there is no consideration of the plaint at all. And we are suffering the trial. The very purpose of section 92 is to protect us, public charitable trusts, from vexatious suits. Now we are driven to face the trial. And no protection is given under section 92.
Yes. Page number?
Page 27.
Yes.
It is in phrase. Declare that the alleged resolution of the Board of Trustees of the first defendant trust passed to the Board of Trustees of the alleged meeting held on 21st, 22nd, and 23rd January 2017. The removing plaintiff as trustee of the first defendant trust is illegal, null and void, and non to issue consequently directives. Declare the alleged meeting of the Board of Trustees of so and so held on so and so is illegal, null and void. Consequently, restrain difference from acting upon the declare the difference 2 and 5 of the legal authority of law. The purpose is to remove the plaintiff from the office of trustee. Grant a decree of permanent injunction, all the different servants and agents, so and so. From acting upon, holding out, implementing, position, or communicating, the plaintiff has been removed from the office of trustee. Sustain difference 2, 5 to 10 their servants or removed from interfering the right of the plaintiff, discharge his duty as trustee of the first trust and cause. No directions in the of section 9 asking for a framing of a scheme or the administration of the stock. Now, the background of the plaintiff, John Portfolio has a look at the plaintiff. Page 3, para 2.
Yes.
So, I am presently a trustee of the Satya Sai Central Trust, founded by Bhagwan Sri Sai Baba, having its principal seat at Pradhan Nilayam, Puttaparthi. Central Trust was constituted by Bhagwan Sri Sai Baba. Then, Lord, insofar as this trust, that is defendant number 1 trust, Loka Seva Trust is concerned, Bhagwan Sri Sai Baba only was the trustee. During his lifetime, he carried out an amendment to the trust deed in 2008. He departed from this world in 2011. 2008, he carried out an amendment to the trust deed, and I have myself executed that amendment as his power of attorney holder, where he said, in this first defendant trust, where he was the only trustee, after his lifetime, the central trust, which he had also created, and not where all luminaries were there in the central trust, those people should have the power to appoint trustees after his lifetime in this defendant number 1 trust. That amendment he executed during his lifetime to this trustee. Then, not only me, some of the defendants also came to be made as trustees after his lifetime in 2011, pursuant to the central trust power. Then what they do is, in 2012, few of these trustees who are there in this local trust executed a deed of amendment in 2012, undoing the amendment done by Satya Sai Baba. So what are they tried to bring it back to the position it was before Satya Sai Baba amended it. At that time, it was only said that he will be the sole trustee. After his lifetime, the existing trustees is the legal appoint. Whereas Satya Sai Baba in 2008 specifically amended it to say, after his lifetime, it is the central trust which he had himself created. They will appoint the trustees to this. Now that was sought to be done by few of the trustees. So in that regard, a suit was filed by me on behalf of the central trust, as also as trustee of this for different one, because I am having two places, one as a trustee in the central trust as well as a trustee in the local trust.
Now I filed a suit along with other trustees of Central Trust. In that also a similar condition was taken. This is a suit under section hit by section 92. Matter was taken up to this High Court. This Honorable Court passed a judgment. Can I just pass on? To which the defendant number 1 is also a party. I may point out, my lords, that was a different cause of action, a different suit. Kindly have a look at page 5. This is the 2015 suit, the Honorable Court may kindly note, where I questioned this undoing of this amendment that is done by Pradhana himself. Then I had filed the relief. Kindly see para 3 of the judgment. The reliefs in that suit are set out. Declared at page 5, para 3. The suit in verse 141 of 2015 was filed for the following reliefs. Declared that the minutes of the board of trustees meeting so and so relating to amendment of trustee is illegal, null and void. Non-as an issue, a consequent direction says it not given effect or implemented. Declared the alleged meeting of the board of trustees allegedly held on so and so is illegal, null and void, non-as in law. The appointment of different 5 to 8 as trustees of Satyasava Locus Trust and that meeting is illegal, because what happened is after undoing the amendment, they appointed a few more persons as trustees. The existing few trustees appointed themselves further trustees. Therefore, I questioned their appointment of themselves, saying it's illegal, null and void, and from acting or holding or representing themselves as trustees. Declare that the deed amendment of so and so executed is null and void. Direct the defendant to deliver the deed of amendment so and so. Declare the defendants 5, 6, 7, and 8 are not violently appointed as trustees of Satyasava Locus Trust. Then kindly see the narration of the facts which I just now pointed out is there in para 4. I may just skip that. Kindly see in para 5 at page 9 is the reference to the amendment with Bhagwan Satyasava himself did in 2008. Then the reference to this amendment by few of the trustees is referred to in para 8. Now kindly have a look at the contentions. At page 17, regarding section 92, the question law is also framed, para 3. There are several judgments. I didn't want to rely on several Supreme Courts because in relation to the very same trust, our High Court has had an occasion to consider this issue. In a different suit. In a different suit filed by others against different parties. And a different cause of action. Then why have you filed 2 suits? I would ask myself.
Because the cause, insofar as that is one of amendment, where further trustees are appointed.
No.
You
can answer to the court's queries, not to your friends. Yes.
Yes, kindly turn to page 25. Para 25 onwards. This onward starts considering the judgments of the Supreme Court on the scope of section 92. Kindly have a look at para 27. In the case on hand, the plaintiffs have contended the meetings dated so and so were non-est, as they were not held in accordance with law. And sorry, para 27, page 28.
Yes.
And consequently, the amendment of the trustee is illegal, null and void, and to declare the defendants 5 and 6, 7, and 8 are not validly appointed trustees of Locus Trust, and consequently restricted from acting, holding out, or discharging any powers or duties of trust. Plaintiffs are not represented as the public, and they did not seek for any relief that contained in section 92A1, A to H of CPC. If the meetings dated so and so were not conducted in accordance with law, the plaintiffs are entitled to question it and get all the consequent actions annulled. The right of the plaintiff attempt to resurrect, where the individual rights of the trustees of plaintiff number 1, the nominate trustees of defendant number 1, there was no allegation of breach of trust or mismanagement or for failing of a scheme of management, etc. The contention of learned senior counsel with the defendant so and so in similar circumstances, the Honorable Supreme Court.
Yes, I've seen that. Yes.
Then kindly have a look at subsequently, they hold the question that section 92 does not arise at all.
Yes.
That these are all private actions of my right to be as trustee. I am not asking for payment of scheme. While I narrated the cause of action, I pointed out why these people are removing me. Why these people are removing me is because one of them is suddenly claiming now to have got messages from Satyasava from heaven directly to him, and he is trying to mistreat the devotees. I opposed all this. I said you are committing fraud. Therefore, without even calling for a meeting, without notifying me, and in the absence of a power in the trust deed, they have removed me. Then kindly have a look at page 36.
where the section 92 is directly considered.
Page 13, para 39.
Para 35 actually. And then thereafter at
39.
39 and 40.
Yes.
This was taken up to Supreme Court. SLP was rejected. They have themselves produced the copy of the order. It was rejected. They said, whatever you have got, you file it in the written statement if you want. Take. So the trial court also in this case, there are a series of judgments which say the same thing. If you are not educated, if you are educating your private right, your claim to be a trustee. In fact, one other judgment I will just point out, where a suit had been filed on removal of trustee and sought for injunction. This one court has again held that this is not a case where section 92 would apply. Kindly have a look at from para 13 at page 27, para 14. The very same judgments are considered of the Supreme Court. And then para 23, where they say you have to go into the allegation complaint itself. And the court says if it is a case where you are questioning actions which affect you as your right as trustee, then it is a suit maintainable under section 26.
Yes. My lord, there is no quarrel with the proposition that I'm sorry to interrupt, that a series of decisions I have held, the plaint has to be read in its sum and substance, not just the prayer, to see whether you are asserting a private right or a public right. Now, in the facts of this case, whether a public right is being asserted is the question.
Kindly have a look at the impugned order now, because a submission was made that the court has not had a look at the lien record. Kindly, the reason start at page 41. Then kindly have a look at page 44 at para 15. The plain government in substance is the defendant number one is a public charitable trust founded in the year 1978 and so on and so. Then they recite about all the amendments, etc., etc. Then about his removal.
Only one
Then
paragraph.
the court considers all the judgments, which says that if a right is being exercised on an individual basis, question of section 92 does not rise. Can you have a look at para 20?
Yes, I've seen.
Therefore, my humble submission is this is a case where a 2017 suit is sought to be dragged on one basis or the other. But in the other case also they had made the same attempt and suffered the same fate. Therefore, my humble submission is the case.
My lords, my humble submission, I'm just producing a series of decisions. In Vidyodaya's case, Honorable Supreme Court has held.
Take that.
Yes.
And please write the paragraph.
Yes, I've written the paragraph numbers also. Honorable Supreme Court has held. It is not just the prayer, but the plaint as a whole, which has to be looked into to determine whether a public or private right is involved. The other case that my learned senior friend is relying upon was a different suit where he had challenged the amendment made by the trustees to the trust deed. This is a different suit where his cause of action is his removal from the trust. These are two separate suits, two separate causes of action, and he has himself filed two suits acknowledging the same. And each suit has to be considered on its own facts. If one reads only the plaint in this case, nobody could say that it's about the removal of the plaintiff's impositor. It's about various other things, various other allegations as well. And my lords, for the past 9 years, they have been taking time. They have been fighting interlocutory applications. They have been seeking transfer and fighting the interlocutory matter. Even the trial has not commenced yet. And it is their own plaintiff's own fault. He's not interested in the suit. Therefore, kindly stay the suit is my humble suggestion.
Number 30.
I have reserved it.
Your Lordship have reserved. Very well, my lords. My judgments, I have included the paragraph numbers also.
For the petition, serious violation which has been referred to the trial court. In this
Cell number 30. Yes,
Challenging the same order, another writ petition has been filed by respondents.
That writ petition is filed after 1 year, my lord.
The next date is next week. Till your lordship's renders.
I'll pronounce it by next week.
Yes, sir. 24th is the date. 24th.
Well, generally, I will not stay the suits unless and until.
Yes, yes. No, we also prefer an order on that.
Yes.
R1. Serial number 30, please.
That has to be it has to be called along with that writ
My
petition.
lord, that
No,
writ
in
petition, my lord,
that writ petition is ordered to post along with this writ petition. But I don't know, it has not been
plaintiffs have
posted.
filed 2 writ petitions, my lord,
I am
challenging very
filing memo
same application, dismissing the application for amendment of the
application is
plaintiff.
dismissed, please.
My lord, by way of amendment, they want to change the nature of the suit.
No,
my
no,
lord.
it is not at all changing nature of the suit.
Please, my lord.
Please, both of you, if people let me ask a question, then we
Please,
can
please.
go further.
Please.
Have you filed 2 writ petitions on
Yes,
the
yes,
same?
madam. Plaintiff, there are many plaintiffs. Respondents,
Or doesn't matter.
two writ petitions are there.
That's what, one we dismiss, other will go.
No, kindly have both on the same day. In that writ petition, it is ordered to
What
post.
is this? Awaiting service of notice in respect of R5.
They are
They
placed
have
ex
moved
parte
away.
before the trial court, my lord.
They have to file a memo if that is the case.
I'll look into and I'll file. Kindly have day after
Last
tomorrow,
date of
please.
hearing, my lord, they
By
made a
that time, I'll
submission that
ascertain it and I'll.
Because you have an interim order in your favor, everything you can't.
No, no, not like
postpone
that.
it.
I don't want, not like that. Kindly have it day after tomorrow. If interim application may be heard on that day, even in the absence of fifth defendant respondent, thereafter I will take steps if it is necessary.
What about other respondents, or sir?
All are served.
In respect of R1.
R5.
the Notice
A
returned
memo,
as
this
unclaimed.
memo I've taken on file.
Amount to deem service of notice.
My lord, R1 we are representing, my lord.
You are representing
Please.
R1.
Please.
The discuss matter on 19th of August, along with, give the right to the.
Yeah, I give
My
no-
lord,
no file.
that another matter is ordered to be listed on 4th, my lord.
Fourth of? Oh, fourth,
Just along with that on 4th. Yes.
480.
Yes, yes.
Please.
31,
Look at it, interim order, only granted is granted. Yes, what about this maintainability?
Your Lordship, I appear for the petitioner. Your Lordship it is of the opinion that the civil revision petition is not maintainable. I respectfully request that I may be permitted to withdraw the petition and with liberty to file an appropriate writ petition, Your Lordship.
The officers raised an objection with regard to maintainability. Objection with regard to maintainability is upheld. Petition is liberty to file an appropriate application within a period of 2 weeks. Same please to return all the documents by keeping the
Much
copies.
obliged.
Yes.
cell number 32, P. Manjunatha.
The office has raised an objection stating that the CRP is not maintained. Actually, what has happened in the trial court?
What is this? What is the order impugned?
Limitation application was rejected. Consequently, appeal also dismissed. Therefore, the revision is lies. In
Section 5 application.
Section 5 application as rejected.
Against that you have come here.
Against, consequently, appeal also dismissed. Therefore, I have preferred a revision. Condonation of delay application was rejected by the appellate court in RA. Consequently, RA also dismissed. Therefore, the revision is lies. In view of the full bench judgment of this honorable court, revision is lies because the appellate court has not adjudicated the entire matter of the appeal. Therefore, revision is lies. Good.
When the appeal itself is dismissed.
Consequently dismissed. It was a decree was not passed. It was not passed on merits. If the appeal is dismissed on merits, then RSA will rise. Here, what has happened? Condonation of delay application was rejected.
This office objection with regard to maintainability is kept open. Notice to the respondents.
Cell number
Yes.
33,
Yes. Next.
Please.
Extension letter.
A. Madhusudan.
And it is addressed with the principal decision session judge Chikmagalur dated 29/6/2026, seeking 6 months time to dispose of the pending suit. A coordinate bench of this court has directed the court to dispose of the matter within 6 months from the date of the receipt of the report. Learned judge has stated various reasons why the same could not be disposed of, considering the same, and the 6 months time is granted for disposal of the matter, and it is made clear that no further time will be granted. Yes.
Cell number 34,
In this
M.
case, your lordship,
Maneshwarappa.
respondent number 1. Office objection, copy served your lordship, caveator.
Non-compliance of office objections for 5th time. What is it?
Copy served only for objection, copy
Look at it.
served.
Is this the one? Look at it. There are 4 office objections.
1 week time, your lordship
Week's
complaint.
time. Or else the writ petition shall stand dismissed. Yes,
Cell number
35.
35, Ravindra Reddy.
Yes, office objections shall be completed within a week. Default order 36.
Cell number 36.
Petition based, madam. The only subjecting is that defendant number 1, as per OS number 278 of the Proceedings, is not made party in this writ petition. Here, my lord, defendant number 1 is died, and LRs are record already on record. That's why.
But you have to show him the office objections to be complied with. Yes, 37.
Cell number 37.
List after service of notice.
Cell number 38. Cell number 38.
My lords, this is the issuance of the hand summons we have
Kumar,
filed.
awaiting service of memo of.
She's saying something. Yes.
My lords, there was an order passed for the issuance of the hand summons. We have issued the hand.
Can you use the mic? I'm not able to hear anything.
My lords, there was an order passed for the issuance of the hand summons. The hand summons is being issued and the same is being filed in the registry, my lord. I plead to before this court to extend of
Who is
the
there?
interim order.
How many are the respondents?
11 respondents are there.
All are served.
Yes. ma'am.
Advocate.
Yes.
A memo, it is submitted that as per the order passed by this court, the petitioner has taken out hand summons on the counsel appearing for the respondent. And a memo is filed in that regard. Peruse the memo. Considering the same, the notice to look at the memo. So and so is held sufficient. Yes.
My lords, interim order granted to be extended.
Interim order earlier granted is extended list in the month of October. Yes.
Number 39.
Respondent number 1 to 7, my lord.
Hand summons had been ordered, my lord, served, my lord.
The respondent 12:13, 14, and 19 to file the
12, 13.
and 14.
So and so submits that he has instructions to file wakalat on behalf of 12, 13 and 14.
I'm
What about-
press.
What about others?
Hand service has been served, my lord.
In respect of whom?
My lord, all the respondents, my lord. My friend is appearing for respondent number.
Your
1 to 7, my lord. I'm appearing for respondent number 1 to 7.
She is appearing for 11.
1 to 7, my lord.
You are for
12 to 14.
12 to 14.
you are for
12 to 15.
Who 8 to 11. I no wakalat is filed for 8 to 11.
No, my lord.
When counsel for the petitioner submits that as per the order passed by this court, he has taken out hand summons for the counsel appearing for the respondent. Respondent, and as far as respondents 1 to 7 and 12 to
12 to 14.
12 to 14 have filed advocates
Taking to file.
they are undertaking to file wakalat. Notice to in between whatever the number is held sufficient. Yes, let's
My lord,
start for preliminary hearing.
My lord,
On
I'm pressing for
tomorrow.
interim order, my lord.
Interim order granted.
Not granted.
Tomorrow. Yes,
Please.
40. Office objections to be complied.
Cell number 40.
Petition in this case.
What is counsel submission?
My submission is, my lord, some of the portion of the my lord, trial court judgment. It is not readable. Page number 20. I'm not relying, my lord. Page number 20, my lord, it's issues, my lord. It's online copy, downloaded copy, my lord. It did not read the Kannada version.
Page number?
20, my lord. My lord, I'm not relying upon this judgment.
It is not you relying on, but it should be, what order is this?
My lord, in a regular appeal, my lord, I filed, respondent filed an impleading application, my lord, to implead the.
No, but how can we allow this?
Please.
Order copy, when you're not relying, don't file it.
Sorry, no, to only bring the fact that suit already decreed, my lord. That's what I am. Sorry, my lord. I will transmit solely.
No, I can't understand Kannada. Somebody else can read it.
Please, I understand. My lord,
File a copy.
I will get a copy.
The petition shall file the
No,
copy.
madam,
of
on
the-
submission. Now it's in RA, my lord.
That's what I say. The petition shall file the copy of the legible copy of the order within 2 weeks. This is matter for preliminary hearing.
No, madam. 7th is the date, my lord. Fixed for arguments, my lord.
This matter for preliminary hearing on 3rd of August.
Please.
Cell number 41.
Yes, report received from 3rd additional judge. What she says is, this court, after the receipt of the orders of High Court, has passed orders on I number 2. This court has assigned the reasons in the order, but in the operative portion by rush of work, again issued emergent notice on I number 2.
My lords, it's been nearly 2 months since I filed that application, my lords.
So according to the learned judge, she has passed orders on the merits of the matter, then you have to avail the remedy available to you. Where is the order? Let's see.
Orders at page number
13 and 14.
13, my lords.
13 onwards.
Page number 13.
13,
That's on order on IA number 2.
please, ma'am.
It is at page 14.
It's the continuation, my lords.
13 is the order sheet.
The operative portion is starting
Issues
from
from
page
summons.
number 14.
So anyhow, what I do is, I'll ask her to, because you can't, against this, you can't file an appeal.
Yes, madam. Otherwise, I would have filed an MFA before.
Please come. The petition
may I
is,
make
you
one?
you
I'm
represent,
appearing for respondent number 2, my ladyship.
what about 1 and 2?
There are only two, my lords. Defendant number 1 is the party. He appears for the BBM.
I pay for the BBMP, ladyship.
Then now to set aside this order, notice is required
It's-
to the first respondent. He appeared before the
They
court?
haven't yet appeared, my lords.
No, summons were not served.
No, my lords. Only
Oh.
insofar as BBMP is concerned, they've appeared.
Issue suit summons to the defendant number 1. The petitioner plaintiff is before this court agreed with the order dated 10/7/2026 passed on I number 2. Invoice number 4118 of 2026 by the principal city civil and session judge. Earlier, the petitioner has filed a suit for
Injunction.
injunction in that, also filed an IA seeking an interim injunction. Earlier, when the suit summons were issued, a writ petition is filed before the court, and this court has disposed of the writ petition, directing the trial court to pass orders on the IA, notwithstanding the fact that the notices or not, summons are not served on the respondent. After that, the present order came to be passed, dated 10/7/2026, whereas in the operative portion of the order, it reflects that the court has issued suit summons, emergent notice on I number 2 to the defendant number 1, and written statement and objections of defendant number 2 by 7/8/2026. Then counsel for the petitioner submits that in spite of an order passed by the court, again the suit summons are issued. Then this court has has called for a report from the concerned judge why again suit summons are issued in spite of the earlier order set aside, and when this court has directed the learned judge to pass the order on the merits of the matter. A report is placed before the court wherein the learned judge states that, in fact, the order is passed on the merits of it. However, in the rush of work, when it comes to the operative portion, it is shown as issue suit summons. Learned counsel appearing for the petitioner submits that now against this order, they can't even file an appeal considering the submission of the learned counsel for the petitioner. The order impugned is set aside, and the learned judge shall only issue a fresh order copy for you.
My lords, until such time, if I may be protected, my lords, it will take another 2 weeks at least, my lords.
Set aside.
My lords, my difficulty is that
This order will be uploaded. I'll ask her to issue an order within 2 days.
my lords, this application has been pending for the last 2 months, my lords. I've already lost 2 months.
This practice should be deprecated.
My lords,
High Court granting injunction, interim injunction,
I've
then
made a
keeping it here
bona
for
fide
1 year, again sending it. And for next 20 years, suit only on interim injunction will be going on.
My lords,
No,
only
I'll
till
ask.
the next date of hearing, my lords. Till
I-
such time my application is heard and disposed
On what
of.
basis?
My lords, this application itself has been pending
What
for 2
basis?
months. my
Mere
lords.
pendency of application will not give you a right for
My lords, the
injunction.
construction is going on for almost
That's
2
why
months. My lords,
now
my suit
I'll-
itself would become
I'll ask the
infructuous.
learned judge to pass an order and upload the order within 2 days from the date of receipt of the copy of the order. You will get a copy of the order will be uploaded by Friday morning.
Once my suit
and
itself
the
would become
petition is disposed
infructuous
of
by then. my lords.
Directing. If you succeed, the writ petition is disposed of, directing the court to pass appropriate order within 2 days from the date of receipt of the copy of the order. This matter by Friday morning, it should be uploaded. What is that? So it's on the stakes, not necessary.
Cell number
But I may be given liberty to advance the matter also. my lords.
Petition is at liberty to advance the matter. Yes.
42
Depending on the
VC Sudeep.
petitioner, my lord. I sought for dispensation of the production of the execution petition, my lord. Here is a case, my lord, where
Then what about non-compliance of office objections?
that have complied, my lord. It was only that original jurisdiction, supervisory
Office
jurisdiction
objections to be complied with.
complied,
IN
my lord.
Office objections, if any, shall be complied with. IN number 1026 is for seeking dispensation of production of the, what is the order impugned?
My lord, issuance of arrest warrant, my lord, arrest warrant is issued. An application was filed for issuance of arrest warrant. Objections was filed. It was posted to here. My lord,
Without that copy, how can that copy be dispensed with?
no, IA for application is filed. The objections also is filed.
It is submitted that as of now, they do not have the copy of the execution petition. The same may be dispensed with for the present. The IN number 1026 is allowed by dispensing it with for the present. This is matter on
My lord, urgency arrest warrant is issued.
tomorrow for in the preliminary hearing. Yes, 43.
Obliged, my lord.
43 KS.
My lord, I'm challenging the order in regards of 2 applications filed.
What are they?
My lord,
What are those 2 applications?
2 applications for under Order 11, Rule 14. It is for production of documents which are in the custody of the.
Then what is the other one?
Both are the same. Both applications are regarding production of document.
Why 2 applications?
My lord,
Why 2 applications?
I didn't get it.
For production of documents, why you filed 2 applications, I am asking.
No, one is with regards to meeting, they are of different subjects. One is to show that whether the deed of declaration, which I'm seeking for a declaration, to declare it null and void, it is with regards to that. And there is another application in regards of meeting held. It is about
Office
meeting.
objection is sustained
My
petition.
lord, office objections have been complied. The office
Office objection with regard to maintainability. You filed 2 writ petitions. Yes. The
My lord, they are disposed of by same or one single order, common order.
Yes.
It is at Annexure A.
Now I want to allow only one IA. I want to allow only one IA. Then what will happen to the writ petition?
No, but
To petitioner shall stick this writ petition to one IA, and for the second IA, the second writ petition shall be filed.
all right, I'll only I'll be challenging only IA number 10.
Number 1.
10.
IA number 10.
10.
And he shall carry out necessary corrections. This matter on Friday.
Cell number 44 Balraj BR.
Petitioner, my lord.
What is the submission?
There are 3 applications are filed. Reopen, recall and production of documents notes. The common order passed on 24/7.
Yes, office objection is overruled.
My lord,
This is matter for preliminary hearing.
tomorrow is a matter for posture for judgment.
Tomorrow.
Judgment is
This is matter for preliminary hearing tomorrow.
the matter is already posted for judgment before the trial court tomorrow, my lord.
This orders matters, they were there in the second list. To complete this process,
Grateful,
I have
my lords.
taken it to the first list, not to hear the matters.
At least preliminary to top of the list, my lord, because
Tomorrow, top of the list.
grateful, my lords, great.
Cell number 45 Balraj BR.
Same, similar.
Yes, next.
Same.
Same.
Then number 46,
Not to the petition.
Madhav Balaji
It
Kashyap.
is two IAs, same common order. One is not order 16, order 18, rule 17. Other one is 151 application to reopen the stage. Essentially same application. That is not the maintainability question.
So next one. What is that? One is?
One is not order 18, rule 17 to recall my evidence. Or then the other one is section 151 to reopen the stage.
Yes, office objection with regard to the maintainability is overruled. Council's, yes.
Not tomorrow it is listed for final argument before the trial judge.
Why everybody is
No, Your Lordship
sleeping
will,
over the matter?
No, Your Lordship will see when I filed this. Interim order, the order challenge is 21/7. I've secured the certified
Tomorrow,
copy.
this is matter for preliminary
May I
hearing
request the
tomorrow.
top of the list, in this matter.
How many tower?
I'm
Only,
so
I think
sorry,
top
Lord.
is only one.
I understand, but the difficulty is that I will produce the latest order.
For the preliminary hearing next.
Then
May I
number
request top of the list at least.
hearing.
Top of the list, may I request. The only,
Already from morning, so many top.
the only reason I'm requesting
No,
the
there is
learned-
no place. First page will be complete.
I understand. My only request is that.
Preliminary hearing will come in the first page itself. Not today, all these matters, that is why the whole
I
time.
understand. I
Yesterday,
bow down.
from there,
I understand.
all matters have come on top
I
with
fully
all these caveats and all.
Please,
All
please.
the entire day.
I
with
understand.
that.
I will not.
Yes.
Then number 47,
Obliged.
Harish HV, preliminary hearing.
For petitioner, petitioner was defendant.
Call it up at 4:45. Yes.
Shall I, Bella?
Yes.
Petitioner was defendant before the trial court. Suit is one for a declaration that's an easementary right. The plaintiffs are claiming easementary right over the property of the defendant. Well, at the first instance, they filed 13 amendment application is allowed by the trial court. Well, after filing the plaintiff evidence, post-trial amendment. No, my lord, what has happened is after filing the suit for easementary right, an application under order 39 rule 112 came to be filed by the plaintiff that came to be rejected. And again, my lord, MEA is filed, miscellaneous appeal is filed, that is also rejected by the appellate court. Now, my lord, I am told that writ petition is pending before the court, my lord, but there is no stay. Now, my lord, certain observations are made in by the trial court while dismissing the application for injunction. My lord, that, my lord, they take it and an amendment application is filed, seeking almost, my lord, along with the suit, a plain sketch was also prepared and filed in the court. No, my lord, we took a plea that, my lord, that whatever the sketch filed is false, and that the road, whatever intended road,
What is the present suit?
my lord, present suit is
Present stage of the suit.
suit, my lord, plaintiff evidence only, my lord. Not it is not.
Not yet commenced.
Not yet commenced. Now, my lord, an amendment application is filed. My lord, your lordships would get it at annexure AF, my lord. Kindly look at the kind of amendment which is done. Almost, my lord, replacing the prayers, replacing the sketch, replacing the survey numbers, and almost everything in detail, my lord, they are trying to get out of the admissions what is done earlier. My lord.
There is a question of admission.
My lord, the plaint, my lord, once they say certain things in the plaint, I take a defense that that is false. And an amendment and application for injunction is disbelieved by the court.
Every amendment generally is made after the written statement is filed.
My
not
lord, true.
before that.
My lord, true. Again, my lord, what happened? Again, they take up a different contention in the amendment application.
You can take up your own contention.
My lord, that is true. Then, my lord,
Oh, it's a pre-trial amendment.
my lord, virtually, my lord, is even changing the sketch of the suit schedule property. And, my lord, kindly see the kind of amendment which is sought, my lord. Annexure F.
Come to the IA.
IA is at annexure F, lordships. IA is 7. Proposed amendment sought. Your lordships.
Page number?
My lord, 67, my lord. Lost but one document, lordships.
I'm just looking at the affidavit. Please read page number, para number 2 of the affidavit. At page number 66.
I stated that along with, Miller? I stated that along with IA 1 filed under 39 Rule 112 CPC seeking for not to interfere with my peaceful portion and enjoyment of suit shall pathway in any manner pending disposal of the suit. This honorable court has rejected my interim application. Taking advantage of the dismissal of IA filed by me, the defendants have stealthily tilled the ABCD pathway road onto deface the existing pathway, and also they planted areca saplings in the said pathway, and they pitched the stone slabs and put up the barbed wire fence across the road so and so illegally to cause an obstruction right by way of reach to my land bearing number 8/9, 8/5 so and so back to main road. And this is the only pathway to reach the land and back to government road, without which I could not reach the land to the agriculture work or enjoy the property. Thereby, the defendants have caused the permanent obstruction to reach my land. In that connection, I have lodged the complaint to the jurisdictional police is of no assistance.
So, according to them, there is further obstruction. There is further obstruction. That is what is that case?
No, my lord, not only that, my lord, if that is the case, only they should have asked for a prayer that remove the obstruction. My lord, now they want to change the entire sketch itself. And kindly look at the other prayers.
To change now.
Yes, my lord.
Sketch will change in the light of this amendment.
No. My lord, sketch would, the land would be there. If I till the land are obstructed, my lord, it is for them.
Some more obstructions you have created.
My lord,
that is what their case is.
My lord, sketch would not change. The land will not go anywhere else. What would respectfully I submit is this, lordships.
The sketch, where is the obstruction? What have you made the construction? There won't be any change in that.
My lord, that they don't do it. Kindly look at the sketch. That they can't depict.
The order, now I saw the affidavit, I understood the fact.
No, my lord, that is one of the ground. My lord, look at the proposed amendment, other paragraphs, my lord. Other paragraphs in detail, they want to change and easement, they want to claim the easement of necessity now. My lord, look at that also, the suit filed, and they want to prayer easement of necessity.
That's what I'm saying. What is the prejudice to you? Ultimately, whatever he is pleading, he has to prove.
My
You
lord,
will have an opportunity of filing your additional written statement.
suit is of the year.
He cannot file another suit now.
My lord, that is true. Suit is of the year 2017. Amendment application is allowed in the year 2023. That is filed. Well, and even any mandatory injunction, the limitation aspect also, lordship.
That is allowed in the year on 24 September 2025.
Oh, please, my lord. 25 also. Application filed is a date to be reckoned.
Notice to the respondents. Is 48.
Then number 48.
Of a petition of lords. Defendant numbers 2 writ petition, my lords, seeking writ of mandamus, seeking further direction, my lords.
That you are also talking to him. Yes.
Writ of mandamus, my lord, seeking further direction in continuation of the order passed in Annexure E, my lords. Writ of mandamus seeking early disposal was filed earlier, my lords, and a direction was passed, my
How
lords.
many times the court will pass directions?
In spite of such order, my lords, dates have been allotted once in 2 months, my lord. And that is where I am again before this honorable court seeking specific direction, my lords.
Earlier court, there was no specific direction.
Specific direction within one year,
Directions will be given.
but the dates have been allotted, my lords, once in 2 months.
No, we can't pass orders like this, consecutive orders, one after the other. Where is the order passed by the earlier court?
Annexure E, my lords, page 114.
Any extension of time is sought?
No, my lords. It is specific, my lords, within a period of 1 year from the date of receipt of the copy of the order. I produced the order, my lords, on 2/4/2024.
Your suit is of which year?
2014, my lords. Interim order is there, my lords.
Order was passed on 23rd February.
Please, my lords. I produced it before the trial court.
So that the court has not asked for extension of time. It must have asked.
No,
Which must not be in your notice.
no, my lords. It
Because,
must have been
when
reflected in the
when
order.
it is a direction matter, they'll ask for extension of time, like how you see every day. Maybe you're not aware.
As per my instructions, there is no extension of
Come.
time. So
The coordinate bench of this court by order dated 23rd February 2024 has directed the trial court to dispose of the matter within 1 year from the date of receipt of the copy of the order. Again, now another writ petition is filed seeking a speedy disposal. It is a case of the petitioner that in spite of an order passed by this court, the court is not proceeding with the matter and has failed to dispose of the matter within 1 year. The registrar judicial is directed to call for a report from the concerned court. This is a matter on 5th of August.
Cell number 49.
To the
49.
petitioner, my lord. My lord,
Yes.
senior is unwell. I haven't got any instructions. I seek for an
It's a
adjournment.
it's a matter on 6th of August. Yes,
Cell
50.
number 50. Samir Hassan.
Application, my lord, under order 14, my lord, seeking recasting of the issues, my lord. That is
There are the
rejected.
earlier issues.
My lord, at page 74, my lord.
You are the plaintiff or the defendant?
I am the plaintiff, my lord. My lord, we have taken this contention, my lord, that the date of
Let's
death
look
of one
at-
Hulgamma, my lord.
Let us look at the original issues.
Issues, my lord, page 74, my lord. My lord, kindly come to serial number 4, my lord. That is the issue that is in question, my lord. The plaintiffs prove that the registered gift deed dated 28/1/1971 executed by Hulgamma is created one as pleaded.
Now, what are the recasted?
No, we sought for recasting of issues by filing
Additional
application, my
issue
lord. That is
number
at page
5.
77, my lord.
Defendant number 3 to 4 in favor of defendant number 8.
My lord, regarding item number 6 of the plaint, my lord, the claim of the defendant number 6 and 7 is that there is a gift deed executed to them by one Hulgamma, my lord, on a particular date. We have, my lord, in our plaint taken a contention that the gift deed could not have been executed, my lord, because she had already died. We have placed a death certificate of Hulgamma, and they have placed one more death certificate on a different subsequent date, my lord. So those two contentions, my lord, both dispositions of fact, my lord, that should have been taken as one of the issue, my lord. The date of death of the one Hulgamma, my lord.
That's what I'm asking. Which issues to be recasted?
My lord, that is not recasted, fresh issue, my lord. Because
Where is that application?
application, my lord, 77, my lord.
70?
7. It starts from 78. 4 issues, my lord.
Why the burden should be cast upon them?
My lord, they also assert, my lord, the fact that the date of death of Hulgamma is not this, my lord. That is a different date, my lord. They also assert, my lord.
So you wanted 3 issues to be
No,
framed,
that
casting burden on the defendant in your suit.
Yes, my lord.
Come to the order.
All right, page 10, my lord. Not page 20, my lord. In this case, on perusal of the entire record,
Yes.
it shows that the plaintiffs have filed this suit in the year 2017, and after appearance of parties and after filing of written statement, this court has framed issues in the year 2019 itself, casting the burden on the plaintiffs to prove the gift deed dated 28/1/1971 executed by Hulgamma is created. But the plaintiffs still they kept quiet and now filed this application only at belated stage, that too after completion of plaintiff side evidence and also after completion of evidence of some of the defendants. And when the case is set down for cross of DW6, only to drag on the case to recast the issue number 4 and to frame the additional issues. But on perusal of the entire pleadings of both the parties, it is not necessary.
Court is right. Why should there be a burden on the defendant?
My lord, they also assert, my lord. We also assert, they also assert, my
They
lord.
also assert, but you assert. You are the one who has come to the court. You should prove it.
My lord, on the issue regarding the gift deed is framed, my lord. The issue regarding the date of death is not proved, my lord.
It is the duty of the plaintiff to prove the gift deed dated 28/1/1971 executed in favor of the defendant
Yeah.
number. Because you are the one that is saying that it is a created one.
Yes, my lord.
And because they are saying that it is executed, that they should prove it.
Yes, my, no, not on that, my lord. My lord, in fact, my application itself is not clear, my lord. My application, my lord, seeking recasting of issues. But at any time, my lord, before framing of the decree also, my lord, court, my lord, if it,
Forget about it.
Yes,
About
my lord.
when is
Yes,
the,
ma'am.
what stage you have filed the application. Now come to the second submission. How those issues can be framed, casting burden on the defendant when you assert that the gift deed executed in favor of defendant is not a valid one or it is a created one. And now you want issues to be framed, casting burden on the defendant. Please come.
Not only on that, my lord, even on the, my lord, date of death also, my lord, issues have to be framed. In our application, my lord, that
Now,
was,
first delay is you kept quiet, entire evidence is over. No, only D6 cross is left. At that time you file.
my lord.
And what you seek the court? Seek
my-
the court casting burden on the defendant to prove all these aspects.
On the
Why will
point-
the court allow?
My lord, on the point of delay, my lord, casting of issues is, my lord, is the duty of the court, my lord.
That's why I'm saying, that's why I'm not dismissing on that.
Yes.
The other reasons what court has stated are correct. Court can't frame the issues in this manner in your suit. The agreed with the orders passed in. I number 30, invoice number 12 of 17, dated 3rd January 2026 by the senior civil judge and JMFC at Shikaripura. The petitioner plaintiff is before this court. Plaintiff has filed a suit for partition,
Partitioning,
filed a suit for partition.
and also for declaration of,
And for declaration. In the suit, when the matter is coming up for the evidence of defendant number, cross of defendant number 6, at that point of time, the petitioner has filed an application for application under order 14 rule 1(4) at this section 151 CPC for recasting of the issues. By way of this application, the petitioner wants the court to recast the issues whereby, page number? That the
petitioner,
issues.
plaintiff number 3. Petitioner is the plaintiff
three.
number 3, my lord.
Where are the issues?
Issues, my lord, at page 74, my lord.
No, that which issues you want it to be recast?
That is on 78, my lord, page
So
78.
he wants, the court has to recast the issues at page 78, all 4 issues. You please extract at page 78. The trial court by order impugned has dismissed the application, and while dismissing the application, the court has given 2 reasons. One is that this application is filed at a belated stage only to drag on the proceedings. And further, the court has held that it is not necessary to, the court on perusal of the entire pleadings of both the parties, it is not necessary to cast the burden on the defendant number 6 and 7, because in this case, the plaintiff has taken a contention regarding creation of the gift deed dated 28/1/1971 executed in favor of defendant number 6 and 7. Hence, it's the duty of the plaintiff to prove the same. Further, in this case, the plaintiff counsel produced decisions regarding point of law and recasting the issues and regarding the burden of proving documents. But in this case, it's the duty of the plaintiff to prove the gift deed dated 28/1/1971 executed in favor of defendant number 6 and 7 is created one. Hence, the judgments are not applicable to the facts of the case and accordingly rejected the application. Next, and counsel appearing for the petitioner submits that it's a duty of the court to recast the issues, and delay cannot be a ground to dismiss the application. It is submitted that when defendants are asserting their right with regard to the said gift deed, the court ought to have recasted the issues by casting the burden on the defendant to prove the same. But all these aspects were not considered by the court. Next, having heard the counsel for the petition, there's a material on record. The petition has filed a suit for partition and declaration. And according to the plaintiff, the gift deed dated 28/1/1971 is a created one, which is executed in favor of defendant number 6 and 7. Hence, at the time of cross-examination of D6, the petitioner filed the incident application seeking recasting of the issue where an issue has to be framed, casting burden on the defendants that came to be dismissed by the court on two grounds. One is with regard to the delay and other with regard to that the burden cannot be placed on the defendant. This court, in the considered opinion of the court, the trial court has rightly considered these aspects and rightly held that the burden cannot be cast upon the defendant when it is a specific case of the plaintiff. The gift deed dated 28/7 is a created one. In that view of the matter, this court do not find any reasons to interfere. Dismiss. Yes, next.
Letter number 230, say number 1. M. Patwari, petitioner.
Hello, this was a suit for eviction. OS IFA was filed. Last week, the IFA order was dismissed. Execution was filed for more delivery warrant. I had sought for time because I'm preferring appeal to the Supreme Court. Serious questions of law were involved. The execution court has dismissed, saying that there's no high court stay on this particular thing.
Correct.
It was passed only last week.
No, you will ask the time to go to Supreme Court in the RFA, or you will go to the executing court and ask.
I did not know I should have sought it in the IFA. So I filed an application under 151. Just annexed C and annexed D. I'll just show my lordships the serious questions which are in dispute. Property.
What are the questions? Should we stay? Is the question.
I leave. My lords, a very short accommodation is what I seek for, because if the delivery warrant is executed.
No, we will not do it. What you can't have it directly, you can't have it indirectly also.
Absolutely.
The present petition is filed. The petition is filed. Agreed with the order dated 22/7.
My lords, just for a second, if order 21 rule 26 is seen, there's a discretion which the execution court also has. A discretion to allow, in that appealable period, a small window can be given to me to prefer an appeal. If I don't.
The RFA dismissed.
IFA 22/7 last week itself. Last week. I've not slept over the matter at all.
When your appeal time ends. Appeal time.
Well, it's 30 days, at least August 22. Even if I take 30 days, August 22, 26. I have 90 days, my lords, for the Supreme Court, extendable. But I'm saying only 30 days till 22nd of August.
When counsel for the petitioner submits that the RFA was dismissed on 22/7/2026 and they are preferring an appeal before the Honorable Apex Court, even before the appeal time is expired. The execution is initiated and now they are going to execute the order considering the same. There shall be stay of all further proceedings. Stay of all further proceedings in the execution number so and so. Till the next date of hearing, list this matter on 12th, same hand summons memo.
Much obliged.
Shall be filed, memo shall be filed by 11th of August or else a stay granted by this court stands vacated.
Much obliged.
Cell number 2, Arun KS.
In this case, I represent the petitioner, madam. Petitioner has suffered an order, my lord, suit for ejectment. And he preferred an appeal. Appeal also came to be dismissed. He preferred SLP, my lord, before the Honorable Supreme Court, my lord. Honorable Supreme Court, my lord, has granted time till 31st August.
That order.
My lord, annexure D, my lord, page 110, if I may. Supreme Court order, my lord.
Shall file an undertaking on.
Please, my lord.
We find no error not to.
On 31/8 till on or before 31/8 date is given, my lord.
It is to extend the time to vacate the premises. We grant time to the petitioner to vacate the premises up to 31/8/2026. The petitioner shall file an undertaking on oath before this court within a period of 1 week from today that he shall hand over vacant portion. You file the.
That has been filed, my lord. Now.
Come to the order.
Now, my lord, the impugned order, in the execution petition, the decree holder, my lord, sought for arrest of the judgment debtor, that is the petitioner herein. My lord, by the impugned order, the court has issued the arrest warrant, my lord, without considering that aspect. If I may
if I may read that order, my lord, page 116, annexure G, my lord. My lord, dated 23/7. Counsel for DHR is present. Counsel for JDR praised time to file objection to IA number 4, but no reason since objection taken has not filed. Heard advocate for DHR on IA number 4 filed under section 151 of CPC seeking arrest warrant against the JDR towards recovery of cost. Next page, my lord. Bailiff has reported that JDR has no movables.
I think there are two issues. One is with regard to vacating the premises.
Please, my lord.
For that, Supreme Court has granted you time. The other is with regard to the recovery of amount.
Please, my lord. In that also,
Those two are independent.
two are independent, my lord. I am not claiming that both are the
No,
same.
morning when he made a mention, the mention what he made is, in spite of an order passed by the court, they are now.
No, my lord. What has transpired here, I am before this honorable court only on the ground of equity, my lord. But now, till the date of vacating, my lord, in fact, even in our objections, we had said that till that period, no precipitative action should be taken. We will deposit the amount before the executing court as well as we will deliver the vacant possession also as per the undertaking given before the Supreme Court. Now, my lord, without issuing the notice, my lord, against that, my lord, the order 21 rule 37, my lord, if I may read out before this honorable court, my lord. Discretionary power to permit JDR to show cause against detention in prison. My lord, may I read the first thing. Notwithstanding anything in these rules, where an application is for the execution of a decree for the payment of money by the arrest and detention in the civil prison of a judgment debtor who is liable to be arrested in pursuance of the application, the court shall, instead of issuing a warrant for his arrest, issue a notice.
Submits in the eviction suit, which is carried up to Supreme Court. The Supreme Court has dismissed SLP, however, granted time to vacate the premises till 31st of August 2026. In the meantime, for recovery of costs, the decree holder has initiated the proceedings and he has sought for arrest of the judgment debtor without any reasons and without even recording the reasons why, without issuing a notice and without even recording the reasons why the judgment debtor has to be arrested. The court has passed has issued the arrest warrant. Considering the submission of the land council, there shall be stay of all further proceedings pursuant to the order dated 23/7/2026. Notice to the respondents, hand summons, memo shall be filed.
Please, ma'am.
By 11th of August, or else the stay granted with this court stands vacant.
May I seek for hand delivery of the order?
Yes.
Please.
My lord's kind permission, my lord. Serial number 63, my lord. The matter is very urgent, my lord, because the tomorrow action has been held, starts from 10 a.m. to 12 a.m., my lord. It is the excise matter, my lord, and even that is only 2 minutes I will take it, my lord. 63, that is the very, very urgent matter, my lord. And it is not listed for.
Similar matter.
Why it has become, my lord? This honorable court has passed an order. This license shall not be used by any person, my lord, till the pending disposal of the suits between the partners, my lord. The suit has been compromised. When we have gone for renewal of the same, they have listed this license for auction tomorrow, my lord. That is the only contention, my lord.
Similar matter I have heard, and I am not convinced I have reserved it.
But this is the order of this honorable court is clearly stated. I mean,
Now you have to question the amended rules. As per the amended rule, that is in the pool.
That's why notification has been challenged with in so far as the my concern notice, my lord. In fact, my lord.
In respect of the similar provisions, division bench has upheld and that has gone to the Supreme Court. Supreme Court has also dismissed.
In my case, my lord, it is totally is a different footing, my lord. This is not comes one submission.
Just listen to the court. Now I understand. Now the thing is, according to you, your license shouldn't have been part of the auction process.
Yes, ma'am.
And they have, according to them, they have made the amendment to the rules.
Yes, ma'am.
As far as these amendments to the rules are already questioned before the division bench, before the learned single judge has granted interim order, that is carried to the division bench. Division bench has set aside the order, that is carried to the Supreme Court by the parties, that is dismissed.
But that is why the amendment what has been sought, that amendment shall not be applicable to my case, my lord. Here in this case, my lord, there is a dispute between the partners, my lord, two partners, and they have gone to up to the civil courts and all the courts for renewal of the license, my lord. It was renewed by the one of the partner, my lord. Later, it was challenged by the another partner. That matter has come to this honorable court, my lord. This honorable court says that there is a matter pending between the partners. Therefore, this license shall not be used by any person and should be kept in abeyance till the pending disposal of the suit, my lord. That is the order, my lord. That is the order of this honorable court. When it is not used by any party, this is the order of this honorable court prior to the amendment that was made out in the year 2022, my lord. Later, the suit was compromised between the parties. But by overlooking that particular order, they have listed this license for the auction, my lord, when it is covered by the judgment, my lord.
I'll hear it tomorrow. Tomorrow also I can stop.
I'll let them direct them not to auction till.
No. If they auction it, we'll set aside it tomorrow.
Again,
If I hear it, nothing will happen.
I request for top of the list, my lord.
May I please, Lordship? May I make only one submission?
Lords, serial number 70, Lords, the clinic is running, but owner has disconnected the power connection. Lords, there is urgency.
That matter will come tomorrow.
Lords,
Now I can't take up. I can't.
at the top of the list, Lords, at the top of the list, Lords, serial number 70.
Please understand, every day let us not do a different procedure. I instructed the court officer where whatever you tell me, you tell her that she will accordingly do it.
Court officer, madam. Court officer, madam. Is in 17. I think I tell you. Court officer, madam. Repeat ಮಾಡ್ತಾರೆ ಹೇಳಿ.
ರೆಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಈಗ
ನೀವು ಇದ್ದಿರಲ್ಲ ಸರ್ ರೆಸ್ಟಾರ್ಟ್
Court officer, what about the rest of the list?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಯಾರು ಇವ್ರಿಗೆ ಏನ್ ಬೇಕಂತೆ ಸರ್ ಇವ್ರಿಗೆ ಏನ್ ಬೇಕು ಫಸ್ಟ್ VC ಇರೋ ಅಂತ ಕಳಿಸ್ಬಿಡೋಣ ಅಲೋ ಸರ್ ಏನ್ ಬೇಕಿತ್ತು ಸರ್
Madam, rest of the matters.
Rest of the matters dates will be distributed, so it will be uploaded by 6:30. You see the status of the case, ma'am. But
Madam, item 59, madam. Okay. Item 59, madam.
ಅದೇ ಸರ್ ಅದೆಲ್ಲ ಡೇಟ್ಸ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಆಗುತ್ತೆ ಅದೆಷ್ಟು ಯಾವ ಡೇಟ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಆಗುತ್ತೆ ಅಂತ ಅದನ್ನ ನೋಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ
ಅಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ನಾಳೆಗೆ ಅಥವಾ ನಾಡಿದ್ದಕ್ಕೆ ಇಟ್ಕೊಂಡ್ರೆ
ಯಾವ್ದು ಹೇಳಿ ಸೀರಿಯಲ್ ನಂಬರ್
59 59
59
ಹಾ ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು
ನಿಮ್ಗೆ ನಾಳೆ ಬೇಕಾ ಅದು
ನಾಳೆ ಬೇಕು ಮೇಡಮ್ ಪ್ಲೀಸ್
ಮೇಡಮ್ ಐಟಮ್ ನಂಬರ್ 76 ಮೇಡಮ್ ಅದು ಅರ್ಜೆನ್ಸಿ ಇದೆ ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ 76 ಮೇಡಮ್
ಆಯ್ತಾಯ್ತು
ಓಕೆ
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 36 ನಾಳೆಗೆ ಆಗ್ಬೋದಾ ಅರ್ಜೆನ್ಸಿ ಇದೆ ನಾಳಿದ್ದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಾ ಇದೆ ಮ್ಯಾಟ್ರು
ಎಲ್ಲ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ ಸರ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಬೋರ್ಡ್ 11 no let it be there in the list ಅಂತ ಹೇಳಿದಾರೆ I will retain it ಒಂದ್ ನಿಮಿಷ ಹೇಳಿ ಸರ್. ಲಿಸ್ಟ್ 1 ಹೇಳ್ಬಿಡಿ ಸರ್ ಫಸ್ಟ್.
ಎಲ್ಲಿಂದ ಬಿಟ್ಟಿದ್ದು ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದು.
ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಮೇಡಮ್, ಲಿಸ್ಟ್ ನಂಬರ್ 1.
Court officer, madam. List number 2, serial number 30. Court officer, madam. Madam, list number 2, serial number 30. Madam, you're not audible. Court officer, madam. Madam, list 2, serial number 30.